All right. In a minute. Good morning again, everyone. We have a couple characters this morning. A plea and arraignment and a probation revocation. And then this afternoon, we've got final plea. Hope everyone's been well. It's been a little while since we had criminal in here. Last week was pretty quiet in this space, not necessarily elsewhere in Fulton County. So we'll start with plea and arraignment. Position one is Tony Cody. I'm confused. This isn't arraignment. This is Mr. Cody and yeah. Okay. I'm remembering who he is. This is one where Mr. Jerome was hoping that maybe the unindicted case could get pulled in with it, and he said, "Forget it. Let's just do the revocation." Okay. Do we know anything about what order would that be? Well, I don't think we had agreed on what was happening with did we have the full-blown revocation hearing?
I think that we were gonna wait to see if the PI cases could be accused. They could not, so
Right.
he was gonna go forward with just the revocation part and handle the PI cases later.
Right, but that's my recollection, but I don't recall that we had like a full-blown state advocates for this and here's why. And I think he just said, hey, what about house arrest?
I actually did, did. You just asked me to hold off on the order pending if the new cases would be able to be indicted by a deadline, and that deadline had arrived and
Passed, and Mr. Jerome sent an email saying, let's just go forward. So going forward would be then I decide what to do. It's not more argument.
Yes, you stated that you would just enter the order for the revocation if the PI cases were not to be resolved with the revocation.
They were not. So what was your position on the revocation?
We were asking for the defendant to revoke the balance.
You were aligned. And what was the balance?
At the time, it was 7 months and 8 days, but I don't know how long.
Okay. And Mr. Jerome said, fine, revoke the balance, but make it house arrest. So it really was just, where do you spend the balance of the revocation?
Yes.
Okay. All right. I will send you an email today. Thank you. Hope you had a nice Memorial Day holiday. All right. Aaron Spencer. Maybe
He is not.
custody?
Yes, he's custody. We did not have him.
Oh, you asked that he not be brought over. Okay, and he was not brought over. See, we did what you asked. And you've done a waiver.
Yes.
All right.
Just a heads up, he has another case in Judge Cox's courtroom that we might want to bring over, but it's on the trial calendar there. So I don't
So
know.
we're because I'm guessing the 22 SC is the oldest case. I think they just haven't bumped into that one yet.
But why you look at me?
It's just saying like, we'll manage that. You don't worry about that kind of stuff. You worry about what's in your inbox. Yeah. You've done a waiver in both positions 2 and 3.
Yes.
Okay. We'll get a scheduling order out. Okay. Position 4. Mr. Battle?
We would like to do a bond hearing for him.
He's here. He's here. Great. He's here. He's up. Have you done a waiver or will we also? Okay. Ms. Wow. So we're not just resolving it. We're doing a bond hearing. Okay. Are you able to do the bond hearing today?
Yes.
Not as in like capable, but I don't know if you had notice and if you need to reach a victim.
That's correct. It's my understanding that we're doing a bond hearing for position 4 and 6.
Oh, look, he's got 3 positions. Huh. Okay. Now I see maybe why it's not on. Okay. So we're doing a bond hearing on Mr. Battle. He maybe has a bond for one of his cases, but not the others. Okay. Have you done a waiver in all 3 cases, Ms. Rios? Okay. Well, we'll get them out in a little bit. Let's just get through the calendar. Huh, all consecutive indictment numbers. And Mr. Battle has probation revocation matters?
Yes.
Okay, and you're thinking it's bond, huh?
I do with my client.
Okay. You have done a waiver. That's great. So we'll chat with him in a little bit. Christian Rogers.
He's my judge. Good morning.
Good morning.
I'm gonna try to work this one out today.
All right. We'll sit tight on that. Would. You're gone next week.
I am, yes.
Are you going somewhere fun?
Yes,
Where's fun?
Florida.
Florida. Florida is fun. When do you leave?
Monday evening.
Just scheduled well. I mean, you get back like not till the following week? Yeah, okay. All right. Well, safe travels. Darius Fields.
I did file a waiver and I would like to have a bond hearing on his case.
That work for you?
It does.
Okay. Yeah, so bond. Jerron Johnson,
John Melnick. Yes. Yeah, it's the whole for his report.
Mr. Melnick.
Yes.
All right. Will that be your case, Ms. Smith? Or is that why Mr. Peoples is here?
Yes.
Okay. And would it be Ms. Williams's case, but she's still out?
That's
Is
correct.
she doing okay? I don't know how much contact you have with her. Okay. All right. DeAnthony Owens.
Not in jail, Your Honor.
Okay. That's a 9.
Yes, I've not had contact with Mr. Owens. We may want to double check to see, was he transferred to a different jurisdiction?
It's like, I'm looking to see as well.
Well, his last booking here was, he was released on March 1 of 2025. He's just out. All right, so bench warrant, he should be findable. If his officer just saw him, maybe Ms. Rios, you can work with Ms. Simpson to see if you can get some contact info and we can hold off on that, but I think that's the default right now. Tasman Lewis.
In custody.
He's mine, judge. I don't think this one's gonna resolve today, but I do want to speak to Ms. Smith and see what we can do.
Okay, well, we'll bring him out at the appropriate time. Melinda Parlor.
I filed a waiver and this should be a bond hearing. I see a talk to her before the bond hearing.
All right. Lots of bond hearings for you today. Mr. Peoples, good morning.
Good morning, Judge.
Thank you for covering for Ms. Williams.
Yeah.
Are you handling position 12 for today?
I'll say yes.
Okay.
What's the name?
Melinda Parlor.
I'm just looking at the charge. I'm not assigning it to you. It was cruelty to children, so you'll handle that.
Yes, Judge.
And then you are handling position 9, Jerron Johnson. You were outside when we called it. Mr. Melnick represents Mr. Johnson and we're holding for his report.
Understood, Judge. And
Okay.
it's clear arraignment, but I'll follow to make sure discovery is served.
Right. We got to bring Mr. Johnson out. Stuff. Okay. Jesse Williams.
He's mine, judge. He should be in custody. I have a note from our pre-indictment team about BHTC. I just need to kind of sort that out.
We'll talk with him.
I don't think it's gonna resolve today.
Okay. we'll bring him out at the appropriate time. And finally, Curtis Gardner.
Hearing heard.
Okay, he is, did you already do a waiver?
Yes.
All right, so in terms of bond, we're gonna hear Mr. Battle. And did you say Mr. Fields?
Yeah.
And Mr. Williams? No, Mr. Gardner. All right. Let's quickly touch on our revocation calendar, see who's here. Willie Williams. Ms. Wood, you handling that one?
I will, Judge, and I need to just speak with him briefly and then we'll probably be ready to go.
All right, Reginald Hughes.
My case, Judge, we have a stipulation to the allegations and also to the disposition.
Okay.
I have Judge Farmer holding for me.
He can wait. That's good to know. No, we'll knock that one out shortly. Ruben Rainey.
Get the petition updated to include an additional question, so I anticipate that.
Okay. The additional violation is technical, new charges. Okay. All right. Derek Rogers. Ms. Rios, is this yours?
Yes, sir. Revocation.
Okay. So you're not going to need an evidentiary hearing.
No.
All right. James Smith.
He's mine, Judge. I just need to speak with Ms. Simpson and then we'll be ready to go.
Okay. Thank you. Antonio Hayes. But that is FTA situation. Will that be yours, Ms. Rios?
Probably.
Yes.
Ms. Wood has answered for you. All right. So you'll want to talk to him when we take a break to see what his story is.
Yes, oh, no.
No? Oh, step back.
Because I resolved Miss Tunisia Hayes, so that number 6 and 7 are both conflicts.
Well, and Ms. Cabrera is here, so maybe that's why she's here. Yep. Well, so Hayes has an FTA, so you'll need to talk to him to see why he missed court, and if he's got a good reason for having missed court. You have Antonio Hayes, that's position 6. At least you are saying you have him. Ms. Rio says she can't take the case, it's a conflict, and I think you just said you've got position 6.
No,
You can't do 6 because you have 7. Yeah, all right, so we got to find a lawyer for
I don't have an announcement about this. I'm going to speak to say out.
yeah, well, I think Kimball we now need to do a scheduling order now that Hayes is in pocket. And so since you're here, we can make sure, do you have discovery, that kind of stuff. But I think yours is a pretty light touch. We need to figure out who's going to represent Mr. Hayes. And then we can move both their cases forward. And okay. All right, well, Ms. Smith is sitting right there, so you can bug her if you don't have it. All right, those are all the names on the calendar. Is anyone in court who thought, hey, I didn't hear my case called?
Yes.
Yes.
Ms. Cabrera and I have a plea this morning from the afternoon calendar so that she didn't have to stay here all day.
Oh, I think we talked about that, right? Okay.
Mr. Walker.
Yeah.
Walker. Let's negotiate.
How are you?
Okay. But Ms. Wood,
And number 10 is the co-defendant.
oh, and that's a
That's
plea
fine.
also? And Mr. Peoples, you handling that?
I am good.
Okay. And then I was just handed bond motion in the Prentice Mayo case.
Bond motion. Oh, yes.
I mean, he may have filed it, you may not have. This is a gentleman who's filed a speedy trial demand. You filed something different. Last week, Ms. Nelson wasn't around. I don't know if you got all the paperwork you needed.
Yes, everything's in order for that to go.
Okay, all right. Do you want to go forward with something with Mr. Mayo then? Is he here? Prentice Mayo?
No, he should not, he should be in custody, but.
I was asking the deputy. He's here, yeah. Okay,
I think, because I think probably not, but I just need to make sure he's okay with that.
yeah, talk with him. If he needs to come out and be heard briefly, we give him a little bit of time. He's been read a lot because he's written lots of things. Oh, but someone did, and one of them is a post-indictment speedy trial demand. And so we need to work through the interplay of your motion under seal, the speedy trial demand, et cetera. I don't want the state to be in a pickle that wasn't of their own design because of all the things he's been filing. And with current case law, the fact that he has a lawyer doesn't mean that they're nullities. I can choose to disregard what he's filing, but we have to have a discussion about that.
Yes.
Okay. So you'll chat with him when we take a break?
Yes.
All right. Anyone else? No? Okay. Why don't we do Mr. Fortis's matter, because that will free up Rios and Wood to start talking with some folks. And then after we do that, because we've got Ms. Cabrera here, I thought maybe we could do that Walker plea. And that will get Fortis and Cabrera out of here. We can focus on all the other things in the order you want to do them. And maybe Mayo would be the one after that. So we get Mr. Body out of here. No rush. Okay. I'm kind of looking forward to meeting him. So, Deputy, to translate all that, Reginald Hughes is who we need brought out, please. Yes.
Okay.
You look surprised.
I'm sending you.
Yep.
Look up my room.
You're asking for a community.
He's on this position.
Which
Believe both.
I read, but which case? Oh, he didn't give you the name of a case.
So you'll have to.
Okay.
We just set position. On the regular calendar. On the calendar that they.
Yeah,
Position, what is it?
I'm opening it up.
Yeah.
Yes, ma'am. Okay. Well, why don't we do, since Mr. Hughes is still downstairs, they're bringing him up. And Miss Cabrera left.
Two guys.
Okay.
From
We could do, well, Ms. Wood left.
right there.
Well, you know where everyone is. We could do that plea, and then we can do Mr. Fortis's case. Think I know what he's talking about now.
I would have to find the calendar. Somewhere on email.
No, we're good. You're talking about Mr. Walker? Yeah, no, we're good. But we also need Ms. McClarity. She's here?
Yes.
Okay, and are we okay having the plea happen at the same time?
Yes.
Okay,
Recommendation.
okay. All right, and Mr. Peoples, you're good to go with the plea?
I am, Judge, in 2 seconds.
Okay, take your time. So let's set it up this way. Mr. Walker, stand all the way to my left, and then your lawyer is going to be next to you, and then Ms. Wood is going to stand next to Ms. Cabrera. Ms. McClarity, you're going to be all the way to my right. Do you want to go to Judge Farmer first and come back? Because Mr. Hughes will be here. Okay. And what is you'll be back this morning? Well, Farmer works in mysterious ways. Okay, yeah.
Once I get there, you gotta let me go.
No, exactly. Tractor beam.
You get an 911 call.
We know where to go. Yeah.
Make sure she can. Quick.
Know when you're ready, Mr. Peoples.
Yes, Judge.
The parents are playing.
Just pulling up the plea litany. Yeah.
What she told me is, so who is in first, is it the counts or was she not present?
I think it's just one girl and children. Is that
I
you
have
to the
one.
email? Okay.
Yeah, I have one written down.
Yeah.
She's in 2, 4, and 6.
Yes.
Count one. Count two.
Yeah. Thank you.
All right, no problem. Get the case up here and we'll get started. All right, Ms. Rivers, are you ready? Okay, we're going to get on the record. This is 25 SC 007831. It's State versus Mr. Walker, who is standing in front of me with his lawyer, Ms. Cabrera, as well as State versus Ms. McClarity, who is also up at the podium with her lawyer, Ms. Wood. Mr. Peoples is representing the state for purposes of the plea. Mr. Walker, my understanding is you're ready to go forward with the plea. Is that correct?
Yes, sir.
And Ms. McClarity, you as well?
Yeah.
Okay, here's how this is going to work since both of you are up there. Mr. Peoples is going to put both of you under oath in just a moment. Once you're under oath, you'll need to answer all his questions truthfully and completely. Many of the questions are going to be identical, so he'll ask it just once. And then he'll say, Mr. Walker, Ms. McClarity, don't answer at the same time. Answer after he calls out your name, and he'll go in whatever order he wants to go. But he'll just say the question once, and then he'll get the respective answers that you all have. There will be parts of the conversation that are exclusive just to you, Ms. McClarity, or just to you, Mr. Walker. But when Mr. Peoples is done with all his questions, then I'll hear from both the lawyers, and if there's anything either of you wants to add as well, I'll hear from you. Any questions about that process, Mr. Walker? Ms. McClarity? Okay, if at any point you're confused by what's happening, or it's not making sense, or you need to clear something up, raise your hand or nudge your lawyer, okay? Mr. Walker? Ms. McClarity?
Yes.
All right, Mr. Peoples?
Yes.
One second, Judge, I think I just lost something. I'll start with Ms. McClarity first, and then
Why don't we have them both raise their right hands and you swear them in, then you go however you want to do it.
you solemnly swear that the testimony you give in the proceedings before you today will be the truth, the whole truth, and nothing but the truth.
Yes.
Yes.
I need you to call their names out before they answer in the future.
Ms. McClarity,
Yes.
Mr. Walker.
Yes.
Okay, you can lower in. Ms. McClarity, can you state and spell your name for the record?
It's Lakedra McClarity, L-A, capital K-E-D-R-A, McClarity, M, lowercase c, capital C, L-A-R-I-T-Y.
And Mr. Walker?
Montague, the Warren Walker, just spell M-O-N-T-A-E as in Victor, I-S, the Warren, E-W-A-N, Walker, W-L-K-E-R.
Thank you. Are you at this time taking or under the influence of any drugs, medication, or alcohol? Ms. McClarity?
No,
Mr. Walker?
No,
Is there a medication that you normally take that you have not been given today? Ms. McClarity?
no,
Mr. Walker?
no,
Ms. McClarity, you paused for a second. You're not sure about, it's okay if you're taking medication. We just need to make sure that there's nothing in your system that's gonna make it hard for you to follow what's going on.
Okay.
You're good?
yes, because I know sometimes I took my anxiety when I was in custody, but I'm not taking it as right now.
Okay, well, sometimes not taking medicine can be as much of a problem as taking certain drugs.
So,
Okay, but does the fact that you did not take your anxiety medicine make it hard for you to follow what's going on?
no.
You feel calm enough to go forward? Yes? Okay.
Okay. How old are you, Ms. McClarity?
I'm 32.
Mr. Walker?
34,
And what's the highest level of education that you've completed? Ms. McClarity?
Okay, 12th grade.
And Mr. Walker?
11th grade.
Okay. Ms. McClarity, are you saying you completed 12th grade?
Yes,
You graduated from high school?
yes.
Okay. And Mr. Walker, the 11th grade? Mr. Walker, do you have your GED?
Been working on it, but it costs.
Are you able to read, write, and fully understand the English language, Ms. McClarity?
Yes,
Mr. Walker?
Yes, sir.
You understand that you're charged with the following offenses. In 25 SC 007-831, one count of cruelty to children in the first degree, which carries a sentence range of 1 to 10 years. I'll do it this way, Judge. Miss McClarity, you're charged with counts 2, 4, and 6. Count 2, cruelty to children in the first degree, which carries a sentence range of 1 to 10 years. Count 4, cruelty to children in the first degree, which carries a sentence range of 1 to 10 years. And count 6, battery, which carries a sentence range of 1 day up to 12 months. And Mr. Walker, you understand that you're charged in count 1, which carries a sentence range of cruelty to children in the first degree, which carries a sentence range of 1 to 10 years. And count 3, cruelty to children in the first degree, which carries a sentence range of 1 to 10 years.
Yes, sir.
You understand that you have the right to plead either guilty or not guilty to these charges, Ms. McClarity
yeah,
and Mr. Walker?
Yes.
You understand that if you plead not guilty or remain silent and enter no plea at all, that you may receive a jury trial,
Yes.
Ms. McClarity
yeah,
and Mr. Walker?
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses? Ms. McClarity
yeah.
and Mr. Walker?
Yes.
Do you need any more time to discuss this case with your attorney, Ms. McClarity
No,
and Mr. Walker?
No.
Are you satisfied with their services, Ms.
Yeah.
McClarity and Mr. Walker?
Yes.
Counsel, do you waive formal reading of the indictment? Ms.
So waived.
And
So if.
thank you. Do you waive any and all defects in the indictment, including any with respect to your client's name?
We do. Yes.
You understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state to the defense, by the state and by the defense to the court is that Ms. McClarity, counts 4 and 6 will be null prost, and that you will plead to count 2, cruelty to children in the first degree, with a sentence recommendation of 7 years of probation, that you shall complete a parenting course, that you shall have no contact except as recommended by the Division of Family and Children's Services, that you shall no drugs or alcohol except as recommended or provided by a physician, and a Fourth Amendment waiver. Judge, I can't recall whether or not the court was inclined to do those. It's been some time since I've been here.
I'm fine with the Fourth Amendment waiver. The no contact is with whom? With the two, there's a Desmond Holt Jr. and a Mackenzie Holt who are listed as the victims in the case. I just wasn't sure. You said no contact without defects, blessing it, and I need to know with whom.
It would be both, Judge.
Okay.
And then Mr. Walker, well, first, Ms. McClarity, do you understand that that's the recommendation?
Yes.
And then Mr. Walker, that count 3 be null prost, and that count 1, the sentence recommendation is 7 years of probation, that you shall also complete a parenting course, that you shall have no contact with the same victims, Judge, except as provided by Division of Family and Children's Services recommendations, that you shall have no alcohol or drugs, and a Fourth Amendment waiver. Do you understand that?
Yes, sir.
So Ms. McClarity was pleading to count, did you say 2 and 5? And then 4 and 6 are the ones being dismissed?
Just the 2, Judge.
Just the 2. So 4, 5, and 6 are being dismissed.
Correct.
Okay. So count 1 for Mr. Walker, count 2 for Ms. McClarity, everything else is dismissed.
That's correct, Judge.
All right.
Counsels, is that the understanding and the recommendation that you understood for your clients as well?
It is.
It is.
You understand, however, that the court does not have to accept this recommendation, and the court can sentence you to the maximum on each of those charges and run those sentences consecutively or one after the other. Ms. McClarity
Yeah.
and Mr. Walker.
Yes.
You understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in the other jurisdictions, including the federal courts. Ms. McClarity
Yes.
and Mr. Walker.
Yes.
You understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today. Ms. McClarity
Yes.
and Mr. Walker.
Yes.
You understand that if you're placed on probation of any kind, that you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence. Ms. McClarity
Yes.
and Mr. Walker.
Yes.
You understand that you are not allowed to possess nor use a firearm while on probation. Ms. McClarity
Yes.
and Mr. Walker.
Yes.
Are you a citizen of the United States? Ms. McClarity
Yes.
and Mr. Walker.
Yes.
You understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty today. Ms. McClarity
Yes.
and Mr. Walker.
Yes.
There are certain rights that you give up by entering a plea of guilty, which include the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand all those rights, Ms. McClarity?
Yes.
Mr. Walker?
Yes.
Has anyone used any force, threats, or promises which has caused you to enter this guilty plea against your will? Ms. McClarity?
No.
Mr. Walker?
No.
Is it a decision to waive these rights and enter a guilty plea because you are in fact guilty? Ms. McClarity
Yes.
and Mr. Walker?
Yes.
How do you plead to Ms. McClarity to the charge of cruelty to children in the first degree?
Guilty.
And Mr. Walker, how do you plead to the charge of cruelty to children in the first degree?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you? Ms. McClarity?
Yes.
Mr. Walker?
Yes.
You understand that unless counsel is substituted or permitted to withdraw, the defense counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later. Ms. McClarity?
Yes.
Mr. Walker?
Yes.
You understand that you have only 12 months from today for misdemeanors and 4 years for felonies to file what is known as a habeas corpus petition challenging the voluntariness of this guilty plea. Ms. McClarity?
Yes.
Mr. Walker?
Yes.
You do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request what is known as a discretionary appeal. The discretionary appeal procedure is outlined in OCJ 5-6-35 and must be completed within 30 days of today's date. Ms. McClarity?
Yes.
Mr. Walker?
Yes.
You understand any of the filings that we've just discussed must be completed and filed by your counsel unless you're representing yourself. Ms. McClarity?
Yes.
Mr. Walker?
Yes.
Your Honor, Ms. McClarity does not have any felony convictions, and Mr. Walker. One second, Judge.
I'll be hearing from pretrial services, so
Okay, then I'll just,
Ms. Gordon can fill me in a little bit. Why don't you finish up your part?
understood, Judge. One second, Judge, just pulling up the factual basis. Your Honor, if this had proceeded to trial, the state would have expected to prove beyond a reasonable doubt that on or about October 17th of 2025, Mr. Walker reported that his 11-year-old son, do you want the full name or the initial?
However you want, your policy.
Desmond Holt Jr. Was in the Desmond DSMOND Holt HOLT was in the home performing oral sex on the 9-month-old Jace Walker, JACE Walker, common spelling. Mr. Walker stated he is the stepfather to 3 of the children, Desmond Holt Jr., Mackenzie Holt, Mackenzie Makenzie, and Jace Walker, and stated that Miss Mackenzie Holt, all children were brought to Hugh Spalding and for a medical evaluation. Before the medical evaluation, DFACS spoke with Desmond, who stated that he had done this and had done it before, sometime around April 3rd. Desmond stated that he had learned by watching YouTube. Family stated all of these events occurred at 311 Scott Street Southwest in Atlanta, Georgia, in the bounds of Fulton County. Miss McClarity had, the DFACS worker stated that Miss McClarity had reported to DFACS that she strikes the children with belts, and Mr. Walker would use what he defined as a paddle, but appeared it was some sort of back scratcher, Judge. Desmond stated that to DFACS that he was struck by his parents with belts and back scratchers for not listening and doing what he was supposed to be doing, quote, doing what he was supposed to be doing on the week prior in October 17th of 2025. Ms. McClarity and Mr. Walker, do you stipulate there's a factual basis for this plea? Counsels?
Yes. Yes.
That's all from the stage.
It took a little turn I wasn't expecting. So one of the child victims in this case was doing something to a sibling, step or otherwise, that was also a DFACS type issue.
Yes, Judge, and I believe the way that it comes out is that while DFACS is interviewing them about
what was going on, then DFACS learns from the 2 children who are the victims here about how they're disciplined at home.
correct, Judge.
Okay. All right. Do you know from your review of the case file where the 2 children who are the victims in this case now are staying? I don't mean street address, but are they with a foster family or a DFACS or an uncle?
So I do not judge. I'm filling in this morning. I
Mhm.
know that Deputy McGillicuddy had done her due diligence, but I believe she is aware, but I'm not.
Okay.
They're still in foster care.
All right, I'll find out from the defense attorneys. I was just curious if the state had a perspective on that. But the state's perspective is that both Ms. McClarity and Mr. Walker are to stay away from Desmond Holt and Mackenzie Holt absent approval of DFACS. So if there is a reunification plan, it comes through DFACS, not through the DA's office or through me.
Correct, Judge.
Okay, understood. Good morning, Ms. Gordon. How are you doing?
Good morning, Judge. How are you?
I'm well. Thank you for joining us.
Yes.
Can you share criminal history information? Let's start with Ms. McClarity first, please.
Yes, Your Honor, the defendant has no criminal record on file.
All right, and then let's pivot to Mr. Walker.
The defendant has 24 arrest cycles beginning in 2009. Last arrest was September of 2023 from Gordon County on a violation of probation. The underlying charge was not listed. 2 prior felony convictions outside the 10-year period. Nothing further.
Thank you, ma'am. Ms. Simpson, is Mr. Walker on probation now? No? Okay, all right. Ms. Cabrera, I'll start with you on behalf of your client, Mr. Walker.
Hey, yes, Your Honor. They are currently, so the children are currently in foster care. There is a plan being worked on through DFACS. DFACS was on hold about what they were doing or how this plan was going to start working until this case was resolved.
Mhm.
I think in June, they should be able to get started working on whatever the plan is that DFACS has.
Okay. And when you say the children, I've heard about a Desmond Holt and a Mackenzie Holt, and then there was a Jace.
Yeah, Jace Walker.
Right. Are all 3 of them in DFACS custody?
Yes.
Okay. And Mr. Walker, do you know if they are together, the 3 siblings?
Mackenzie and Jace are together. Desmond are separated.
Okay.
Because of the answer.
Oh, right. That makes sense. So Desmond is in foster care on his own, and then Mackenzie and Jace are in foster care together.
Mhm.
Yes. Okay. All right. I'm sorry, Ms. Cabrera, back to you.
Yes. So we were fortunate enough to there was another resolution that the state had wanted to try to reach with this case. Unfortunately, Mr. Walker wasn't eligible for diversion and things like that, but initially that was something that they had presented and hoped that would have resolved the case. And obviously we can't do it this way. So the next best thing was the plea to probation. So I'm asking that Your Honor accept the plea as negotiated. If there is an opportunity for probation to at all terminate early, that we would also ask for that.
Okay. Got it. Ms. Wood, well, let me ask you, Mr. Walker, is there anything you want to add, or have we covered it all?
We covered it all.
Okay. Your biological relationship to any of the kids? I heard you were sort of stepdad. Are you the biological father of any of the 3 kids?
No.
No, you're the stepfather.
Yes, sir.
And how would you describe your relationship with Ms. McClarity, if you all have one?
We're married.
You're married?
Yes, sir.
Okay, well, there you go. How long ago did you get married?
Yeah, 24/5.
Okay, I'll talk to you, Ms. McClarity, in a minute, although she seems pretty excited about that date. So you've got an anniversary coming up in a few months. All right. Do you work?
I'm currently through first step staffing.
Mhm.
So we had work when we first got out, but then work don't start back up until August. So
Okay.
we're waiting for more work to come.
But it'd be through First Step.
Yes, sir.
Okay, it's a good program. All right, thank you, Mr. Walker. Ms. Wood?
Thank you, Judge. So Ms. McClarity served 126 days on this case. If you recall, I had filed a speedy on this earlier this year because she actually had a 4th child while she was incarcerated. That baby is with a family member of Mr. Walker's. So there's 4 children total. I have been speaking to the attorney that's been working with DFACS or with Ms. McClarity for DFACS, Ms. Vanna Wilson. I was hoping she would join us today, but I don't think she made the call. She says that Ms. McClarity is a model client, that although she did have poor teaching about appropriate discipline growing up, to her credit, she's been very communicative with DFACS and law enforcement, and she's indicated that she's ready to learn alternative discipline methods. And so they had actually reached out to Ms. Cabrera and I to see if we could modify bond conditions to start the supervised contact. So I think this is a fair resolution. We appreciate the state working with us.
Okay.
Oh, and I would ask for first offender treatment for Ms. McClarity. If I didn't say that already.
You didn't?
Okay.
All right.
No objection from the state.
No objection from the state. All right. Ms. McClarity, anything you want to add? All right. Now, I know you're married to Mr. Walker. Mr. Walker several times said, we about work. Were you also getting work through First Step? And your hope is to get back to that when they start hiring again?
Yes.
Okay. All right. And you have a fourth child, boy or girl?
Boy.
Okay. Is the father of Desmond and Mackenzie at all active in their lives?
No.
No? Okay. Okay, so Mr. Walker is, if DFAX says it's okay, is going to be the father figure in their life.
Yeah.
Okay, understood. Do you have any questions about anything we discussed?
No.
Anything you want to add?
No.
So first offender, Ms. McClarity, is primarily an opportunity for someone who does not have a felony conviction. It means that while you'll have a sentence here and you'll be on probation and need to do all the things people do while they're on probation, if you successfully complete your probation, then you can have this all wiped from your record. It also means that if you are applying for a job or thinking about going on to college, when you see that question, are you a convicted felon, you get to say no, because a first offender is not. You will be on probation. Your probation will be no different from Mr. Walker's, except that if you manage to sail through it all right, then when the case is closed out, you continue to have no conviction. That's the good side. There's a downside, and that is that if you get in trouble while you are on your first offender probation, not only do you have the new charges, but the state could come back to say, hey, we misunderstood who Ms. McClarity was. Look at this, 6 months in, she got arrested for hitting her kid again. That would be the kind of thing where not only would you have new charges, but I would very likely revoke your first offender status, and I could resentence you, because you've already pled guilty, up to the maximum in this case, which Mr. Peoples told you is 10 years. I'm not saying I would do that, but you need to know there is a risk to, a downside to being a first offender. Do you feel like you understand how first offender works?
Yes.
Do you want to be sentenced as a first offender?
Yeah.
Okay. Well, I'll start with you since we're in the midst of a conversation. Ms. McClarity, I find that there is a factual basis for your plea. Both you and Mr. Walker administered discipline in a way that's not okay. But you learned from that. Sounds like you won't do that again. I also find that your plea is knowing and voluntary, that you've understood what we talked about and that no one's forcing you to enter this plea. Do you agree with that?
Yes.
All right. Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
Mr. Peoples, can we sign for you?
Yes, Judge.
And Ms. McClarity, are you okay if we electronically sign your name to the indictment indicating your guilty plea to count 2?
Yes.
We'll do that. Counts 4, 5, and 6 will be dismissed. I will follow the recommendation. My sentence is going to be a little different. I'm just giving you credit for the time you've been in. I'm sentencing you to 7 years to serve 4 months with a balance on probation. So you're going to get credit for the time you served. You have a little less probation. Then special condition of probation number 1 is that you take a parenting class. And then number 2 is that you have no contact with any of your 4 children before DFAX has entered a parenting plan that designates how you have contact, where you have contact, et cetera. The goal is to reunite if that's what DFAX thinks makes sense. If that can be safe for your kids, then let's get everyone back together. But you go at their pace, not your pace. Do you understand?
Yeah.
Okay. Mr. Peoples, anything else?
Nothing from state, Judge.
Okay. Ms. Wood?
No, Judge, thank you.
All right. We have one more thing to say about probation, but I'm going to turn to Mr. Walker now. Mr. Walker, I find there's a factual basis for your plea, and that your plea is knowing and voluntary. It means the same things I just said to Ms. McClarity. Any questions about anything? Okay. Mr. Walker, can someone in my office sign the indictment for you indicating your plea to count 1?
Yes, sir.
We'll dismiss count 3. Ms. Cabrera, can we sign for you?
Yes, Judge.
All right, Mr. Peoples already told us yes.
Yes, sir.
Mr. Walker, your sentence is going to be 7 years to serve 4 months. You did a little more than 4 months, not quite 5, but you'll get credit for those 4 months with a balance on probation. And just like Ms. McClarity, Special condition number 1, take a parenting course. And that may be more than one class. It's just you need to get through the whole course. And then number 2, no contact with any of the 4 children we've been talking about without DFAC's approval. It sounds like you are both working together with DFACs to reunite with your children. But as I mentioned to Ms. McClarity, you need to do it under the structure and the rules that DFACs provides, okay? Mr. Walker, what county do you live in? Okay. Ms. McClarity, do you live with Mr. Walker?
Yes, Mr.
All right, so you live in Fulton County too. Ms. Simpson is going to give both of you reporting instructions for probation. Don't miss your first date with probation, okay? Do you know where the Fulton County Probation Office is?
Yes, I do. It's down by pretrial.
Is that, I don't know where pretrial, oh, meaning the pretrial detention center. Yes, yes, it is. What do you want to talk with them outside? Okay, so, and Ms. Cabrera, I think that's everything you've got here. So if you would just go with Mr. Walker, have him engage with Ms. Simpson and Ms. McClarity, you can go as well.
Thank you, Judge.
You bet.
Thank you, Judge.
Goodbye.
If something interesting happens, I'll be in Delaware.
Oh, you're not going to faraway counties? Okay. All right, we'll holler if something interesting happens. You bet. You're back.
I think I'm trained for my client being out county, so they literally just got out.
Oh,
So
so you should go do some other things for a little while?
that is gonna be the case, but I don't know if I'm gonna make it back here unless this afternoon I can pop on Zoom or something, if that would be an option.
It's not a problem. I think you said that the Hughes case is one you and Ms. Smith have worked out. Or is it contested?
Stipulated to the time served, private time release time served. And I think that Ms. Smith is not going to do the time served, but that's something that I need to.
Okay, and you're comfortable, Mr. Hughes would be here in court, as would the prosecutor. I'm fine having you be on Zoom as long as you don't think that's gonna make Mr. Hughes have
To
a,
the extent he's uncomfortable,
we just reset it. Okay,
I'm here all the time.
okay.
Would that work for you? And I'll bounce, I'll finish to Judge Farmer those.
Yeah,
I'll come back.
swing back by here and see, just in case he's here. All right, sure.
What about? It's Rios' class, she said that she went and do it right here.
She was at a doctor's office, too busy to.
Ms. Rios, what would you like to do next?
Here, so let's handle that if possible.
All right, we've got the prosecutor here. Tell me what you envision happening.
No problem. Today, we're gonna wait.
Okay, is he aware of the steps you're taking to help him out?
Yes.
Okay, then let's bring does he need to come to you think it's pretty brief or should he come to the podium? Okay, all right.
So I'm going to discuss about the plans and the speed of how detailed that conversation.
Well, he can just come to the podium with you. Are they getting Mr. Mayo? Thank you. Hi. Oh, okay. Thank you for being here.
Here. 6, 6,
Okay.
9, 8, 9, 9. That the date you went down there was March.
Did you and he talk about the speedy and your view that that's probably not the right way forward?
Yes, he didn't file any of those things.
Okay.
He didn't know anything about them.
Oh. Family did?
Yes.
Okay. Lawyer family members?
I hope so.
I don't
Mr. Mayo,
Mhm.
are you Mr. Mayo?
Yes, sir.
Great. Mr. Mayo, I'm Judge McBurney. We're gonna have an informal conversation right now. I wanted to introduce myself and give you a lay of the land in your case. But I'm pulling it up right now. Here we go. Okay. So, you're charged with some pretty serious offenses. Ms. Rios is your lawyer. I have already been working with her and the prosecutor to make sure your case is moving forward. Your lawyer filed a waiver of arraignment. That's just entering a not guilty plea on your part so that she could start to get discovery, whatever evidence the state has, body cam, witness statements. I don't know what the evidence is, but your lawyer is going to get it so she can meet with you and talk with you about it. She also has arranged for a doctor to come talk to you. I hope when that doctor comes, you'll engage with the doctor. That's up to you, but I think it's pretty important for the doctor to work through a few things with you. Someone has been filing lots of things on your behalf in the docket, not your lawyer. And I would encourage you, Mr. Mayo, as you're talking to friends and family members, to have them talk with Ms. Rios rather than putting things in the docket, because it gets a little confusing for me to figure out, well, wait, who's asking for what? Ms. Rios needs to be the one who's asking for things. And if she says, you know, I don't think this is a good idea, ultimately that's her call as your trained, professional, experienced attorney. And you may have friends or family members who get online and think they know some stuff because they've seen it on TV or ChatGPT told them something, but they aren't the ones who actually have your case file and have your legal best interests in mind. So I will typically not pay attention to things that aren't filed by Ms. Rios. But we'll see each other every once in a while, and you'll be able to say, Judge, I'm frustrated if you two are disagreeing about something. I want my lawyer to file X, and she's not doing that. Maybe we can talk about that a little bit. But Ms. Rios has taken all the right steps to move your case forward so far. Do you have questions about anything we've been talking about? No? Okay. Well, like I said, there's going to be a doctor who's going to come talk to you soon. Please engage with that person. Ms. Rios should be, looks like she already got a big chunk of discovery in the case. So she's going to be going through that. And if there are things that she wants to share with you that aren't paper, because she can give you paper, but if it's a video, she can make arrangements so that she or her investigator can come out to the jail and they can get there and watch it with you so you can see everything she's got as well. And that's typically how we move things forward, okay? Ms. Rios, was there anything else you wanted to cover with Mr. Mayo here?
No, Your Honor, thank you.
Mr. Abadi, anything about the case discovery-wise that you're thinking might slow things down?
Just the ballistics testing, Your Honor.
Okay.
That's hopefully in the process now.
Sure. So, Mr. Mayo, that's a good announcement from the prosecutor. It sounds like all the discovery minus one piece he's either already got or he's getting soon, and he'll give to your lawyer. The ballistics testing just means that maybe there was a gun recovered, and they're going to see, does the gun that was recovered match a shell casing or a bullet? I don't know the specifics. That takes a little while because the crime lab, there's a long line to have things tested, but they're working on it already. Okay? Any questions for me? No? All right. Well, I'll keep looking for things from Ms. Rios and from the prosecutor. We'll have you come back here anytime we need to talk about your case, okay? All right. Appreciate it. Nice meeting you. Ms. Wood, you got something you want to do?
Are we on Willie Williams from the probation revocation calendar?
Ms. Rios, we'll do I don't think there's a scheduling order yet in the Mayo case, so we'll do that, or should we wait because we need to get the results from the work you've asked for? We should probably wait.
Yeah, yes, Your Honor.
Okay. Hey, Mr. Williams.
How you doing, sir, Judge?
Give me 1 second while I get your document on my screen. All right. Ms. Rivers, are you ready? We're going to go on the record in Mr. Williams's case. It's 21 SC 179174. And we are here today to talk about a revocation situation for Mr. Williams. He's here in court with Ms. Wood. Mr. Abadi is handling things for the state. And Mr. Williams, I signed in December of last year, so about 5 months ago, a warrant, probation warrant, that said that you had left the Salvation Army program and then you were a little bit behind on your probation supervision fees. So these are both technical violations. I'm gonna hear from you and Ms. Wood. I'm just setting the stage here. It's not that you got arrested again, but that, hey, we were hoping you'd benefit from being in the Salvation Army. Maybe that didn't work out. Maybe it did. You're gonna tell us about it in a second. And we got to make sure you're handling whatever your obligations are. So, Ms. Wood, is Mr. Williams stipulating by way of explanation to what was here, or?
I'm just planning to stipulate and admit to the violation, Judge. He's
Okay.
got 1 year, 9 months, and 6 days remaining. Ms. Simpson and Ms. Smith, I believe, are recommending revoke 45 days and reinstate the balance. I was going to ask for the same. He's been in 59 days. There's actually a representative from PAD here who's here on his behalf. So I was just going to ask that we revoke time served, and then as soon as I get the date certain from PAD, I'll get a release order in place.
Okay.
And then, of course, once I get where he'll be staying, I'll get an updated address for you. No.
So it would be released to PAD, not, obviously, PAD wouldn't be a condition of probation. And when we release to PAD, someone comes and picks him up? Is it, you all have the transport, or does the public defender's office get someone to your office? Okay, all right. So Ms. Wood, you'll get a transport order when, or I guess there are three. I mean, does the sheriff's team bring people to PAD, or you prefer PAD people come pick participants up?
So we have them scheduled to go into the program. There has been officers to have transported him, but usually we take them. We schedule for someone to come.
Okay, it'll be whatever order Ms. Wood submits. And then Mr. Williams, you'll be transported to PAD. Hopefully you will embrace the services they provide you. They're not being forced on you. If you say, no, thank you, it's just gonna make probation a little more complicated, but they can be very helpful in terms of finding supportive housing and other things you might need, okay?
Okay.
Do you have questions about anything we discussed?
Well, Judge, I just want to say this for get the record straight. Yeah, I put myself in the Salvation Army, and what happened? I was pitching beds together, and the guy who was training me, he went back to his hometown. So the other people I went to go help load the truck, they didn't work that day. So I'm there on the dock wandering around. So they said I wasn't working. They said I was hiding from working. So they put me out.
Okay.
That's what
Well, that's a frustrating ending. We're gonna move past that. It sounds like, there's another opportunity for you, which is great. Ms. Simpson, did you have anything you wanted to add in connection with Mr. Williams?
On his last, recognition in September of last year.
Okay,
Where you were voting to the MEDRC, but he abstained from us, so he never actually got to start. So, my recommendation was going to be the time served, but to include the condition that he entered into the MEDRC.
all right. Mr. Williams, any reason why you didn't start the MAD? We meet fairly often. And we were together, not all that long ago, September of last year. And, you had asked for some help. And one of the things we decided was to have you go to the day reporting center, through probation.
to them.
Yeah.
Yes, I was going there. I was going.
Well, I don't mean that just that you reported to probation every once in a while, but the day reporting center is, series of classes and you get, drug treatment, things like that. That's not something you had started doing.
Oh, I haven't got that. I ain't did
No.
that one this time.
Is that something you're willing to do?
To that one.
Yeah.
Oh. Yeah, that's kind of hard though.
Tell me why it's hard.
Why it's hard?
Yeah.
Well, I can do that.
Well, you don't need to be agreeable. I want to get your input. If you think we're signing you up for something that's not going to go well, then I just see you again. And you got to get dressed up like that. And that's not great for anyone.
But I just come to report. I like this come to report. Oh, do I have to take the class?
I'm not sure. I'm trying to decide. I want to know why you don't want to take it.
Well, you know, cause
Let me hear, our friend from PAD is going to add something.
And he was recently assigned to me. So there's two tiers, and the first tier is more like a lower level. And then there's a higher level need, so now it's on the higher level need side. So I'm sure you're familiar with that, but we work with individuals without SPI, severe persistent mental illness, or chronic illness and valve addiction, and one or multiple of these things. So some of the hurdles that he's been facing is transportation, and there isn't, the level of care isn't all under one facility, so it's having to get from this place to this place. So we're working on getting him the housing first, and then from there, make sure he has the transportation to get from one place to the other. Because it's hard to address, any type of mental health or addiction, anything.
Sure. No, understood. So maybe, so the dilemma is this, doctor. PAD does wonderful things. PAD's philosophy and I'm gonna call it business model. I don't mean to commercialize what you're doing, but its approach is that PAD cannot be a condition of a sentence. And so I can be hopeful that Mr. Williams embraces the services that PAD is providing and takes advantage of them in a good way. But if he decides not to, and then he wants to go hang out with friends that aren't necessarily conducive to his mental health and sobriety, PAD doesn't stop that. It's not their role. But PAD also doesn't call 1-800-revocation to say, hey, he stopped using the services we provided. If Mr. Williams is going to the day reporting center, if he decides to stop because addiction got the upper hand or he stopped taking medication for whatever reason, we're able to take action because I learn he stopped going to the day reporting center. And so that's all I'm trying to work through. I trust Mr. Williams would want to use the services that PAD provides, but if he doesn't, we often learn about it too late. So that's just sort of what I'm working through. Had Mr. Williams been a tier one person for a while at PAD, or this is his first time through, and your assessment is that he is in need of tier two?
Tier two earlier in the month or the end of, so he's fair.
Okay.
Two.
Got it. Had he been a tier one PAD recipient in the past, or this will be sort of his first time with PAD?
He's been with like tier one, and there was like another evaluation of him to determine that he benefit from higher level care.
Okay. So, Mr. Williams, I'm just looking back. We were together in May-ish of 24, May of 25, and here we are. You've got a pretty good cycle. It seems like once a year we get together to talk about revocations. How do we stop that from happening?
Well, I'm really, I'm trying, basically, what's bothering me, I'm trying to get into my own place, That's bothering me, because when I got out last time, they put me in like a shelter, and I stayed in like 7 months, and I'm trying to, I don't put my name on, I went to safe house, for a voucher for my apartment, so I had my own place, because when you live around 300 people, that's different vibe.
Hmm?
You can't bring nothing in, you can't work to own and hold nothing. So, but I get a check, but you go anywhere to rent, they want $1,300.
Right, and your check's not that big.
Then I can't work. So, they leave you like homeless, what can you do? And but I have one thing I haven't done. She tell you this. I haven't like gone to pass like once a week. She see me there at the place at pass.
How do you get there?
Oh, just look at my bus card.
Okay.
So I do report the pass. I do.
Okay. Well, Mr. Williams, I am going to revoke your probation. I'm going to revoke 2 months. You will get credit for the time you served. I'll reinstate the balance. I will ask Ms. Simpson to include language on the revocation order that you'll be released under a separate order. So you're almost done with the 2 months. Tomorrow will be 60 days, but they're not going to release you tomorrow. They'll release you when PAD says we're able to come get Mr. Williams, that we've got the housing in position, et cetera. So that might be a few more days than just tomorrow. I'm going to waive your probation supervision fees for 6 months. And I will not, for now, require you to go to the day reporting center. We'll see what happens over the next few months. You're still going to need to report to probation.
Right.
You can't be scarce. Your officer needs to be able to find you. But hopefully you will get your own place. Okay?
Okay.
Ms. Wood, anything else in connection with Mr. Williams?
No, thank you.
Ms. Smith, Mr. Abadi was covering for you for a little bit, but I never got to turn into see what the state thinks. Any thoughts about Mr. Williams?
We have the same recommendation as probation.
Okay, all right. Doctor, I appreciate you being here. Anything you need to tell Mr. Williams, I need to tell him, or he knows where to go?
So when I get out, so that I go report to pass.
You will be taken to PAD.
Oh,
You are not just going to be released and there you are at Rice Street wondering where to go.
Oh, PAD.
PAD's going to come pick you up.
Okay.
And you're going to go where that car takes you.
Okay.
It either will be to PAD's office or it might be to the place they found you.
Okay.
Okay? All right. Thank you.
Judge.
Thank you. Okay.
I just promise. Since they're.
That's close. Ms. Rios,
Yes, did you have several things, you want to bond?
you have lots of things.
But if you do the probation.
Whatever you want. I mean, it's, I think you and Ms. Smith have everything else. What-
You went into the probation revocation with Derek Rogers?
Yeah, I'm ready for that. Yeah.
Yes, you could throw it out. Shane.
Nope. Was
You want to kind of cut in? Okay.
conscription remains in place.
Right. It's not, I walked down the first one. It's another short.
You need me to wait. We're done before I get back. We're just waiting on the reporter. How you doing? Are you starting your line? Are you starting your line? Are you starting your line?
No, I'm just messing with it and getting down like it up. Yeah. How's your day?
Okay, how's your day?
Yeah. Good day.
Mr. Rogers, we got to wait 1 second. Court reporter had to take a quick break. I'm gonna get a little information before we start. Ms. Simpson, how much time is left in Mr. Rogers' case? Number 4? All right.
He doesn't have control. He's gotta wait till they come back. They gotta wait there. But you have to control all that. I'm not going, he can't, I know he can't do. Cause he can't order immediate release, like the jail has to process.
I mean, I think, get me on the whole,
Okay. We'll just, you know,
just work it out.
yeah.
No problem. All right. Get on the record. This is 24 SC 004-406, State versus Derek Rogers, who's here in court with his lawyer, Ms. Rios. Good morning, Mr. Rogers.
How you doing, sir?
I'm all right. And Ms. Smith, are you handling this for the state?
Yes, Judge.
Okay. Mr. Rogers, we are together again after a plea a little over a year ago in your case. I signed a probation warrant from March of this year that says in May, June, and July of last year, you were testing positive for cocaine, also meth. Didn't report in February of this year, and you're a little behind in some of your payments. So these are technical violations, things that worry us because if you're not doing well in terms of addiction, that could lead to other problems for you that I'm sure you don't want. Ms. Rios, is Mr. Rogers admitting to these allegations?
Yes, Your Honor.
Okay, and what are you recommending that we do?
I'm recommending that we revoke the 30 days, and I've talked to probation and the state, and we're all in agreement. He is currently, as far as like the payments and things, he's on disability. He's had a lot of health issues. He had a bone infection. He had, I'm not sure if you remember before, but he has a prosthetic leg. So he's dealing with a lot health-wise. And so he's trying to just address it and try to be healthy again. And he's hasn't gotten a new offense. I know that's a low bar, but he hasn't picked up a new case. And he's just been trying to spend time with his daughters and his grandchildren.
Okay. What are we doing to address the substance abuse? Because simply saying time served doesn't seem to be putting any support in place.
Haven't got set up services yet, but I can, if you're on, we can try to go through PAD. I'm not sure. We haven't discussed, I know he was saying that there might have been an issue with the drug tests. I'm not sure. But
It's a lot of drug tests to have issues with, but
we can we add on to probation evaluation?
sure, that's what I'm going to propose. I'm going to ask each of the stakeholders here. Mr. Rogers, do you have a place to stay?
Well, yeah, I'm staying with my mom, but you know what I'm saying? Like, I'm still like searching for my own place.
Okay, but if you get out soon, you have a place to go, and that would be your mom's place.
Yes, sir.
Okay, and is that in Fulton County?
Yes, sir.
Does she know that you'd be staying with her?
Yes.
Okay, all right. Ms. Smith, your thoughts on this one?
Yes, Judge, the state will be asking to revoke the 30 days and to reinstate the balance. And I was also going to ask for there to be a drug and alcohol evaluation with treatment if necessary before the defendant to complete that within the first month of getting out. That way we can go ahead and treat, or there's treatment toward any substance abuse problem there may be.
Got it. All right. Ms. Simpson?
Yes, Judge, I am in agreement with, the recommendation. He also has a probation warrant from Mississippi. He got a new conviction there and was brought here on an ICOTS case. And so Mississippi points him back for violating the probation. In addition to also has a fugitive justice for Alabama. I'm not exactly sure what that one is for. So I'm in agreement with the 30 days only on the basis because I don't know if he's gonna leave here and go to Mississippi.
Got it. Alabama. Okay. So, Mr. Rogers, we've got the ability to close out the probation hold, but it is possible that once we do that, that either Mississippi or Alabama is going to come get you so you can deal with what's going on in those two jurisdictions. I just don't want you to be surprised by that.
Well, like, how can like, if they turned it over to the state of Georgia and they trying to say I violated because they didn't pay $55, and you told me that I wouldn't have to pay any supervision fees or court costs because of my disability. Last time you seen me, I was on crutches. I'm amputee below the knee on the right side. So, like, how can they pick up the case once they deliver it to Georgia? How can they say, well, okay, we want to violate it now? I mean, they went through ALCOT and whatever reason they turned this case fully over to Georgia. I paid whatever money I needed to pay for to be supervised on probation here in Georgia. So how can they just back and forth with me like that?
It's a good question. It's a question that Mississippi needs to answer. I am looking at your final disposition, and it does say probation fees waived. So that would be not a reason, it seems like, to have to go back to Mississippi because they say you haven't been paying your Georgia probation fees. Now, I don't know if they're Mississippi probation fees you're supposed to be paying. I don't control that. But there is an inconsistency here because one of the things you got written up for in your warrant is you're behind in payments, but you don't need to make payments because of your disability and what you're working through. I made it a condition of your probation. You got to do some community service. Stay away from this Salcedo guy. No using Lyft or Uber, but also you're not paying probation supervision fees. So
Case that, they were notified by our business team that we had not seen them, that is a basis for assistance.
got it. Okay, so it's not a money thing. It was absconding. When Georgia probation couldn't find you, they let Mississippi know, and Mississippi has said apparently that they want to talk to you about that. Now, I don't see a warrant in this system. It may well be that when you get to the time served, you're released. But Ms. Simpson is being helpful here by letting you know that there may be a warrant swirling around, and it could be that you get pulled over in a month and the officer says, oh, look at that, I just ran your name and I gotta lock you up because you gotta go to Mississippi.
Okay,
So-
that's I'm like kind of back and forth because once I was released, the probation officer signed me up for the American Disability Act, ADA.
Mhm.
So they were coming to me and seeing me at the residence. I was calling in once a month.
Good.
So, I mean, I'm kind of baffled. Like, do I come see you or do you come see me?
Well, don't be baffled. You will have the name and a phone number for your probation officer, and you need to get that real clear and maybe even want it in writing. Like, hey, you're saying that I don't need to come on in. I have that in writing that you're going to come see me because of the ADA consideration that you've got. This is not meant to be a trap or a trick, but it's certainly something where you need to be out ahead of it, saying, am I in the clear if I don't come down to the office? Okay? All right, I'm gonna do what I can here, which is, I'm gonna revoke 1 month of your probation and reinstate the balance. You've still got plenty to go. I'm adding as a special condition of your probation that you submit to a drug and alcohol abuse evaluation. You're gonna meet with a counselor or someone who's just gonna ask you about what you do and what you don't do, not to get you into any kind of trouble, but to figure out, hey, you need to go to NA meetings, or we need to do X to help you with the addiction. You had enough positives in there. I'm not at all worried that there's some problem with drug tests. Now, if you're taking medication because of a bone infection or this or that, you are going to want to let people know who are doing the drug test, hey, by the way, look, I take these pills, because that might make something spike up in your drug test that isn't an illegal substance, but it's a prescription substance. So make sure you communicate with both this person who's going to do your evaluation and if you have drug screens. You'll need to complete that drug and alcohol evaluation within the first month of your release. I don't know when you're getting out. If there are no holds from Mississippi or Alabama, then you're getting out this week. And then you got a month to line up that evaluation, but your probation officer will help you figure out how to do that. And you will also have, over the next 6 months, at least 3 random drug screens a month. So we can figure out what's going on and are you keeping things out of your system. Ms. Smith, anything else on behalf of the state?
Nothing further, thank you.
Ms. Rios, on behalf of Mr. Rogers? Okay. And you're going to be staying with your mom. And what does Mr. Rogers need to do, Ms. Simpson, in terms of reporting? He's going to, if there are no holds, he's going to get out soon.
Yes.
But then we have a big evidence because the officer was, when I there, he just wasn't there.
Okay.
So we're good, but I will meet with the Nicholas office.
Okay. Sounds good. Any questions, Mr. Rogers?
No question.
Good luck. Ms. Wood?
I need to go in the back, so.
All right. Ms. Rios? One of your many bond hearings?
Yeah. Be back there.
All right, Ms. Rivers, you ready? We're gonna go on the record in 26 SC 001-408, State versus Fields. Mr. Fields is here in court with Ms. Rios. Ms. Smith is representing the state. Good morning, Mr. Fields.
How you doing today?
All right, I'm Judge McBurney. Your case has been assigned to me. You are charged with aggravated assault. And we're gonna talk about bond. You have been in jail now for a little under 3 months, and you have a bond. Doesn't look like you have a bond on the felony. You had a bond on the criminal trespass, but that count was dismissed by the state. They only went forward on the felony. So Ms. Rios is going to talk to me about bond. She's already waived arraignment for you, so she's entered a plea of not guilty, and she'll get discovery soon in the case. We'll move it along that way, but she's going to talk to me about bond. I'll hear from the prosecutor and I'll let you know what I'm going to do. Okay?
Yes, sir.
All right. When you're ready.
Mr. Fields is 38 years old. He's been in the Atlanta area for about 4 to 5 years. He's originally from Chicago. He was working at Staff Zone as a day laborer. He has one child who's 15 years old. He was providing financial support to before he was arrested. He did obtain his GED. I don't believe he is on probation or parole at this time. I'm asking for a bond. He's been in custody since
March 2.
so a couple of 3 months, almost 2 months now, a little over 2 months without a bond. He cannot afford much of a bond right now since he hasn't been working. I'm asking for a bond at the $3,000 that maybe through the Bill Project, we can try to get him a bond, get him to pay, but that's the most he'd probably be able to do.
Okay. And where would Mr. Fields stay if he was able to post his bond?
I have an address that he provided. It's in Atlanta.
Okay.
Do you want me to?
I don't need you can get that to Ms. Nelson. Mr. Fields, what is at that address?
Female acquaintance that I've been staying with, who brought me to Georgia, that I've been dating.
What was the last part you said? Who brought you
Who brought me here? That I came here for a woman that I've been dating.
Oh, meaning you came from Chicago to be with this young lady. Got it. And she's got a place. Is it in Fulton County?
It's in Fulton County.
Okay. And she would let you stay with her?
Yes.
You're listed in the system as not living there. Had that been kind of on and off with her?
No, it's just I never really updated my ID. I still got a Chicago, Illinois driver's license and.
Okay. Let me look at one more thing. When you were arrested in this case, you told the booking people you didn't have a place to stay. You didn't give her info.
Yeah, because I be having staying in and out of hotels, but her address is valid. She said I could use it.
Well, it's two different things. You saying here is someone's address versus that's where you're staying. I mean, the point of me being comfortable with bond is if we know where to mail things to get them to you, and if we're needing to find you, that's the address, because that's how the court communicates. We don't email people saying you need to come to court. We'll put something in the.
No, I get mail that, sir. Yes, sir.
Okay. What's the last name of this young lady?
Smith.
Miss Smith. Does she work?
Yes.
What does she do?
She a stylist.
She what?
A stylist. She do hair at boutique.
A stylist. Got it. Okay. And did you know her in Illinois, or you met her when you came here?
Been knowing her since Chicago.
Okay. And she came down here with you?
Nah, she from here. She's born and raised, from Grady Hospital.
How'd you meet her?
Through a friend, acquaintance of mine back in 2020.
Okay. And did you meet her in Chicago, or you met her here?
I met her here.
Okay. All right. Your 15-year-old is where?
Chicago, Illinois.
Who besides Miss Smith do you have down here?
She's the only person.
Okay. All right. Different Miss Smith, Prosecutor Smith. Your thoughts about bond?
Yes, Judge. In this case, the state is going to be requesting that no bond be set for two reasons. To start off, the state does believe that the defendant, there is a risk to reoffend. In this case, the defendant has some multi-state offenses. In Illinois, there are a couple of offenses for armed robbery and also ag battery, with the most recent being in 2019, the defendant was convicted of robbery, sentenced to 6 years of confinement. It kind of leaves us at the 2024-2025 year. At that time, to my understanding, that is when the defendant came over to Georgia and was arrested and convicted of disorderly conduct in 2025. And also, well, I have that one, wait. Well, there's been one conviction since the defendant has been here in Georgia, to my understanding. This case was previously heard back in March of 2026, and the bond was denied for the reasons of risks to offend. Also, Your Honor, the state does believe that the defendant may be a danger to the community. And we say this based off the facts of the case. This was a stranger to stranger incident where the defendant did not know the alleged victim in this case. The state did not have a chance to talk to the victim. We've attempted contact, but we don't have a statement from the victim. But because the defendant has a risk to reoffend, and also because he may be a danger to the community based on the offense we have here, the state would be requesting that the bond be denied in this case.
Okay. Ms. Gordon.
Yes,
Good
Your Honor.
morning again. Can you share criminal history information on Mr. Fields, please?
Yes. The defendant has 48 arrest cycles beginning in 2003 with multi-state interaction. Last arrest November of 2024 by Marta Police Department from DeKalb County. Simple battery, which was amended to disorderly conduct. There's a 2019 felony conviction from the state of Illinois for robbery with 6 years probation. 3 prior felony convictions, also state of Illinois, outside the 10-year period. Nothing further.
Thank you. All right. Ms. Rios, anything you want to add?
I just want to give a little bit of context for the case. I know we're not going into the facts, but it was some back and forth. It's not like he went up and just punched a random person or alleged to have punched a random person. I believe him and the gentleman on the train had some back and forth. Even if Your Honor would consider maybe as a condition of bond, he have to stay away from those particular MARTA stations. The other charge in here in Georgia was a misdemeanor. So aside from that, he hasn't, since he's been released, just been going around town committing different crimes and things like that. So I believe he should get a bond in this case, with it being one, aggravated battery charge.
Okay, got it. Mr. Fields, I am for now going to leave you in no bond status. The 48 arrest cycles since '03 leaves me with the same concern that Judge Hughes had. Judge Hughes is the magistrate you were in front of not all that long ago, as Ms. Smith pointed out. It was just March of this year, so it's been a couple months. The good news is, and it's going to be a thin silver lining for you, but Ms. Rios is now moving your case forward. She's already filed a waiver of arraignment. She's entered a plea of not guilty for you. I'll get a scheduling order out, which will require the state to get discovery to Ms. Rios, and then she, meaning Ms. Rios, and you can start figuring out what's next with the case. Is there a motion that she wants to file? Is this something that's going to work out? Should go to trial? But I'll make sure that it keeps moving forward so that whatever the resolution is something we can do shortly. Thank you.
I'm not sure if we should take a break because Miss Wood needs to see some clients and they can't.
Oh, she can't be back there
Yeah.
if we've got someone.
So I don't want to. I mean, I can still. I don't know what we should do. More blind there. Well,
Right, you've got Battle and Gardner.
talk to.
Why don't you go back and talk with folks too?
Yeah, is Ms. Parker up?
Okay.
Yeah, like, he told me she's here, but it's not up.
And then do we know yet if our Cobb inmates have made it?
Yeah.
Okay. All right. Who are you here for?
Yeah, that means it's going to have court today.
She's in the building. She's just when people who are in custody come into the courthouse, they start out down in the basement and the sheriff's team has to take these elevators down and get them. Women are transported separately from men. And so the first big batch to come in were male defendants in the county jail. So Ms. Parler is here, but our deputies have been busy doing the stuff in court. And so I'm going to take a quick break so they can go down and get people and the lawyers can talk with their clients back there. But we are 100% going to meet with Ms. Parler today. All right? Anyone else waiting on something? Yes, ma'am, in the very back.
He's on the afternoon calendar.
He is on a 1 o'clock calendar, so we'll deal with his case at 1 o'clock. Ma'am?
I know his lawyer was running a little behind this.
Yeah, Mr. Melnick, he said he'd be here this morning, so we're hoping to handle that this morning. I can check with my team to see what their update is from Mr. Melnick. If for whatever reason Mr. Melnick can't be here till this afternoon, we'll certainly see your son this afternoon, but it's his first appearance on these charges in front of me, so we'll make sure it happens, assuming we get Mr. Melnick here.
We're just having to stay at the door.
Sure. This is?
13 is for this Williams.
Hey, Mr. Williams.
I'm gonna wait for today's clear, not guilty, but I've already asked Ms. Ross to get involved. And so I just want to let him see the judge and then we'll let him go downstairs.
Got it. So, Mr. Williams, I'm Judge McBurney. It's nice to meet you. Your case is assigned to me. Ms. Wood is your lawyer. She's going to file some paperwork that indicates right now you're pleading not guilty. That will trigger the prosecutor, that's Ms. Smith sitting over there, her obligation to get all the discovery to your lawyer. So police reports, if there's body cam video, whatever it is, we'll get to Ms. Wood so she can see how strong or weak the state's case is. She'll be talking with you. And more importantly, what I heard her say is that Ms. Ross, who's a colleague of hers, is going to come meet with you to talk about, are there programs or services that might be helpful for you if you got out? That's often something that your lawyer would say, Judge, instead of sending Mr. Williams to prison, let's get him connected with, I'm making this up, I don't know your situation, with drug treatment or mental health treatment or who knows what. And Ms. Ross is the very right person for you to talk to about what's going on in your life and where you've got challenges and where you don't. And then she and Ms. Wood will see if they can come up with some solutions. Okay? Any questions about any of that? So getting out depends on Ms. Wood talking with Ms. Smith to see how's your case going to resolve. Are you entering a plea? Is the state dismissing it? They don't dismiss lots of cases. If you're going to enter a plea, Ms. Wood needs to have something to recommend if it's not going to be go on to prison. And my guess is you don't want to go on to prison. So that's why you're going to talk with Ms. Ross so they can see if they can come up with a program for you, okay? And we'll get you back here soon to talk about what are those next steps. All right? Nice meeting you. Ms. Smith, did you have a nice Memorial Day holiday?
Kind of. It was raining the whole time.
It did rain a whole lot.
Put a damper on the day, but it was okay.
Yeah?
What about you?
Baseball tournament. So we were off to each day, Saturday, Sunday, Monday, baseball games. We managed to get them in before the rain. They were early, which was unpleasant, getting up 6:30 a.m. on Memorial Day to get to Georgia Highlands College for a baseball game. But we got the games in because the rain seemed to hit later in the day.
Good.
dry-ish. It was always misty. It was weird weather. It wasn't pouring down, but it's all good. Yes. And frankly, I'll take that over 95 degrees blazing sunlight. Because some of these baseball fields, there's no shade. I mean, the dugout, the kids get to go be in the dugout when they're not on the field, but the parents melting like crayons on the metal bleachers. All right, I'll step off the bench. You all can keep talking with folks. Should I just come out in a few minutes or you'll send someone back?
How long will it take to go bring her up, Miss Parler? So some people can go down right now.
That's correct, so we can either have some non-hearing.
Okay. How about this? I'll come back out in about 10 minutes and take everyone's pulse. Okay. Sure.
Position 11, hearing counter, Mr. Lewis.
Yes, Mr. Lewis, how are you? Good. I'm Judge McBurney. Nice to meet you.
Later today, and I'll get with Ms. Smith, so we can get this case rolling.
Got it. So, Mr. Lewis, I'm probably going to just be repeating things Ms. Wood told you, but your case is assigned to my division. Ms. Wood, by filing this waiver of arraignment, is going to prompt Ms. Smith, the prosecutor seated over there, to get all the discovery to Ms. Wood. Police reports, witness statements, whatever's out there, surveillance footage. Ms. Wood can take a look at that and then meet with you to say, man, you're cooked. It's all on video, or look, this has got the wrong guy. I mean, you guys will start developing your theory of the case. If it's a strong state case, you guys may want to figure out how to work it out. If it's a very weak state case, let's go to trial. But those are decisions for you and Ms. Wood to make after you have private conversations. So she'll be with you soon, not meaning today, but in the near future, to talk about resolution after she's had a chance to look at the discovery. I'll see you again, either because someone's worked the case out or Ms. Wood has looked at that discovery and decided, wait a minute, they searched your pockets and they weren't supposed to be searching your pockets. So she'll file a motion to suppress, something like that. We'll have a hearing, people will come testify. Anything we're doing with your case, you'll be here for that, okay? All right, so I will see you soon. Anything else, Ms. Wood? Ms. Smith? All right. So I think DeAnthony Owens ended up being a bench warrant. He's back. Yeah. So why don't you stick around? They're going to go down to the basement and bring people up. They'll see if your guy is here. If he is, they'll bring him up. If he's not, we'll do it this afternoon. All right. I'll be back.
Sounds good.
Yeah. Before we all go, you are?
I got summons to court today, and they keep sending me to this courtroom.
All right. Do you have a case number? So how do you know you got brought to court?
I was in contact with the public defender. I went to Zoom court last time, and they told me today. So I've been to like 3 different courtrooms, and the lady, the info desk downstairs, they're sending me back to this.
All right. Give me 1 second. So Washington standard spelling. What, how do you spell your first name? All right. Date of birth? Let's see if we can find you. Eric Washington. Yep, you are all over the place. Michael's your middle name? Okay, you're a popular guy. Here's a case of yours. Yep. Let's see. hold on one second. Ma'am, Mr. Melnick is supposed to be here at 11:30. So we'll definitely see your son before the lunch break. Mr. Washington, yes, your case had been in non-complex and it got transferred here about a month ago because of your background. And let me see who signed this. Okay. So I'm gonna have you take a seat. Ms. Wood, who is one of the two defense attorneys here, are you Ms. Rios 5 through 9 or are you 6 through 0? Okay, so Ms. Wood, who's talking to someone right now, is gonna be your lawyer. She can talk to you about your case. I don't have anything listed here that you needed to be here today, but your case is assigned here. So you should definitely connect with Ms. Wood. So sit tight, and when she comes out, she's the one with the red hair. Make sure the two of you talk. I'm gonna write down your case number as well.
Are we talking about the trial calendar this afternoon?
Yes, we are. Ms. Wood,
Yes.
can you come here for a sec,
Yes.
please? Mr. Washington, who's wearing the Tupac shirt back there, his case was recently transferred to us about a month ago from non-complex. His case number is right there. It ends in 0, so it'll be your case. Ms. Safarazi had it in non-complex. It's not on a calendar today. For some reason, Mr. Washington thought he was supposed to be in court today. And so when he goes to wherever they go, they keep saying it's a McBurney case and it's not on any calendar here. I just wanted you two to connect, to exchange information, and then you're good to go. You're not, after you get Ms. Wood's contact information, she gets yours so she can let you know what's going on in the future. You should scoot. Okay? All right, I'm gonna step away. We'll see if we can bring up Ms. Parlor and we'll see if you guys here.
Judge, it's not here. I'll just log on this afternoon.
Yep.
Any particular time?
We're supposed to start back up at 1. So 2 would work. I'm going.
I just need to put people in.
Yeah.
Yeah.
Oh, sorry, ma'am. Please, tomorrow grant for browsing and Nicholas. We just need to talk as we can talk. Those two are negotiating. And then we're gonna talk about Barbara Lavard's Barbara going break. And we're gonna reset, right?
You say Reeves and Jamar.
Yeah, those are still negotiated.
Okay.
All right, we're gonna go there and get baby Bell, Hughes, and Johnson.
Where did they go?
Oh, that's the name, because they're gonna have to come back. The issue of just transport our Cobb and our females.
Yeah.
Sometimes Cobb comes on time, the females, we can almost guarantee to come. So we do our best. I know. Ready?
And the reason why I do that is because I realize you can't have that. Certain not.
Yeah.
So I want to make sure everybody's here. We'll go ahead and bring them up so I can go. And yeah, it's kind of like face. But I'm not gonna sit here. It's just not. The transport.
Basically, what did you do with Jesse?
I was gonna do a waiver. I probably gonna do like a BHTC referral.
I was asking, I missed it.
Yes. Bless you. Okay, yeah, there's two on the calendar. I kept getting confused.
I wanna make sure I wrote it under the right Williams, cause I just. Willie Williams was the one that revoked 2 months.
Yes.
Okay, and then the other Williams was,
Jesse on the.
Jesse, so,
Ms. Nelson,
yes,
I don't really, I'm gonna just, I told Judge I'd log on at 2 o'clock.
okay,
You send me the link,
I believe I did, but I'll send it to you to make sure.
1 o'clock link.
Should be the same one this morning.
It is. It's not,
Oh,
saying, there's a one.
oh,
Right.
I didn't get it.
I'll have to look.
You wanna send it?
So I'm gonna just file a waiver today.
Okay,
I'm
and
about to-
possible BHTC?
Yes.
Okay.
And
Didn't think.
waiver on this person too.
Okay.
Lewis.
Okay.
Oh, before you leave, let me bother you.
You're never allowed.
There is a court date that's showing up in Odyssey for like the 16th of June. Do you think that one will stick?
Oh.
Okay. I'm just making sure.
I sent Rios that we have court every day that.
Oh wait, that's a trial calendar call. Okay,
And it was switched. There's gonna be a lot of switching
okay.
because that was normally.
I'll see you at 2 o'clock, or you have my cell number in case you need me earlier? Okay, just text me and be like, come on.
Okay,
And I'll step out.
okay.
Okay.
Will do.
Thank you as always.
You're welcome.
Okay. Oh, that's a calendar call.
Yeah, because originally it was like
That's what
2 days later.
Yes.
It was on a Thursday, but I switched the P&A in the Thursday because we're gonna have not problems. We're gonna have challenges with the World Cup.
Yes.
So I switched, since we'll probably be able to get here on the 17th, but we will not be able to get here on the whichever is vice versa.
Okay. Oops. Okay, so this will probably have court on this day too, the Wednesday?
The Wednesday, yes, but that's gonna be a jail Zoom.
Oh, okay, cool.
And then the Thursday, that's gonna be a calendar as well, but my hopes are if we can't travel, that most of those people are on bond.
Okay.
And we'll just have to reach out to them and give them the Zoom.
Okay. There's 2 people on, you said that's a jail Zoom though? Okay, I think I have 2 people that I saw on there that are gonna be pleased, but they're both in custody, so that.
Well, we can do that, yeah. I mean, that's fine.
Okay.
So then so now what I'm doing is I'll be preparing the calendar for July that is actually Ellerby's,
Okay.
which I really think is August, but so there, her calendars, any of the calendars in July, I'm doing if they have to be published before the 1st.
Got it. Okay.
So
That's good to know.
yeah. So I'm trying to get as much of our stuff in. That's why it's packed.
Okay.
We're already having by the time switch.
Um,
Sounds like it.
I'm
The-
asking.
yeah, I'm doing the trial calendar that is in, I think they might have had I'm doing the calendars that are in July, the first 2 to 3 weeks. I'm doing those, but anything after that, she's going to do. And so I don't think, I don't think that she's going to have the trial calendar till August in her court. So I don't think you guys are going to have a trial in July, but that's what I see, but that's what I see, but
It sounds great on the front end. Is that a good thing on the back end? I'm like,
Yeah, we
Yes.
talk enough and resolve a whole lot in this courtroom. I think we can go a month.
in this part.
Well, okay, I don't care about no one else's courtroom, but this courtroom will be fine.
you'll resolve a lot, but then I think things will change a little bit about.
We will
like
resolve
helping-
less.
I think traditionally her track goes a little bit faster because and when I say faster, I mean, her history is she's had the lowest criminal case count.
Yeah, Ms. Gilbert said the same.
So we'll be going faster than this courtroom. How is that even possible?
I think because she combines one of her final plea and trial calendars.
So we final plea, and then if they don't plea a final plea, then we go to trial. There's no like a month between.
Oh, no, I think they're combined. Like I think she has
Very long.
final
That makes a
plea,
very long.
but there is not gonna
So
be.
aside from the, 6 and 7 pages we normally have, look at like maybe 10 to 12.
There's not gonna, but there's not gonna be a lot of continuance.
I mean, but McBurney doesn't really grant that many either. Well, I guess well, not really.
But traditionally, they're faster.
Well,
So.
maybe I don't know. Maybe
But I don't know
slow
if that's
down.
a bad thing. It's just a different patient.
Yeah,
You
different.
probably
Different.
just won't have as many calendars.
Well, less court might be better.
I don't know if that's gonna be.
But not a lot less.
Because what that does, that.
Oh, she's there
They
today.
have to be put in somebody else's court on days we don't have a partner.
But I don't know if that's gonna happen. I don't know. I don't know how many days.
Do you have anybody else?
So I think both of my other guys, well, you don't have any applicant up yet, right? Do you have I think my guys might be in Cobb. You don't have Rogers. Okay, so Rogers and then I forgot who the other person was.
Oh, wait, boy.
Wait, is Rogers my only one? Oh, he's got a private attorney, right? Jonathan
Yeah, that's
Melnick?
Melnick.
He's Melnick.
He's coming in about 10 minutes.
I think, I thought I had another one, so hold on.
Cody.
No, he's got a private attorney. Maybe it is just Rogers. Speaking of Rogers, who was office for today?
What calendar? I'm sorry.
Oh, you're fine. It's position 7 on the computer.
So I gotta make some different contact.
Okay.
I called, and it's the right number. I got voicemail, but
A valet or something.
yeah.
Like
yeah.
not, it's like a stranger to him.
Yes, and it was a like, you took my money type of.
Yes,
thing.
yes.
I looked at this case. I know there was a motion for bond reduction.
Yeah.
Now, the reason why I can't resolve it is because I didn't talk to him, but I do think it's something that's resolved.
Okay.
But once I talk to him, or after I made him to talk to him,
Okay.
we can figure that one out. With the bond reduction, I wasn't, of course, I was gonna ask for more, but I was trying to remain at the 6,000.
Yeah. No, I think, yeah, I would rather resolve it than have the bond, so. What if, do you think you might be able to talk to the victim before Thursday?
I will
Possibly.
try.
Okay.
I'll keep calling them back and then
Okay.
we can try to get it. Are you trying to get him back over here
Yes.
this week? What's on
Yes.
Thursday? Trial calendar.
We've got like a little, there's like not much left on it.
Oh, the trial calendar and an inquiry calendar.
Oh, God.
Yeah, but I don't think they're yours.
Okay.
But
So I don't think I have anything with you on this trial calendar.
I don't know. I don't want to speak. Probably. That's probably right.
Yeah, because I have 3 people left and one of them's a major case.
There are a lot of different divisions.
Yeah,
of the
it's-
28th
yeah.
trial.
That's how it works. I got you. I was wondering. Yep. Okay, Miss Wood, did I help you straight? Did you get me straight?
Yes, thank you.
Rainy, what are you doing out there?
Oh, probation.
Okay, that's it.
Him and Smith, I'm ready to go on.
Yeah. Was Euphemia coming back on Kimball, or that was done?
That was done. I'm just going to send her discovery.
That's it?
Maybe just like an update type of thing.
Okay. Oh, yeah, this is the other book one.
Yes. Yeah, I told her that she would be staying with you to answer her box. Yeah, she's like, she's happy about it. Thank you. Okay.
Oh, okay.
I know. Leonard said he's gonna be here 11:30. Who?
No.
Is there anybody else that you guys are waiting on Friday?
Resolve from your trial calendar.
So I only have 3 things left. The state food is missing. One of their.
His attorney called in and said,
And then
am I supposed to be?
my 3rd person
Says yes.
fires me. So. I don't really like. Tell the judge that.
Yeah.
That's
Then he's gonna email me back.
Okay, well.
Because he's supposed to let me know what he's trying to do.
I don't think I should have anything because Adam was saying he doesn't think the murder is gonna go because of the codependents. And then,
Oh, that's.
what we know about my woman client with the text messages.
Oh, yeah.
What is?
Yeah.
Wow.
I unblocked her today though to see if she's gonna try to.
I
Actually, it was like every 5 seconds. I was like, call me my office number.
And I
right
think
now,
Ms.
ridiculous.
Smith just said they're through with him.
It's just way too
Yeah.
much.
Yeah.
Said she didn't job,
Downside of giving out my Google Voice number, but.
Did she talk to Kimball?
I don't think so.
Let me text her right quick. Cause Ms. Sim said just updated on Discovery, that was it, she thinks I can let him go. Let me text you, give you her. Make sure.
Lacey, if you don't mind emailing me, like either later today or tomorrow about contacting the victim for.
Yes,
Okay.
I will do that.
Oh yeah, what are we gonna do about Deja?
Child.
Whenever we get the results, what are we gonna do about her?
I don't know. She don't want to just do no. I just wanted to take a evaluation.
If she gets it, okay, so if she's getting evaluated, will you dismiss after she gets it, or like, and we get some, if
She don't want to plead to a misdemeanor battery.
she's not pleading anything, she's not pleading anything.
Mm.
And honestly, I don't even know if I'm her attorney because she's fired me, but then talk.
I know that her granddad has recanted his statement.
Yeah,
He's
he's very upset that y'all do contact.
I haven't talked to him since the last time, so you talked to him after me. So
Yeah,
he
I
probably
talked to
mad.
him and he just like, I've been a police officer for 20 years. I never known an officer.
So he understands about like,
Huh?
so he understands about like changing his statements and stuff.
Well, he's just like, I've never had a case go forward if the victim doesn't want to go forward. So he's like,
That's the thing. I mean, I know it's a common perception that if the victim doesn't want to participate anymore, then we like dismiss the case, but.
Y'all can go for it. Like,
Yes,
that's
he gave
what's
us
crazy.
and I don't want to do granddad like that, which is why I'm saying I dismissed the felonies, plead to the misdemeanor. You don't even want to do that. And we went down to 6 months. I didn't.
yeah, I know.
Why don't you put it on non-negotiable there?
She's a dismissal.
Uh,
She came her office 6 months now.
When is the evaluation you're talking about going to be completed?
I
After
still-
trial calendar?
I think the judge order up from house when we call the trial calendar.
Okay. Definitely don't want to put it up as trial because I don't want granddad to have to get up there and have to admit that Nate's telling another story. I just want her to get the treatment. And just because you're doing the treatment, don't come with an automatic dismissal. Like I'm giving you this.
I'm not sure she understands anything, so.
Are the deputies bringing people up or?
So we could,
they were switching out for the cop people,
Oh.
but I don't know.
Okay,
talk to Ms. Parlor, and I wanted to do her because she has,
she does? Yep, so we could do that. We just need a deputy.
Hey, don't forget.
Oh my God, is it today?
it's usually at 4.
It is at 4? It's not secret?
I just didn't have my calendar, so I didn't know what time.
I don't think that it was sent out.
It wasn't, I was just like.
Why?
Did Ms. Nelson not let people know?
Have her come out.
I'm gonna check my mail to confirm.
I mean, I'm serious.
We could do it tomorrow if that's better. No? Okay.
It's better.
It's fine.
All right,
Bro.
we gotta figure out what we're gonna try.
Everything was on there.
You won't be here. Yeah, that's what you'll be trying is nothing. Good, resolutions are great.
I think I'll be trying anything. Maybe a private attorney. Where are you going? Is that near Destin? Go to the alligator. Alligators. It's called. Got a kick out of that.
There.
I'm sorry.
That's okay. Do we have Ms. Parlor up?
Yes, we do.
Can we do that now? What are we, before she comes out, this is, we're just having a conversation about, oh, that didn't make the list of your long list of bond. That's on there too? Yeah, this is like you not knowing that at 4 o'clock today, we had a meeting. So whatever, it's just selective recollection, like, nope, you said you were dismissing the charges. So we're gonna talk about bond.
Yes, sir.
Okay. All right. If you all are ready, Ms. Parler would be great. Thanks. Good morning, Ms. Parler. If you'll come on up to the podium, please. Ms. Rivers, you ready? All right, this is position 12 on our plea and arraignment calendar, 26 SC 001-498. It's State versus Parler. Ms. Parler is here with Ms. Rios, and Ms. Smith, are you handling this for the state?
Yes.
Okay, Ms. Smith is handling things for the prosecution. Ms. Parler, I'm Judge McBurney. It's nice to meet you.
Nice to meet you.
Your case is in my division, and we're going to talk about two things today. We're going to talk about bond in just a minute. Ms. Rios is going to tell me why you should get a bond or a lower bond, whatever the situation is, and then I'll hear from the prosecution. But I also want to talk to you about what's happening with the case. So you were indicted at the end of March, and now the case has been assigned here. Ms. Rios will be representing you. She's filed a waiver of arraignment, which was basically entering a plea of not guilty on your behalf. That will mean that I'll do a scheduling order, and that scheduling order is going to have a deadline for the prosecution to get discovery to your lawyer. Discovery is whatever evidence the state thinks they have. So pictures, interviews, whatever their case is, they'll give it to Ms. Rios so that she can look it over and share it with you so that the two of you can figure out, what does the state really have? Is this serious? Is it bad news for us? Is it good news? How do we want to start negotiating, if there are going to be negotiations? So that's what's going to happen later this week, next week, as things flow along. Right now, we're just going to talk about bond, okay? Ms. Rios?
Ms. Parler is 59 years old. She has 3 children, 2 boys and a girl. They're grown, but her 2 sons, one has autism and one has impaired hearing and cannot walk. She took care of her 2 sons, but since she's in custody, her daughter has been taking care of her 2 sons, so she needs to be out to continue care of her.
How old is Ms. Parler's daughter?
In her 30s, right?
30s, yeah.
They're all in her 30s.
Okay.
And
So all of the children are adult children. Some have disabilities like you described, but they're all, no one's a 4-year-old.
correct. Right.
Okay.
So her daughter has, and her concern is her daughter has her own children to take care of and was not expecting to be taking care of her brothers who have disabilities. She does, my understanding, she doesn't have any criminal history. She has had a home, but she lost it since she's been in custody. But
Is that the Lovejoy Street address?
Yes,
yes.
Yeah, okay, so that was your house?
yes.
Okay, but it was a rental?
No, yes, I was renting.
Okay, so when you say it's lost, can you not go back there, or your things were removed, or what's your
I
understanding?
had put in a notice to vacate, so I probably had moved out.
Okay,
She does have a place to stay. Miss Smart from her church has given me her address and said that she can come stay with her. And then the members of the church are going to be working on getting her a permanent place. But for now, I can do a change of address and her mail can come to Miss Smith's home. So I'm asking for a bond in light that she's not a flight risk because she's been here for 26 years.
her children are here. She's a member of the church here with really good people who want to help her. So she has very strong community ties. I'm asking for a bond no more than $3,000.
Did you say 3 or 38?
Three.
3. Okay. Haley Coney is who to Miss Parler? Granddaughter. The daughter of her daughter?
Yes.
So Ms. Parler's sons are with Ms. Parler's daughter, which means Ms. Parler's sons are with Kaylee Coney right now as well. I mean, that's all one
Yes.
crowded household.
Yes, Your Honor.
Okay. Got it. Okay. I think I understand that. This seems like a good case, Ms. Smith, for your office to have had contact with Ms. Parler's daughter, the mother of Kaylee Coney. And I know you are filling in for someone who is filling in for someone. And so I want to make sure your office has had enough time to have that conversation. I'll be pretty heavily guided by what Ms. Parler's daughter thinks about her daughter, so the granddaughter, Miss Kaylee Coney. I may be saying it, it's spelled two different ways in the indictment. Is it Kaylee or Kaisley?
It's Kaisley.
Kaisley, it's spelled two different ways. Kaisley's safety, if you know what I'm saying. So if Miss Parler's daughter, an adult, is saying, hey, as long as my mom stays away, she can be out on bond. Besides, I want my brothers out of the household. That's very different than we don't know because people haven't had contact.
Yes, Judge. So that's kind of complicated. One, we have not had contact with either the mom or the daughter. The mom in this case is alleged in the facts to also have participated in the actions that happened with the daughter. So the state does not believe reaching out to the mom would be the best case because she's also in the police report as being a person who participated.
Okay, not indicted, but listed in the report.
That's correct.
Okay.
From the notes and from what I know about the case, we have not made contact with another guardian of the child. However, we haven't reached out to the mom in this case. So we don't have a statement from the victim.
Got it.
But regarding the status of bond, we do understand that the defendant has a lack of criminal history. However, we do believe based on when her bond was denied first in March of this year, that the defendant may be a danger to the people in the community, AKA her granddaughter, based on the facts and circumstances of this case. The state also believes that the defendant in this case may be able to intimidate the victim in this case. And we base that off of not going into the case, but there was a forensic interview where the victim told the person who was interviewing her that she did not want to talk about it because her grandma told her not to say anything. So the state does believe that if the defendant is able to get out, and even if there is a no contact order in place, that because of the relationship between the victim and the defendant in this case, that the defendant may be able to influence or intimidate the witness. And based on the facts and circumstances of this case, we don't want it to be another offense that is similar to the one that's already happened in this case. So because of that, the state is asking for no bond.
Okay. Give me 1 second. Okay, Ms. Gordon, do you have any criminal history information on Ms. Parler?
Your Honor, the defendant has no criminal record on file.
Thank you. Ms. Rios, would the plan be for Ms. Parler's two sons to move back in with Ms. Parler at the friend's house?
What, so not for now, my understanding is that she's going to stay with a friend until the members of the church are able to get her own place.
Mhm.
And when she gets her own place, then her boys to come stay with her. But they're already in the mix when I talked to Miss Smart about working on getting that for her.
Okay. Ms. Parler, have you worked in the last few years?
Yes, I recently was working until I got incarcerated, sir.
And what kind of work were you doing?
I was a leasing consultant.
Tell me what that means you did.
I was leasing apartments.
Okay, so like you would work at an apartment complex and you'd show people the apartments and whatnot?
Yes, sir.
Okay, how long had you done that?
I was doing about a year at this location, but I've been doing it for over 30 years.
Okay, that's your background.
Yes, sir.
Your daughter, does she work?
She was working at a base doing housekeeping.
Okay, a base like a military base?
Yes, sir.
And did you and she both live on at that Lovejoy address?
I let her come stay with me because she needed a place to stay. The
Okay,
kids, so I let them come stay with me. I didn't supposed to have them there, but
okay,
I wanted them to have a place to go.
sure. And how many kids does your daughter have?
She has 6.
6 kids.
Yes, sir.
So Kaisley is one of her 6 kids.
Yeah, she's the second oldest.
All right. Do you know where your daughter is staying with her kids now?
Yeah, she's in Columbus, Georgia right now.
Okay, with friends or family?
She has her own place.
How did she get that?
She was going through a housing authority. To get a
Okay.
house. Yes, sir.
And all her kids are with her down there?
Yes, sir.
Is there a father figure active in any of the kids' lives to help your daughter out financially or anything?
No, sir. I was helping her.
Okay. So then where are your sons right now?
They're with her.
They're with her in Columbus?
Yes, sir.
Okay. And your 2 sons, are they able to take care of themselves some, not at all? Or how does your daughter go to work if
Well, my oldest son, my youngest son, he can move around and he's able to do some things around the house.
okay. I
And-
mean, he can use the restroom if he needs to use the restroom. He could pour a bowl of cereal.
Yes, sir.
Okay. And your other son?
And my other son, he has to help.
Okay. And can one son help the other son?
Yes. Yes, sir.
But they still need another adult around.
Yes, sir.
And right now that's your daughter.
Yes, yes, sir.
Okay. All right. Well, Ms. Parler, I am going to set a bond in your case. You're going to need to have no contact with your daughter and her kids while you're out on bond. You can't, as much as she may be important in your life and you want to be around your grandkids, until this case is resolved, it's important that you aren't with them. Do you have brothers or sisters?
My sister is in Florida, Jacksonville, Florida.
Okay. Does she communicate with your kids at all?
Yes, sir.
Okay. So if you need to provide financial support to your daughter or your grandkids, it would need to go through your sister. But just based on what I read about what the allegations are in your case, and they're only allegations, you're presumed innocent, but you and Kaisley need to be far apart. Might be that your daughter and Kaisley need to be apart as well, but that's not in front of me right now. I just need to know that between now and however this case is resolved, you aren't trying to influence them as they go forward the way they're going to go forward. Okay? So I will set a $15,000 bond. It will be through the sheriff's 10% program, which means that whoever posts the money, and they don't have to post 15,000, they post a fraction of that, they'll be able to get the money back when the case is resolved. However it's resolved, the state dismisses, you plead guilty, people will be able to get the money back. You'll be on pretrial supervision, but only level 1, that's the lowest level. You'll start out, you'll be required to reside with, is it Smart? Is that the last name? With Ms. Smart. And Ms. Rios is going to send that address to someone on my staff. That's where you have to stay. You cannot move out of that place until they find you one, but then you're going to need to let pretrial services know the new address, and they need to check it out. And it needs to not be in Columbus. You can't be, that's where your daughter is. Now, your 2 boys can come stay with you, whether Ms. Smart says, hey, they can stay with us, or you get your own place. They can stay with you, but your daughter and her kids you need to stay away from them, okay? So you'll be required to live with Ms. Smart till you find your own place. Pretrial Services needs to approve the new location. You may have no contact, direct or indirect. I need to say that correctly. You may have no contact at all with Kaisley. Don't get her on FaceTime or anything like that. You can communicate with your daughter through your sister. All right, and I'm going to need the sister's name in the bond. So if there's something you need to, hey, I want to make sure you're doing okay, or do you need any money or anything, your sister can reach out to your daughter to say, how are things going? Do you need anything from your mom? And then your sister can get back to you and, hey, she needs some diapers. And if you're able to help out, that's great. But you need to, until we resolve this case, or Ms. Rios can always get back in here and say, Judge, I want you to modify the bond. It turns out that one of Ms. Parler's grandsons is real sick, and he needs to be able to stay with Ms. Parler. Maybe that's going to be okay, but we have to have a conversation about that first. Kaisley needs to not see you or hear you in any way, and your daughter only hears about you through your sister until we modify the bond or you resolve the case. All right? Is that clear?
Yes, sir.
Other conditions, Ms. Smith, that addresses the no contact. And okay.
No, L-Y-A-E-N-N. That's it. Oh, okay.
So Ms. Rios, you'll get the address of Ms. Smart's place,
Yes,
and you'll get the name of Ms. Parler's sister.
yes, you're gonna have both of those.
Okay. And again, Ms. Parler, if something needs to change, like you get a different address, or there's a situation such that you think it's important that you see one of your grandkids who's not Kaisley, let Ms. Rios know and we can have a conversation about it. But until we do, it's a real bright line that you stay out of that situation. Okay? Any questions?
No, sir.
All right. Ms. Rios, anything else?
No.
All right. Ms. Parler, what's the church you go to?
It's Grace and Truth Ministries,
Okay, and that's how you know Ms. Smart?
sir.
Let me see your church names, Katie.
Ms. Wood, you got something?
Yes. Position 3 on Commissioner Commission, Ruben Rainey.
Mr. Rainey, okay.
Mr. Rainey.
Yes, please.
Mr. Rainey.
Thank you. You still wearing?
Yes.
All right. Let's get on the record in 23 SC 188930, State versus Ruben Rainey. Hello, Mr. Rainey.
How you doing, sir?
All right, how you doing?
So.
So. All right, Mr. Rainey. Well, you are here to talk about a probation warrant that I signed back in July of last year. You're here with Ms. Wood representing you. Ms. Smith is here for the state. And the warrant, Mr. Rainey, basically says you disappeared on probation. You were supposed to report on a couple dates, did not. Probation tried to call you. You didn't respond to phone calls and text messages. You've also only done a teeny bit of the community service you were supposed to do. Not a good thing, but the disappearing part is the bigger deal. Ms. Wood, is Mr. Rainey admitting to the allegations?
He is, Judge.
All right. Ms. Simpson, how much time remains for Mr. Rainey? All right. So tell me, Ms. Wood, what's going on with Mr. Rainey and what you think ought to happen?
Yes, Judge. So Mr. Rainey is 60 years old. He does have a good, stable address on file with probation. That's where he still lives.
Is that the Wilson Mill Road?
Yes.
Yes, Judge.
Okay.
He does have some health issues. He's working on getting disability lined up. He's been in custody here 27 days. We're asking the court to consider revoking 30 days and reinstating. He had indicated to me that at the time, last summer when this all went down, that the probation officer that was assigned to him, he was having trouble every time he went to 276 Memorial Drive, that the probation officer was not there, wasn't answering his calls. I think the protocol has changed since last summer, and that even if he shows up to the probation office, someone will notate it.
Good.
But that was part of his issue last summer. And so, yeah, he's eager to have another chance at probation.
Okay. How long had you been on probation, Mr. Rainey?
Ever since you gave it to me, sir.
Well, I just don't remember when that was.
I can't remember.
Well, I can look it up. I was just curious if, it looks like in February of 24. Okay. So you made it for a year-ish, although, oops, there was a revocation order in March of 25. Let's see what that was for.
Vehicle.
You what?
Got hit by the vehicle.
You got hit by a car? We don't tend to revoke people because they get hit by a car. Looks like, oh, and that's why you hadn't reported because you were out of commission. How are you doing? You better?
No, sir. No,
You're
sir.
not better?
No, sir.
Okay. Are you worse?
Well, you're getting worse, sir.
Okay. What kind of injuries did you get from the accident?
I got steroids my whole left side.
Okay. All right. So 30 days, reinstate, and hopefully better communications with the officer.
Yes.
All right. Ms. Simpson, what is DCS's view?
Mr. Rainey left the state and was picked up on a warrant in Indiana. So my recommendation to state into Ms. Wood was to revoke 4 months and reinstate balance.
Okay. Mr. Rainey, I had forgotten that since the time of the warrant, which was a while ago, like I mentioned, that was July of last year, when we finally caught up with you, it was not at Wilson Mill Road in Atlanta, wasn't even in Fulton County, wasn't even in Georgia. You had really gotten out of town. Tell me what's going on in Indiana.
Well, my auntie had died. I mean, my dad had to go up there. I tried to call my probation officer and let him know. Well, it kept going to a voicemail. So I couldn't leave no text or nothing on his voicemail. So we went up there to my dad to get the body moved back to Georgia. And police stopped us, asked, I showed my Georgia ID, my social security, warrant popped up, sir. On the way back to Georgia.
Okay, and when this was then what led you to being here?
Yes, sir.
So what the system shows me is that you've been in the county jail since April 30th, so 27 days. Were you stuck in Indiana for a while before you got here?
Yes, sir.
For how long?
Almost 3 weeks.
Okay, so you were arrested in April, but it was early April in Indiana.
Yes, sir.
All right. I'm sorry about your family's loss. So you were pulled over and there was a dead body in your car?
No, we went up there to have a body transferred back to Georgia.
You just went up there to arrange it,
Yeah.
but you didn't have a pickup truck with your aunt
No.
in the back of the pickup truck?
No, me and my
Okay.
dad drove his car
Why did you have to go to Indiana to do that?
with my dad. Well, my dad 80-something years old. I
Okay,
need somebody to ride with him.
got it. Does he have other kids?
Well, they was out of town at the time.
Okay.
I'm the one to stay with him.
Oh, he is at that address we've been talking about, the
Sir.
Wilson Mill?
Yes, sir.
Okay, all right. Ms. Smith?
Yes, Judge, in this case, the state is going to follow the probation's recommendation. We're following the recommendation because this is the defendant's second revocation second revocation for failure to report. And also because the defendant is aware that, like you said, he needs to let the probation officer know if he's going to go out of state. And make sure that they know that even if it's going to voicemail, whatever the case may be. So because of that, we're going to follow the probation's recommendation.
Okay. All right. So, Mr. Rainey, there always seems to be a pretty good story that you've got. Last time when we couldn't find you, you had been in this bad accident. This time you're helping your dad do something that's pretty important, which is arrange the movement of remains so that, I assume this is so your aunt could be buried in a family cemetery or at least closer to family. But you gotta get the green light before you do something like leave the state.
I tried.
Well, I heard you. Did you go down to probation and go to?
I had no ride at the time down there.
Okay, but you had a ride all the way to Indiana.
My dad, yeah.
Yeah, you didn't have a ride to probation. So I'm gonna split the difference. I'm gonna revoke 2 months. I am only giving you credit from the day you got booked in. So you're getting credit from April 30th of this year. So you're gonna do another month. And then I'll reinstate the balance. Is it correct, Ms. Simpson, that now if Mr. Rainey is having trouble connecting with his officer, if he just goes to Memorial Drive and says, here I am, there'll be something put in the system saying he is not AWOL, he is not missing, he's not hiding, he showed up and Officer so-and-so needs to figure out a way to connect with Mr. Rainey. All right. So if what you're saying is accurate, this should never happen again. Because if you try to text and it doesn't work, you try to call and it goes to voicemail, you go to Memorial Drive. And as long as you're going between, what is it, 8 to 4? What are the hours?
I know.
8 to 4:30.
I know 2 days I came, and the day I supposed to report it was the first day of the month. He wasn't there.
I hear you. But that's changed. If he's.
I came back 2 more days.
Hmm?
Sat there from 8 in the morning to 4 in the afternoon.
That's no good. So that's not how it should work. What will happen now is if you show up there, they'll make a note that Mr. Rainey reported, and you don't have to wait around for someone. Someone else will come interact with you, or at a minimum, they'll check the magic box.
And then I try to make my doctor appointment at the same time.
Okay.
Well, I go and see the doctor like
Good.
3 times out of a week.
Smart. That's efficient. You knock one, like, hey,
I couldn't do it.
because you were stuck waiting at the probation office.
Right.
Well, hopefully it works differently now, okay?
I hope so.
Yeah, me too. All right. That's the plan. How's your dad doing?
he doing all right.
Good. Keep taking care of him. So we're gonna keep this Wilson Mill Road address? That's a good place for you?
Permanent address.
Permanent address. All right. Excellent. That's it. Thank you.
Judge. Mr. Rainey. Have a good one. Can we do James Smith next? If we have time.
Yeah, we can do one more.
You said. Oh, James Smith.
All right. Let's get on the record with Mr. Smith. It's 25 SC 003292. Good. It's now afternoon. Good afternoon, Mr. Smith.
Good afternoon, Your Honor.
You are here with Ms. Wood on your behalf. Ms. Smith, different Smith, is representing the state. And Mr. Smith, we are talking because in April of this year, I signed a warrant, probation warrant that alleges that you, in March of this year, got arrested in Coweta County for driving with a suspended license, and maybe having some drugs on you and a drug-related object. I don't know much about the case. I bet Ms. Wood knows a bit more about it, but we're going to figure out today what the probation consequences are for that Coweta arrest. Ms. Wood, is Mr. Smith stipulating to the arrest, or has that already been resolved, or where is he?
He's stipulating to the arrest only, Judge. It sounds like it's still unindicted. He is on bond for it. We are asking the court to revoke 45 days and reinstate. I don't know a ton about the case. It sounds like there's possible motions issues. So yes, he has a good address on file with probation. I think the only other thing he needs to enroll in the family violence intervention program. Okay. So yeah, so that's our request of the court, Judge.
Is revoke 45 days and reinstate?
Yes, and then
We may want to put some deadlines on some other things happening.
that's correct, Judge.
Okay, let me look some things up.
Already did 45.
Ms. Simpson, how much time is left on Mr. Smith's case? All right, and Mr. Smith, I have a couple addresses for you. One's in Fayetteville, North Carolina, and another is a shelter here.
No, neither one of those.
Neither one. Okay. Well, you're gonna be able to tell probation about whatever the right one is. 41. So Tanika Thompson was supposed to pick up Mr. Smith from jail. You did a transport order or release order. Who's Tanika Thompson?
Yes,
friend.
together?
Yeah,
Okay.
Your friend?
yeah, that's where I stay at.
Okay, so we just arranged it that that was who was gonna pick you up? I'm not remembering. I'm looking at the sentence
Yeah,
here.
she can come pick me up.
Well, that's a peculiar one. Well, but it was no violent contact with her.
We had
Um,
oh, excuse me.
so how's the family violence intervention program going?
Well, we didn't get it started yet.
Haven't started it yet. Okay.
I was doing my community service though on Thursdays.
Okay. Where were you doing community service?
At the probation office.
Okay. It's a good place to go to get it done.
Bring food up there.
Have you had your drug and alcohol abuse evaluation?
I think no.
Nope.
No, sir.
Okay. All right. So Ms. Smith, what are your thoughts about what we do here?
Yes, Judge. In this case, the state is asking to revoke 6 months and to reinstate the balance. The reason why we're asking for those 6 months is because the defendant pled guilty to the underlying case back in September of 2025. And around 6 months later, this new offense is, that's when the new offense in this case occurred.
Yeah.
So we believe because the new offense happened so quickly after he pled guilty to another case, and the fact that he is not enrolled in that FVIP or the drug and alcohol evaluation we will be asking for 6 months to revoke, and we'll also be asking for the defendant to complete or at least enroll in the FVIP and the drug and alcohol evaluation within 2 months after being released from custody.
Okay. Ms. Simpson?
Yes, Judge.
Yep, that was in the sentencing order. Okay. I'm still confused by the release order. Do you tell me what you remember? It's not a bad, it just is peculiar. We wouldn't normally say you're released to the victim.
I remember Miss Willingham and I went back and forth on this case a good bit, and then from my email, there was some representative from NAVCare that was emailing and asking me to do a release order for his medication. So
Maybe that's what, in order to get him the 30-day supply, he had to be released to
I
someone?
think that might be it, just from what I see right here.
Okay.
Did get my 30-day supply.
They did or didn't?
I did.
All right. Have you re-upped it?
Yes.
Where?
At Grady, Tim Park Place.
Okay, good.
It's doing good.
All right, it's a start. Good stuff. All right. So Mr. Smith, I do find that you violated the terms and conditions of your probation by getting this arrest in Coweta. That's going to play its own way out. Make sure you don't miss court or anything like that, and you need to let probation know what's going on with that case. I am going to revoke the 6 months. You'll get credit for the time you've been in, and you'll stay locally. You're not going down the road, but you're going to need to make sure you take care of the obligations that you've got on probation. You were supposed to start that family violence intervention program within the first 3 months of probation, which would have been starting it before the year was out. And here we are in into May, and that hadn't happened. So I'm going to require that within the first 2 months of your release, you get enrolled in that class. You also, within the first 2 months of your release, make sure you have that drug and alcohol abuse evaluation. And if there's any treatment that's recommended, that's going to become part of your probation. And the other conditions are maintained, which is it's fine for you to be around Ms. Thompson, just needs to be nonviolent contact. Sounds like you've been doing all right with that. And you've been knocking out your community service. But I'm hopeful that Coweta County, when they're thinking about, well, what to do with these charges, they'll see that as a consequence of those charges, you already had something happen here. And that'll make that thing flow more smoothly. Okay.
I do have a job though that I'm trying to get back to.
Okay. Well, what's the job?
I work at a restaurant and I cut hair at a barbershop.
Okay. What restaurant you work at?
It's called Finna Eat.
Okay. And did you know the people who work there? How'd you get the job?
Applied for it.
Okay. How long you been working there?
3 months.
Okay. 3 months leading up to this situation?
Yes, when I got out.
Okay. Any reason you think they wouldn't take you back?
'Cause I've been gone for so long, but
Yeah. But if you did good work, when they want you back?
yeah.
Okay.
Yes,
Well, good. I hope they take you back. I hope most of all, Mr. Smith, that when you ease on back out, you keep doing the good things that were happening, getting the meds, treating Miss Thompson right, working, and this will be it. We won't have more hiccups, okay?
Okay.
All right. Thank you, everyone. That was within the first 2 months of release as well, both getting started with FVIP and Mr. Smith, I'm gonna do one more thing. I'm gonna waive your probation supervision fees for the first 3 months, give you a minute to get back to work and focus on that stuff.
I don't know. Once it pops up in the booking screen, I'll tell you, okay?
Okay. So can you tell me when I get released?
Nope, not because I don't want to tell you, but I don't do that math. But you've made a dent in things already because you'll get credit for all the time you've been in.
All right, thank you.
Bye, Mr. Smith. Good luck.
Thank you.
You want to do one more before we break for lunch? Oh, and Mr. Melnick is alive and is working his way here. He realized that his estimate clearly wasn't accurate, and he asked if we have an afternoon calendar. Answer is yes. We're going to start back up a little after 1 o'clock. I need to give everyone a break. So you've been very patient, and he will be here. He's not a I don't show. He is a I'm in about 400 different courtrooms. He's in high demand. So that's the deal. What would you like to do for the last few minutes before we give everyone a lunch break?
Request for position 7 on the plenary calendar, Commissioner Rogers.
Yes.
Would it be possible for us to bring him over on Thursday for a plea so that Ms. Smith would have time to connect with the victim? Maybe?
So I'd say yes. Let's check with Ms. Nelson. I know on that day, one, we have a trial calendar, which will be a circus as always. We also have a bond hearing. Someone has asked for a bond hearing.
I don't think so.
Probably Rios. No, it is from presiding. It's one of those, but Ms. Nelson just said yes. So if you let her know it's position 7 from today's plea and arraignment. Rogers, I'll write it back.
And I'll go ahead and do a waiver just to be safe,
Great.
but I would like to resolve them.
Okay, so that's a reset to Thursday. And you think that'll be a plea, assuming there's good communication? Thursday. All right. Well, is there one?
I don't know if there's enough time to fit it in.
Certainly not Mr. Battle.
Okay. What have you, Curtis Gardner?
I don't know. I'm looking at the calendar. Hold on.
I mean, I'll be here all day. That's okay.
I understand, but if we could squeeze in one more. So Cody, we took care of Battle. We'll do after lunch. Jerron Johnson, that's mom. We're waiting on Mr. Melnick. And DeAnthony Owens was a no-show as a bench warrant. We just did Ms. Parlor. So Curtis Gardner. And then from the revocation calendar, What about Antonio Hayes?
Those are the ones that's still looking for.
Well, he needs a lawyer. And then Hughes is Mr. Fortis's guy. So is Hayes up? Well, Hughes is, yeah, but we don't have his lawyer. What about Antonio Hayes?
He's up.
He's up. Can you just bring him to the door, please? And then Ms. Cabreras took off before we dealt with Kimball, but I don't think we needed to necessarily talk with him. Yeah. Okay, I'll have him come to the door and that's it. So Ms. Rios, we'll do your bonds after the lunch break. I'm gonna have two people come to the door and then we'll break. Hey, are you Mr. Hayes? Hey, I'm Judge McBurney. Your case is assigned to me. You're charged with armed robbery, aggravated assault. You've got two co-defendants, a Mr. Kimball, who you may have seen back there, and then Tanisha Hayes. I don't know if she's related to you. She's resolved her case. So she's out, you're still in, and we need to, well, I need to find out if you need a lawyer. Are you planning on hiring one? You need a lawyer. We need to get you a lawyer. The public defender is conflicted off. They represented Ms. Hayes. And then our usual conflict defender is representing Mr. Kimball. So I need to get you an independent lawyer who's in it just for you. And that's easy to do. I just didn't realize that till you were on the calendar today. I think you have been missing in our eyes. You had missed court. It's okay. You're going to tell your lawyer, and your lawyer will tell me. There may have been a perfectly good reason why you weren't here. But your lawyer needs to talk with you about that, and then he or she will make the argument like, hey, give Mr. Hayes, let him out. He missed court for these reasons. But we need to get that lawyer assigned. I didn't realize you didn't have one when we had you brought over today. So I will have you come back once we have that lawyer lined up. Ideally, that lawyer will come see you first. Doesn't always work out that way. So it may be when you come back, you're like, man, I still haven't seen the lawyer. That person will be here when that happens. So you guys can talk, and then we'll talk about why did you miss court. And we'll be able to move your case forward because that lawyer will waive arraignment for you, can get discovery, all that stuff. Any questions? It has been. That's why I've got it. Actually was indicted. It's interesting. I don't know how old the alleged incident is. Kimball was arrested on, it's an old indictment. I'll be clear with you. It's from 2024. So it was indicted 2 years ago. 24. You can ask, you shouldn't probably say a whole lot because your lawyer might say, shh, Hayes. Okay. How long had you been in Cobb? Oh, well, that's why you missed court. Okay. That'll be pretty easy for your lawyer to clear up. Yeah, we had plea and arraignment in December of 2024. That was going to be your first appearance, and you weren't here because you were in Cobb. But you were indicted on October 1 of 2024, and you are charged 1, 2, and 4, the robbery of a guy named Charles Jenkins, aggravated assault, and possession of a firearm, you and Mr. Kimball. So anyway, you need a lawyer who can represent your interests. We'll get that person assigned. We'll get you back here, and we'll probably be able to clear up the missed court date and move it forward. Why were you in Cobb so long? For all those months, it got dismissed, and then they shipped you over here. Okay. All right. Let me get that lawyer assigned, and we'll get you back here soon to move this forward, okay? Thanks. Can you bring Kimball to the door?
Probably, yeah. Yeah, so I think it'll just be a 5 year.
That's not promising. Hey, Mr. Kimball? How you doing? Good. Your lawyer was here earlier today. I don't know if she met with you. She had to scoot to another courtroom. But your case had been kind of stuck because we had been trying to get Mr. Hayes here. We now have Mr. Hayes here. He's your co-defendant in the case. So we're going to make sure your case moves forward. Your lawyer did have a long conversation with the prosecutor on the case to make sure she's got all the discovery. So whatever the state has, whether it's video or witness statements or what. And then Ms. Cabrera, that's your lawyer, is going to be meeting with you soon to talk about what to do with your case, whether it's some kind of thing that should be a plea or a trial or what. Okay? Any questions about that?
What about bond and stuff like that?
So that's a conversation you should have with Ms. Cabrera. She is going to, once she gets that discovery from the prosecutor, figure out a time to meet with you, and you should bring that up, because the way you would be heard on bond would be if she filed a motion for a bond hearing.
I've been here 6 months. I haven't talked to them particularly or anything.
Well, it's probably good that a detective hasn't come to talk to you, because a detective shouldn't talk to you. The detective should go through your lawyer. But it sounds like we need to make sure Ms. Cabrera, your lawyer, comes to see you real soon. Would that be helpful? So you don't have your rights read to you unless someone from law enforcement's trying to talk to you. So if the detective did come to try to talk to you, he'd need to say, you know, I'm Detective so-and-so. I'm investigating this armed robbery of Mr. Jenkins. Would you be willing to talk to me? Maybe. And then the detective would read you the rights. That should not happen now because you've got a lawyer. And so really, if someone wants to talk to you, other than your own lawyer, they need to go through Ms. Cabrera. So now you may talk with Ms. Cabrera and say, I have some things I would like to tell the detective. And then she'll arrange for that to happen. And she'll be there for that conversation. She wouldn't let you just talk to a detective. She'd be right by your side. So if there may be some things you want to tell law enforcement, but that's part of what you talk to Ms. Cabrera about. Hey, what about bond? And I got some things I think the detective will want to hear. Okay. She can line that up. All right. We'll see you soon. You may.
Another month, I would, what I do in another 2 months before I go see court again.
It shouldn't be 2 months. I don't know exactly how long it'll be. Part of that depends on how much discovery there is and Ms. Cabrera's time to read through all that before she comes to see you. But do you have family on the outside?
Yes, sir.
So you should have folks try to call Ms. Cabrera to say, go see Mr. Kimball. All right? Yep. No, I hear you. That's a very fair question. And part of that hold was we got to get Hayes. And we learned he was in Cobb County. He had to finish his time there. And now he's here. So because you're co-defendants, we move you guys together.
You said it was another conversation.
She pled guilty. She's out. No one's waiting on her. She's already resolved her case.
Slow her process down and we wasn't incarcerated.
Well, she was interested in resolving the case. If you want to resolve your case and you need to talk to Ms. Cabrera about that, you can do that whenever you want.
Curious. Because I'm just kind of been lost this whole time. I haven't heard anything. It took me forever to get an attorney.
Yeah.
You know what I'm saying?
No, I know, because you showed up and like, hey, it can't be the public defender because they represented Ms. Hayes. So we had to line up an attorney. You got top-notch Ms. Cabrera, and she needs to come talk to you to let you know where things are.
Okay. I'll just make sure. Same process 2 times.
Yeah, so today, it wasn't the same process, because you've got a lawyer, and she and I and the prosecutor even talked about your case a little bit, just to make sure it was moving along. And that's when Ms. Cabrera said, I've got that discovery from Ms. Smith, I gotta look at it, and then I'm gonna go see Mr. Kimball. So I brought you over here to make sure she had everything she needed. Answer yes. And because now we've got Mr. Hayes, we can get, he needs a lawyer, and we'll do that. We'll line one up, but that's not gonna hold you back anymore, okay? You bet. All right, thanks for sticking around for that. Let's start a little after 1 o'clock. And I'll call the 1 o'clock calendar, but we've got the Battle and Gardner bond motions.
There I go.
Whatever works. Mohammed Doumbouya? Are you Attorney Lane? Great. What are we doing today with Mr. Doumbouya's case? You're going to trial. Okay, then we'll have a conversation on the record once we get our system working. It's working. You guys take a seat. Yep. Thank you, Aaron. So for those of you who were on Zoom, we knew we were muted to you all. There was a technical problem that our IT people had to solve from their special cave where they sit. But we're back, so audio should be working for everyone. I want to confirm, Ms. Wycliffe, can you hear us?
Yes, I can hear you.
Great, okay, she's here. So we talked about Mr. Doumbouya. How about Deshaun Price in custody? That's Ms. Rios. Levatus Barber. Okay, Ms. Rios. Luis Ramirez Perez. Okay.
This will just be a final hearing, or I just need to step back with the interpreter shortly.
Okay. So let's prioritize that. I'm going to get through the calendar here, and then if you and Madam Interpreter could speak with him, and then let's do the final plea, and that way we're not tying up the translator the whole time. Matthew Matreyan, I apologize if I...
Better than I.
Is he here?
He's present.
All right.
We will be entering plea today.
Great. Ms. Smith, you ready to go with that one?
Yes, Judge.
All right, we can do that soon.
I think we need to speak before, but that is.
You and Mr. Cohen.
Yes.
Okay, great. You'll have time. You bet. Alex Blue.
It's my judge, she's in custody. Just step out of here today.
Okay. Up 2 cases for Alex Blue. Kanye Willingham. Hey, how are you? It's been a minute. All right, well, the state is seated right in front of you, so talk away when we get through the calendar. All right. Laura Charles. And she's here. Do you like it when you hear the lawyer say, she's mine? Like you got a lawyer.
I just speak with her. I think it'll just be a final hearing today.
Okay.
But I'll put this to it.
Right. Ms. Smith, any update as to whether Mr. Peoples is coming back, or should all these lawyers talk to you about the Ms. Williams cases?
Just give me a few more minutes.
Okay. All right. That was it for this afternoon's calendar. I know I see Mr. Melnick, so we're going to talk about that case in a moment. Anyone else here? They didn't hear their case called, wondering what's happening? Nope. Okay.
The people say he's coming over now, Judge.
Great. Before you go back there, let's just make a plan. So Ms. Rios, we need to do a couple bond hearings. I'd like to do, not because Mr. Melnick's late, but because Mr. Johnson's mom has been here all day, handle his arraignment and whatever else we're gonna do with that.
Judge, so if we can have that heard today, that's.
Well, that depends on whether the state knew that bond was gonna be heard today, and that's not they did know?
Yes.
Okay.
Yes.
You're gonna handle that one?
Yes.
Oh, then yes. Okay. Are we able, Lieutenant Lattimore, to have someone out here while lawyers are back there talking, or the way we're staffed today, we need to go sequentially? Okay. Why don't we have the quick conversation with the translator and your client, knock that out, and then we'll bring Mr. Johnson out. That way you guys can talk. So Mr. Cohen and Ms. Smith, chat, you guys feel free to talk till we're back up.
Hey, give me 1 second, please. Hey. Oh, yes, yes. Yeah, it was a good time. The food was really good. Well, some maybe some like Nigerian food, because I haven't had a lot of Ethiopian food. I don't think what other African food was. Yeah, that's probably like number. These two rows. Are you still with the complicated? Just wait. Give me both of y'all on the top. All right. What is this? The counseling address, like I know what the counseling does, but what is it there? I guess what, see, I'm not, no.
You will be. So that's voluntary. It's really. That's what I'm suggesting. Lots of all right with misdemeanors, one after the other, and if he screws up, he's done. He's like NATO, you know, NATO is, don't actually talk on.
Oh, he's on red.
You don't know. To me, you agree.
Sure. You did it? All right. Offer that I sent was 5 years probation. We don't have to get HTC because he's getting the counseling.
So then I think that's why. So I was saying if we can do even make it 4 different misdemeanors with probation or consecutive, which would be worse than. I just hate it.
No, I'm kidding. I've been used to us. You can't persist. That was the opportunity to be like, hey, one get help, I want to do it. I appreciate the counseling, but I do not think I really do so this thing.
Judge.
We do not negotiate, please, so they just say we don't negotiate on sentence. We don't.
Yeah, that's fine.
So I think
This be I was what else was always be tough. You're nice.
get it, no. Happy.
With that.
Right, right, but I think because you're out.
I'd like to. Can I just do? Nothing changes other than.
Yeah, I know. I think for me, I'm still, I am still going forward with the family. I should call my victims back to see. The state is still with the family.
If I was seeing where you were, I wouldn't be that tough. I wasn't.
No, it's not even about me being tough, it's literally. Having this change.
I can hear me fighting. But if he took a gun, took a knife. I'd be right there, just all telephone stuff. You know, blasted voice and stupid child. So.
I did it. I don't know how to.
So are you ready for Mr. Ramirez?
Yes.
I need to like preface before we actually start.
Okay.
Offers watching.
So for 3 years.
Probation.
Hey, Ms. Smith, I gotta interrupt you guys. We're gonna do a quick final plea conversation with Mr. Ramirez Perez, and I think this is your case. So I'm gonna get a little input from you, and then you, Mr. Cohen, can get back at it. Your negotiated plea. All right, Ms. Rivers, are you ready? Let's get on the record in 25 SC 007-813. I'm going to swear in our translator. Do you swear or affirm that you will translate faithfully and to the best of your ability from English to Spanish and Spanish to English? Thank you. Good afternoon, Mr. Ramirez.
Good afternoon.
How are you doing?
Muy bien, ¿y usted? Very well, and you?
Okay, I'm all right. I'm going to ask you a few questions and also hear from your lawyer. It's important that you wait for the translator to translate into Spanish everything you hear in English, even if you understand what's being said.
Okay.
Will you also let me know if you have any questions?
Okay.
Great. Ms. Wood?
Thank you, Judge. So in speaking with Ms. Smith last week, I realized there's an unindicted false imprisonment case. That's
Related to this?
yes.
Should it be one indictment or it's two different incidents?
Two different incidents.
Okay.
Yes. And
Not super, 2 months. apart.
yeah, okay, 2 months. Anyways, I think it makes the most sense for us to try to take care of everything at one time.
Especially if it's the same alleged victim.
Yes. So that is what we're working towards now.
Ms. Smith, tell me your forecast for getting the false imprisonment indicted. Is that a next month it could happen, or gosh, World Cup is coming maybe by Christmas?
Within the next, I'll say 2 weeks.
Oh,
Yes.
okay.
They're, like I said, they're kind of similar. It has the same victim and an additional victim in that other case. So if we can try to get it wrapped up, that'll be fine. I don't think it'll be a problem.
Okay. But we'll take it off the current trial track it's on, this case, and we'll have the other catch up to it.
Yes.
Okay. Does Mr. Ramirez understand that there's another set of charges out there?
Yes.
Okay, great.
The one thing that he was tripped up about was the name of this calendar, finally. And I advised him that it's not the last chance.
Correct.
Correct.
So, Mr. Ramirez, we're going to pause the work on this case to let the other case catch up. When they are together, Ms. Wood and you can talk about how to resolve both. Does that make sense?
Yes.
Any questions about anything we discussed?
No.
No.
Okay. The prosecutor believes that your other case will be indicted in just a few weeks. And then we'll try to bring both the cases together and move them forward.
Okay.
All right. Thank you.
Gracias.
Thank you, Judge. You're live.
Yes, if you could, bring out, please, 1 second. Jerron Johnson. Yes, ma'am. Thanks for being here. Oh. There you go. Thanks for your help. All right, Mr. Cohen, unfortunately, I got to eject you from that table.
I'm ejectable, Your Honor, and we reached an agreement with all.
Look at that.
30 to be 31
Okay.
in July. Is that right?
Please. This one was accepted. This one was accepted.
All right, let's get on the record in 26 SC 001420, State versus Johnson. Mr. Johnson is here in court with his lawyer, Mr. Melnick. And Ms. Smith, you're going to be handling this for purposes of the bond hearing? Yes. Okay, great. Mr. Johnson, you were on this morning's calendar. You should know that your mom's been here all morning long, but Mr. Melnick, was stuck in courtrooms not in Fulton County, and was able to make it this afternoon. We're appreciative that he didn't get a speeding ticket and hurried over here. And we are going to talk about your case in, I think, a couple ways. Let me see what's in the docket here. So first, I need to know if you're waiving indictment for Mr. Johnson.
Waive formal arraignment and enter.
I mean, waive arraignment. He's been indicted. If you'll fill out before you go, you can do the bond hearing first, but before you go, if you'll fill out the waiver of arraignment, that'll lock you in as lawyer, and yet you're gonna participate in discovery, et cetera. I'll enter a scheduling order, Mr. Johnson, once I get that waiver of arraignment from your lawyer, and that'll start all the discovery in this case flowing to Mr. Melnick. Then he'll be talking with you about it. The other thing we're going to do today is talk about bond. You had a bond hearing a little less than 3 months ago. And Judge George heard that bond motion and denied it, although she didn't say why. She just said no bond.
I think it's because of the kidnapping charge, Judge. I don't believe that the judges at first appearance think they can set bonds on kidnapping charges.
Well, we'll have to clear that up because I don't think that's actually on our list.
Yeah.
Be that as it may, we're going to talk about bond again. I'll hear from Mr. Melnick. I'll also hear from the prosecutor, and then I'll let you know what I'm going to do. Mr. Melnick?
Thank you, Judge. Good morning or good afternoon. Your Honor, Mr. Johnson is 30 years of age. He's a lifelong resident of the Atlanta area. As you already know, his mom is present in court. He has a lot of family members who live in the metro Atlanta area who are there to support him. He was gainfully employed prior to being arrested. He works for a mobile detailing company called Dan's Mobile Auto Spa, and he's been doing that for about 2 years or so. So he's got strong ties. He's got 4 children, 10, 9, 8, and can't actually. It's 2 8-year-olds, right? So
are the 8-year-olds twins or different moms?
Different moms.
Your Honor, upon his release from custody, he'll be living in Marietta. So he's got a stable place to live. I looked over, I don't have an actual formal GCIC. So I just looked over his history here in Fulton County, and then he told me that he had a case from 2020 in Putnam County. I didn't see anything that I found to be terribly significant in Fulton County. There was a case from 2020 that ended up being a plea to a misdemeanor battery, as I recall, and then a case from 2017 that was originally charged as theft by receiving, but was reduced to disorderly conduct and driving on a suspended license. The case from Putnam County, he entered, I think, a first offender plea in 2023, I guess he would still be on probation for that case. They do have a hold on him right now, Judge. But that's his only.
Putnam County has a
Putnam
hold.
County, yeah.
Okay.
And that's for an entering auto charge. Your Honor, I've spoken with the victim in the case, LaTanya Barnett. She does not fear Mr. Johnson. She's in favor of him having a bond.
Is she the mother of some of his kids? This sounds like he took his kids or someone's kids and maybe that wasn't the understanding of how it should go.
There was an issue inside of the car. Mr. Johnson stopped the car and said this was his car that he was in. And he said, I need to get going. She got out of the car and ran. So he took the children to another location in Austell with her family members. So a place.
Meaning they were also in the car, or Mr. Johnson took the kids to
Austell.
Ms. Barnett's family members in Austell.
That's exactly right.
I'm dumping you off at a McDonald's.
That's exactly right. Yeah. Nobody was physically injured. Ms. Barnett, as far as I know, did not complain of any physical injury. She told me she wasn't physically injured. The children were not physically injured. There's no firearm involved. And as I said, Ms. Barnett has told me apparently her position has been from the beginning that she does not want him to remain in custody and wants him to be released on bond. The allegation supporting the aggravated assault is apparently that he put his arm around her neck. Not so much that he grabbed her by the neck and squeezed it. He denies doing that. And as I said, she has told me that she doesn't really she wasn't physically injured or anything along those lines. He doesn't really have much of a history of anything like that anyway, Your Honor. So what I'm asking you to do is to to give him a $20,000 bond. As far as contact, both Mr. Johnson and Ms. Barnett have said to me that they don't have children together. So there's no real reason for them to have contact with one another.
They were boyfriend, girlfriend?
Girlfriend, that's correct.
And Ms. Barnett brought into the relationship the kids who are listed in the indictment.
Those are her children. Yeah.
None of the 4 kids you mentioned are any of the kids in the indictment.
That's correct.
2.
Oh, there.
It's two of the kids were mine, 2 was there.
Oh, okay.
So let's just be clear. There is an Amiri Dawson, your kid?
No, that's her kid.
Okay. How about Sincere Barnett?
That's her kid.
Amiri Dawson, Sincere Barnett, Prince Johnson.
That's my.
That's probably you, and Nasir Johnson.
That's my son.
Okay. So those two are your kids. So there were 4 kids in the car.
Yes, sir.
Got it. Okay. Oh, that's why you can't kidnap your own kids. So it was Ms. Barnett's kids that the allegation is you took them without authority to have them and drove them to wherever you drove them. But Prince and Nasir were in the car as well.
Yes, yes, sir.
It's a big car. How many kid seats did you have in there?
Just one, because all the
Other ones are big kids?
Yeah.
Okay. Who's the littlest one?
Sincere.
Okay. All right. Okay.
That's all we have, Judge.
So $20,000 bond, leaving it to me whether there's contact, no contact between the two of them. All right. I think I understand that. Before I hear from Ms. Smith, I would like to hear from Ms. Gordon. Looks like we had a pivot. We've got Ms. Smith. Hey.
Hi, Judge McBurney. Yes, we have a change.
All right. Always good to see you. Happy day after Memorial Day. Do you have criminal?
Thank to you.
You bet. Do you have criminal history information for Mr. Johnson? He's number 9 on our plea and arraignment calendar from this morning.
Yes, Your Honor. There are 21 prior arrests, not including the one that's before you today. Last arrest, 8/25/25, theft by shoplifting, which is still open. It's showing a warrant in Putnam County. There is a first offender that was mentioned earlier, 2023, Putnam County, identity theft fraud, 10 years probation, Your Honor, and there was an entry into car. Nothing further.
Thank you. Ms. Smith?
Yes, Judge, in this case, if they would be asking for the bond to remain at no bond in this case, regarding the fact that, of course, the state sees it differently. In this case, the victim asked the defendant not to drive away with her kids. He refused and pushed her out of the car and took her kids to wherever he said he took them. However, it does, with the state remains that she wanted to remain in the car. The defendant did not let her and left with her kids inside the car. This was not something that was consensual. And at the time the victim did not know where the defendant was taking her kids. Regarding the Ayala factors in this case, the state does believe that the defendant may be a flight risk. Pre-trial, please correct me if I'm incorrect, but on his GCIC, I see at least 5 FTAs, and that's ranging from 2019 to 2022. This raises some concerns for the state that the defendant may not return to court if he is released. Also, that open case that's in DeKalb County for shoplifting, it's my understanding that the defendant is out on bond and committed this offense while he was out on bond. So the state does believe there's a risk to reoffend in this case. Because of the risk to reoffend and also those previous FTAs that I saw in this GCIC, the state will be asking for no bond. I did get a chance to speak with the victim in this case, and she told me that at the time, like we stated in the police report, she did fear for her life. Right now, she's not fearful of the defendant. She's not opposed to bond if one was set. So we believe that up in the court's discretion, if the defendant is to get bond, but from the state, we are asking for there to be no bond set in this case.
Okay. Got it. Thank you. Ms. Smith, man, did your research come up with any FTAs for Mr. Johnson?
Your Honor, I will go back and look. We typically now don't look at the FTAs, but I will do that for your court. And I do have the history up if you would like for me to go ahead and look at that.
I don't know how involved that is for you. I don't want you to do things you don't normally do. It's just
No.
5 is a big number. And so
I
if
can
it's
look
not,
at it.
yeah, if it's not too hard, if you could say, yeah, you know what, I found 4, whatever it is, that
Yes.
would be helpful.
Yes,
Thank
I
you.
would do that right now. You're welcome, Your Honor.
Thanks. Ms. Simpson, it sounds like Mr. Johnson is on active probation. It would be first offender probation out of Putnam County. Okay, and he should have a bunch of years left on that. Okay. All right, Mr. Melnick, anything you want to add, having heard these other things?
So what Mr. Johnson told me is that what the FTAs are all for like traffic tickets and traffic violations, nothing serious. I mean, he obviously doesn't have much of a history because he got that first offender in 2023 out of Putnam County.
Right, it's an interesting history. It's a whole lot of arrests for a guy who's 30, but he got a first offender in 23. So must have gotten a lot of traffic tickets.
I think it is primarily stuff like that. I mean, like I said, in his Fulton County history, I saw the driving on suspended license, and unfortunately, those can lead to, you know, sort of a revolving door of arrests and releases and all
It's
of that.
hard not to drive, but if
Right.
they know you in the neighborhood, they'll know that guy doesn't have a license. We're
Right.
gonna pull him over again.
Yeah.
And lock him up, and you have another arrest cycle.
And
And then you
then-
don't come to court because you don't have $500 to pay your ticket. Then you get an FTA.
Yeah. And I believe that's what we're talking about here, Jeff.
Got it. Okay. Well, Mr. Johnson, either way, you're kind of stuck. You got to go to Putnam County next anyway. I could set a bond. If you make the bond, all you're going to do is go to Putnam. I don't know how that's going to play out. I don't know if you want to confer with family about whether they want to post a bond only for you to go to Putnam County. That may be a quick turnaround. It might be they say, well, given these allegations that look serious on paper, there may be a different way to look at them based on what Mr. Melnick shared, that they're going to revoke a chunk of time. And I want to be thoughtful of your family's finances, because I'm inclined to set a bond, but it would be a higher bond. But if your family posted it, then all that's happening is you're going to Putnam County to confront a probation revocation. They're not going to give you a bond on that. They will say you need to have a hearing. And then it could be you negotiate something. It could be that the prosecutor there needs to prove up a little bit of whatever this case is about. So I want to be thoughtful about how we structure this. Do you all want to talk for a minute?
If I could just have a second.
Sure.
So, are you otherwise compliant with your and the arrest in Decatur County? That arrest in Decatur County. I mean, Your Honor, would you consider a lower bond if, or something comparable to what I had asked for if he were to be fitted for an ankle monitor for at least a period of time?
So I was going to do the ankle monitor just to ensure that he's staying away from Ms. Barnett. But I wanted the work through the logistics in his mind and his family's mind about, do we want to put up X dollars that simply then gets them to Putnam? And if Putnam, I don't know what Putnam County is going to do, but if they say we're going to revoke a year, then you paid a whole lot of money to go spend a year in custody, and we'd get you back here to resolve this case before then anyway. And so it's more a financial thing.
Judge, so what I'd like you to do is, if you would consider granting him the bond, and then I'll talk to his family and we'll figure out whether that's going to be worth it to him to post the bond or just remain in the Fulton County Jail.
So what I'm going to do, Mr. Johnson, is I'm going to set a $50,000 bond. It's across all counts, so this is the total amount. It's through the sheriff's 10% program. The significance of that is that the money that your family puts up, they'll get most of it back when your case is resolved, whatever resolve means. Plea, trial, dismissal. There's some fees they don't get back, but at least they get some of the money back, most of the money back when the case is resolved. Special condition of probation number 1 is no contact with Ms. Barnett. You stay away from her. I'll need to get an address. You probably both have it for Ms. Barnett. Well, I need 2 addresses. One where Mr. Johnson will be staying. And I meant to ask about that. What's in Marietta? Is that
my mother's house.
You'd be staying with your mother?
Yes.
Okay, that's a okay place. So I'll need that address because we'd start out there with a curfew. We can adjust it based on what your work hours are. But if you're doing mobile detailing, that seems like that's more daylight hours.
Yeah.
Yeah, so we could do I don't know, if like 8 p.m. to 8 a.m. I don't want to get in the way of the work. So we'll start your curfew, meaning you got to be at your mom's, would be 8 p.m. and then you stay there till 8 a.m. And then you can be out and about with the ankle monitor on. Although where you can't go is wherever within 200 yards or wherever Ms. Barnett lives. So we'll need to get that address.
I got the address for you.
Well, great. But one of the lawyers is going to email it to my litigation manager.
What address do you have for?
1440 Kenilworth Drive. Kenillt, no, W.
Kenilworth.
Yeah, Drive.
Or is that Atlanta?
Atlanta.
Is there an apartment number?
No, that's a house.
Do you know the zip code?
No.
Okay, that's fine. I can figure it out. Judge, do you want me to just email the two addresses to
I
Ms.
do,
Gibson?
I do. And then one last thing. What's the status of your license right now?
I believe it's still active for the.
As in, it's not revoked or suspended or anything?
No.
Okay. Well, the last condition of your bond is no driving without a valid license. Obviously, that's a crime anyway, and you might get a ticket. But if I learn that you got another driving with suspended license, driving with no license, I'll take your bond. So it have an additional consequence of not just a $200 ticket, but then I'll revoke your bond. So those are the parameters. You and your mom and Mr. Melnick can talk about, does it make sense to invest in the bond or to sort this case out, then go to Putnam County or what? I'm here either way. I'm happy to move this along. Your lawyer's going to get discovery soon, although it sounds like he knows a whole lot about the case. And talking with Ms. Barnett's going to be 85% of the case anyway, and he's done that. Okay. So my guess is he's going to start talking with the prosecutor about where could we go with this. And it may be you resolve it here before you go off to Putnam County, and that's often a signal to that county of, hey, we'll just do what happened in Fulton County. Okay. We'll see.
Thank you. Your Honor, would you consider doing the 10% or a cash or surety bond, or I'm sorry, I didn't mean to say cash, a surety bond in the alternative?
So yes, but it's a county funded ankle monitor.
Okay.
That's through Second Chance. Gotcha. I just don't know how they do that if the bond is with Smith's Bail Bond. If they say, that's fascinating, we're not going to do an ankle monitor. I don't know. That might be awkward business for them. Mm-hmm. But if you want to explore, let's start with the Sheriff's 10% program. Okay. And if you identify that, you know what, we could afford a $50,000 bond through a bonding company other than Second Chance, okay, then let's just find out, all right, is there a way to do that? The size of the surety is the important part to me. I thought it could be valuable to the family to be able to get some of the money back. But I've also heard sometimes, yeah, but I can get on a payment plan, and if we resolve the case early, then it's not so bad. So I'm open to that. It's mostly stay away from Ms. Barnett, the ankle monitor, so we know Mr. Johnson is in the places he said he would be. And we're not running into another one of these FTAs.
Okay.
All right.
Thank you, Judge.
Mr. Johnson, you have any questions for me?
No, sir. Thank you.
Well, you're welcome. Ms. Smith, anything else from the state? Okay. All right. Thank your mom for being here all day. All right. Ms. Rios, do you want to do one of these bond hearings now, or do you have a final plea thing you want to do? Oh, hold on. We got Mr. Lane here. Yes, sir. You are, right. So we got to get something real quickly on the record as to what the offer is. You want to do that right now? Yes. Okay. And then what bond hearing are we going to do right after that?
Mr. Garner.
Okay. All right. So why don't you and Mr. Dumbuya come up here, please? Gardner, we're going to do next. We got to do this. This will be 2 minutes, and then we'll be ready for Gardner. All right. We're going to get on the record in your case. It's 25 SC 006-794, State versus Dumbuya. You are charged, sir, with aggravated assault and possession of a firearm in connection with that aggravated assault. Your lawyer, Mr. Lane, is here. Ms. Smith is representing the state. First, Mr. Lane, do you feel like you've got all the discovery in this case?
Yes, Your Honor.
You're good to go on that front.
Yes.
So that's why you said you're ready for trial. Ms. Smith, what is the state's offer? Thank you. All right, Mr. Dumbuya, do you understand that if you were to enter a plea today, the prosecutor would recommend that you serve 1 year in custody, followed by 9 years on probation.
Yes, sir.
Okay. Mr. Lane would be free to recommend a different sentence. He could recommend straight probation. If I were to sentence you to more than what Mr. Lane asked for today, you could withdraw your plea if you did not like the sentence you got. Do you understand that?
Yes, sir.
After today, you're still free to enter a plea. You can enter a plea in the middle of a trial. What changes is you don't get to withdraw it if you're unhappy with the sentence that you received. Do you understand that?
Yes, sir.
Okay, last thing, the state's offer of 10 to serve 1, that's their offer today. It may not be their offer tomorrow. It may get better for you as they learn more about the case. It may get less good for you because they say, well, fine, we're ready for trial. We've had to put in more work, spend time with the victim, and now it's 10 to serve 2 or something like that. You don't get to resurrect this offer if the state's not interested in it. Do you understand that?
Yes, sir.
Okay, understanding all those things, Mr. Doumbouya, do you want to go forward with the plea today or have your case moved to the trial calendar?
Yeah, I want to move forward to the trial.
That's what we'll do. Let me look up your case and ask you a couple questions about it. Mr. Lane, anything else on behalf of your client?
No, Your Honor.
All right, Mr. Doumbouya, you... So old. So you've been on bond now for almost 2 years. Your bond, you are supposed to stay away from Camelot Drive. That'll keep you alive. And you're supposed to stay away from a David Larker. You staying away from that person?
Well, he was one of my tenants. I don't think the guy's,
You just need to know you're staying away from him.
Yes.
Regardless of who he is, your godfather, your tenant, whatever, you and Mr. Larker are supposed to stay apart. That's part of your bond. I just need to make sure you're still doing that.
Yes, sir.
Okay. Those were the conditions of your bond. And so you owned something in Camelot?
Yeah, I own several properties there.
Okay, but you're staying away from there.
Yes, Your Honor.
Yes, sir.
Okay, I'm gonna let him answer, not you. I got an address for you on Camp Creek Parkway. Is that where you still stay?
Yes, sir.
An apartment?
Yes, sir.
Okay. I just want to make sure we're able to reach you. We'll obviously be contacting Mr. Lane, but the actual court notice that goes out goes to your address. And we do it by mail. We're old school. There's not email or a text. So this apartment on Camp Creek Parkway is still your spot.
Yes, sir.
Okay. Ms. Smith, anything else from the state? All right, Mr. Doumbouya, I will see you and your lawyer, I think it's on June 16th that we're calling the calendar. Let's look. June 16th. Yes, June 16th. We'll see you here. Okay?
Thank you.
All right.
Thank you, Your Honor.
Now, Mr. Gardner, please. Did you already do a waiver?
Yes, Your Honor.
Okay. Let's get on the record. 26 SC 001-658, State versus Curtis Gardner. Good afternoon, Mr. Gardner.
Good afternoon.
I'm Judge McBurney. How you doing?
I'm doing fine, y'all.
Great. Ms. Rios, your lawyer, is here with us. Ms. Smith, are you handling this? Okay. Ms. Smith is going to represent the state for this bond hearing. All we're going to do right now is talk about bond. Ms. Rios is going to tell me why you should get a bond. She may need to tell me a little bit about the case, just so I have a little bit of sense of what was about. I can see what it says. It's a family violence battery charge, but it's not your first. You have at least one other. Ms. Smith is going to give me the state's perspective, and I may ask someone who you can't see and I can't about your criminal history. Then I'll let you know what we're going to do. Ms. Rios?
Yes, Your Honor. Mr. Garner is 59 years old. He's from Georgia, so he's not a flight risk. He has 9 children. I believe the youngest is 18 years old. He was working for a custom glass company. And I don't believe he's on probation or parole. As far as this case goes, I believe his brother is the victim, and it was just a tussle between brothers, from my understanding. I'm asking for you to set a bond of no more than 5,000 in this case.
He has no bond right now?
I do not, I think, well,
I'll look. I just, for this charge, that's,
it's just high. It wasn't like,
okay.
I don't think I have.
oh, I'm sorry.
I don't.
Thought he had a bond, but no, I guess not.
Yeah, on March 16th, this case has rocketed along. Judge Jor, oops, nope, that's wrong. Judge DeFore denied bond. Okay. I'm listening.
Oh, that's all I was asking for, a bond no more than $5,000.
Okay. Ms. Smith?
Yes, Judge, in this case, the state is asking for a bond of at least $10,000. I didn't get a chance to speak with the victim in this case. It is his brother. He said that he is not opposed to the defendant getting bond. He had a conversation with his brother and believes that he's learned his lesson. So because of that, the state is not opposed to bond, but we are asking for at least $10,000.
Do you know if Mr. Gardner's prior family violence battery involved his brother?
Sure, if the previous, give me one second.
Mr. Gardner, are you comfortable answering that question? You picked up a family violence battery before.
It was with my wife.
Okay.
It has nothing to do with my brother on this case.
Okay. Got it. So two different family members.
Yes.
You got rough with your wife sometime in the past, your brother much more recently.
Yes, sir.
Okay. All right. So the state is saying yes to bond, just a higher amount. And what about contact with the brother? Is he also a Mr. Gardner? I'm assuming. What did Brother Gardner say about contact, no contact?
He said that there could be contact with no bond.
Okay. Mr. Gardner, tell me what you do at this glass company.
I do storefront glass and I repair windows and replace windows.
Okay. When you say you do storefront glass, as in you install it?
Yes.
Okay. How long have you worked there?
For like 11 years.
Do you think they'll take you back?
Yes.
Where do you stay?
Oh.
Well, I'll pull it up right here. I've got a Princeton Drive address, an apartment on Princeton Drive.
That's the old address. The new address is 5245 Willow Park Boulevard, College Park.
And whose place is that?
That's my mom's.
Your mom's place. When you were on Princeton Drive, whose place was that?
It was my mom's also.
Oh, so you've stayed with your mom?
Yes.
And she moved recently?
Yes.
To College Park?
Mm-hmm. She has all times.
Okay. Do you stay there with your brother?
Yes, sir.
So you and your brother, the victim in this case, would be living under the same roof?
Yes.
Okay. And Ms. Smith, you didn't hear concerns from the other Mr. Gardner about that?
No.
Because this Mr. Gardner has learned his lesson?
Yes.
Okay. All right. Ms. Smith, what criminal history information do you have for Mr. Gardner?
Yes.
Your Honor, there are 29 cycles, last arrest being 8/19/20 in Fulton County. There are 4 felony convictions, Your Honor, 87, 01, 09, and 09.
What were the 09 convictions?
Okay, there is an 09 ag battery. There's an 09 burglary. And then the Fulton County one is 17 ag battery, aggravated assault, 17 SC 150982.
Thank you.
You're welcome.
Ms. Simpson, is Mr. Gardner on probation? Was there probation for that 17 SC case? Okay. All right. So Mr. Gardner, I will set a bond, in your case. The main thing about it is you just got to leave your brother alone. If you guys get into it verbally for whatever reason, you got to walk away. Even if he's the one who's being a pain, he changes the station on the TV, he takes the last chicken leg, whatever it is, just walk away. Don't, if you get mad at him and do something, your bond goes away. It'll just be you're locked back up
I
again.
learned my lesson.
Okay, I hear you, but you're 59. You should have learned your lesson when you were 29.
Exactly.
Okay, well, you talk a good game.
Thank you.
I'm gonna set the bond at 7,500. I'll set it through the sheriff's 10% program. The only condition of the bond is no violent contact with your brother, who is Gregory Gardner.
Yes.
I know who you knew that was, but okay. So no violent contact with him. We need to get an address change. You'll do that for Mr. Gardner. If you move, you need to let everyone know. If your mom moves and you move with her, you need to let everyone know that new address, okay?
Sure.
Attorney Smith, anything else? All right. That's it.
Thank you, Your Honor.
Bye.
Thank you.
You want to do Mr. Battle or?
Someone else.
Or Robert Herman?
Well, if you've got a final plea, we could knock a couple of those out. Not,
Oh, she lives with a time zone.
Okay.
To be able to get back today.
and what are we doing with Ms. Wycliffe? Hey, let's talk about that. That's quick. And then if you've got anyone who is simply doing a final plea, why don't we knock a couple of those out, especially if they're in the gallery? And then we can do, Mr. Cohen, your client's plea. What did you, Mr. Rhodes, figure out? You still need more time with Ms. Smith? Yes. You haven't been on bended knee long enough? You haven't been able to convince her yet of the wisdom of your situation? Okay. Oh, you haven't talked at all? Okay, she's been busy. You notice how many lawyers are here to help her today with all the other cases. So, okay. Let's turn then to that.
Judge, I just want to let you know I'm logged on at this time.
All right, thank you, Mr. Fortis.
Okay.
Ms. Wycliffe, can you turn there we go, add you to the screen. There you are. Whoop, you got really dark. You need to be less dark than that. There we go. It's still pretty dark. You have any light bulbs in the apartment?
Yeah, I just hold on.
All right. Great. Yeah, you are in a different time zone. Okay. So I don't think we even need to be on the record if we're just doing diversion. Why don't you tell me, Ms. Wood, what's happening? I'll make sure Ms. Wycliffe understands it and that Ms. Smith says, yes, that's actually happening.
Sure, Judge. So Miss Williams and I started talking about diversion months ago, and then Miss McGillicuddy and Mr. Peoples saw the referral through, and I confirmed with Mr. Pollard, I think with the DA's diversion program, that it's all good and well, that she's in a different state and she can do the orientation virtually, and all will be fine with that.
Okay, that's good, because I know there was something about if you don't do orientation in the first 30 days, it's all over, but that can be virtual.
Yes.
Okay.
So we should be good to go. I sent her all the conditions, and she had a couple of questions about everything, and we talked through it. So.
Okay. And someone, Ms. McGillicuddy or Ms. Smith, someone's going to submit a proposed order that has those conditions? I assume it's the fairly standard vision board and 3 to 5 page paper and whatever.
Yes,
Okay.
we'll make sure.
Ms. Wycliffe, what town are you in?
I'm in Fort Worth.
Ford?
Fort Worth.
Oh, Fort Worth, as in Dallas, Fort Worth.
Yes.
Got it. Did you vote today?
No.
Not your primary?
I was so focused on trying to make it to court, so I
You
won't
did a great
have
job.
another FTA.
Okay, no FTAs. Do you understand what's happening with your case?
I do.
You are gonna take care of the small list of obligations that the diversion program puts on you.
I am.
Usually about 6 months to knock that out. We'll put a reminder in our system to bug the lawyers to say, hey, it's been 6 months. How did Ms. Wycliffe do? And once you finish that stuff, the DA's office is pretty good about sending a proposed order to the judge that says, close this case out, dismiss the charges. Ms. Wycliffe did the thing she was supposed to do. If you run into any obstacles, reach out to Ms. Wood so she can help here in Atlanta run interference for you. But hopefully it's the kind of stuff you can knock out, okay?
Okay, thank you.
I'm just looking at what the charges are. There was a child involved. Was that Ms. Wycliffe's child? And is that child in Fort Worth?
I think so.
She is. She is in the room, actually.
Oh, hi, child. How old is your child?
She's 16 now.
16?
Yes.
Okay, well, she's gonna do cruelty to adults soon. Okay, you guys are getting along okay?
Yeah.
All right, well, good. Do you have any questions about anything we discussed?
No, Ms. Woods explained everything beforehand, so I'm kind of up to date with everything.
Okay, Ms. Smith, anything from the state? All right, well, I'll look for that paperwork. I'll sign it. You don't need to worry about missing court anymore. You just need to take care of those things on the list of requirements or conditions of the pretrial diversion, and you should be all set.
Okay, thank you, Judge.
All right, take
Thank you,
care.
Lacey.
You're welcome. Have a good day. Go
You
vote.
too.
Judge, can we do a final plea hearing for number 15, Miss Charles? She has a big crowd with her.
Sure. All right, so this is a final plea hearing?
Yes.
Then we'll get on the record. 26 SC 000-103, State versus Laura Charles. Hello, Ms. Charles.
Hello,
How you doing?
I'm doing great.
Great. You got a lot of people here for you.
Yes.
All right. Ms. Charles is here with Ms. Wood, and Ms. Smith is here for the state. Ms. Charles, you are charged with cruelty to children in the first degree. Ms. Wood, do you have all the discovery you expect should be out there?
Yes, I do. I'm sorry, Judge.
That's okay.
Yes, I do. And I was just telling Miss Smith earlier that Miss Charles has gotten me a lot of mitigating evidence. Some of it I've been able to share directly with Miss Williams. The other pieces that she got to me last week, I'm going to get to Miss Williams when she gets back.
Okay.
So it doesn't get lost in the shuffle.
Great. So this is a case that will be on the June 16th trial calendar. Do we have a sense of whether Ms. Williams will be back before then?
Yes.
Great. Okay. I'm not rushing her at all. I just wanted to know. So this is a conversation you and she can continue to have. Got it. All right. Ms. Smith, what is your understanding of what the state's offer is today, pre-mitigation evidence?
Either probation with the special conditions of anger management course and no contact with the victim.
And Ms. Wood, who is the victim to Ms. Charles?
She is a niece of Miss Charles.
Okay, got it. So Ms. Charles, if you were to enter a plea today, the state would recommend straight probation, 3 years, that you complete an anger management course, and that you, during those 3 years, not have any contact with your niece. Do you understand what the state's recommendation would be?
Yes.
Ms. Wood could recommend less. All that would mean would be less probation. The state's not seeking to have you spend time in custody. If I were to sentence you to more than what Ms. Wood advocated for, today you could withdraw your plea. So you know what, I would take what my lawyer asked for, but not what you gave me, Judge. After today, this case may still resolve by way of a plea, but you won't be able to withdraw your plea if you don't like the sentence that I impose. Do you understand that? Yes?
Yes.
Okay. The state's offer may stay open. It may get better because of this mitigating evidence. It may be that they learn some things that causes them to say, wait a minute, we actually think it should be 3 years in jail. So there's no guarantee that the state keeps its offer open. Do you understand that?
Yes.
Okay. Well, understanding those things, do you want to work the case out today with the plea or have this case moved to the trial calendar?
Move to the trial.
We'll do that. You'll need to be back here on June 16th. That's when we're calling the calendar. It may be that you're back here before then. If you and Ms. Wood work something out with the state, it's always better to knock it out before that trial calendar day. That's a busy day. At the latest, I'll see you here then. I don't know what the conditions of your bond are, but you're still on bond. So whatever they are, make sure you keep doing that.
Correct.
My guess is one of them is no contact with your niece.
Perfectly fine with that.
Okay. All right. Ms. Wood, anything else on behalf of Ms. Charles?
No, Your Honor, thank you.
Ms. Smith from the state? All right. Do you have any questions, Ms. Charles? Okay. Then I'll see you on the 16th.
Okay.
All right. Should we do the Metreon plea now? And then we'll do Mr. Fortis's client's revocation.
Beat the meter, but I think I'll gamble.
Ms. Smith's pretty efficient. That will get through it. You ready? Okay. All right. Let's get on the record. Position 11 on our final plea calendar, State versus Metreon, 25 SC 007846. Good afternoon, sir.
Good afternoon, Your Honor.
Mr. Metreon is here with his lawyer, Mr. Cohen. Ms. Smith is representing the state. Mr. Metreon, in a moment, Ms. Smith is going to put you under oath. Once you are under oath, you need to answer her questions and mine truthfully and completely. You also need to let your lawyer or me or both of us know if at any point you have questions. Things
Yes,
aren't
Your Honor.
making sense, or Mr. Cohen said it's going to go this way and it goes that way. Anything like, wait, what? You need to stop us and have someone explain it to you, okay?
Understood, Your Honor.
All right, Ms. Smith?
Yes, Judge, thank you. Mr.
Metreon.
Metreon,
Yes, ma'am.
please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Matthew Ryan Metreon.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given today?
Yeah, I'm prescribed to Lexapro, Buzz anti-anxiety, and Trazodone for sleep, but I did not take the medication this morning because I haven't had a chance to eat yet.
Does the fact that you have not taken the medicine make it hard for you to focus on what's going on?
No, absolutely not. It's an antidepressant, anti-anxiety, and then a sleeping pill at night. So
Okay, but sometimes I've had folks in here who didn't take their anti-anxiety medication
Yeah.
and they're very anxious because court's not always a warm, fuzzy space. You're doing okay?
yes, sir.
Okay. Maybe you don't need the medicine anymore.
Hopefully.
How old are you and how far have you gone in school?
I am 36 and I have a bachelor's degree in business marketing from the University of Alabama.
Ooh, so you're recommending jail, I assume.
Come on, I'll get the University of Alabama, even though my youngest daughter graduated from there.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Counsel, are you satisfied that your client has an understanding of this proceeding?
Absolutely.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Absolutely, indeed.
Mr. Metreon.
Metreon, yes, ma'am.
Metreon,
Yeah.
do you remember being arrested on these charges?
I was completely blacked out.
The state is unaware of any outstanding warrants related to these charges. Are you or your client aware of any outstanding warrants related to these charges?
I am not. I believe all of the charges have been, he was arrested for and is now being prosecuted for.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years probation?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
I do. And I am.
Mr. Metreon,
Yes, ma'am.
has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 25 SC 007846, how do you plead to counts 1, 2, and 3, terroristic threats and acts?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal directly from your guilty plea conviction, but if you believe that there has been some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal?
Yes, ma'am.
Do you understand that that process must be completed within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you. Your Honor, if this case were to proceed to trial, the facts would show that on August 20th, 2025, officers responded to the 6 Concourse Parkway address that's in Sandy Springs where the company NX Direct was located. When the officers got there, they spoke with a Venice Acino, that's Vinicius. Last name is Ascencao. When they got there, the victim told the officers that they received some text messages via LinkedIn from an employee that had started at the business around 6 days ago. The victim was able to identify that person as being the defendant in this case. The victim in this case showed the officers text messages that was sent from the defendant to the victim in this case. Those text messages, there were a lot of them, but some of them were telling the victim that he would take everyone out, the victim and everyone at the business, that they should kiss their families tonight because tomorrow they will all be dead. And other statements like, go ahead and let everyone know that 400 near Sandy Springs will be shut down. The business is near Sandy Springs 400. The victim in this case told the officers that the defendant not only threatened him, but also threatened his business partner in this case and other employees that worked at the business. I was able to talk with the victim, Mr. Vinny, in this case, who told me that he was okay with the state's offer of 5 years probation. His main concern is that he just wanted to make sure that the defendant would stay away and that he would not have access to the business anymore. Also, I was able to speak with the secondary victim in this case, who told me that he still looks over his shoulders to this day. He does not want the victim to be around, and he didn't have that many conversations with the victim, so he was kind of shocked when he saw his name directly in some of those threats that the defendant sent to the victim via LinkedIn. All of this occurred, the messages were sent to the victim that was located in Fulton County. Therefore, this alleged offense here was committed in Fulton County. Regarding the negotiated plea between the state and defense, we've agreed to 5 years probation. That's for counts 1, 2, and 3 for them to run concurrent. For the special conditions of probation, the state is asking for the defendant to complete an anger management course, to have no contact with either of the victims in this case. I believe count 3 lists the employees of the direct company as victims. The state will also be asking for anyone that's an employee of the direct company for the defendant to have no contact with them, and also for the defendant to stay away from the incident location, is what we're calling the location of the NX Direct Company. It's my understanding that the defendant was hired there 6 days previously before these threats went out on LinkedIn. And lastly, Your Honor, the state is asking for the defendant to complete a mental health evaluation with treatment if necessary. That's all from the state.
Thank you. Ms. Smith-Mann, any criminal history information from Mr. Metrion?
Your Honor, this is a multi-state offender with 4 cycles from Georgia, 1 Alabama, 2 from Tennessee. I'm not sure if this is the same case. With last arrest 9/3/25, Fulton County, 2 counts of terroristic threats, 2 counts of simple assault, open 25 PI 007116. There was a first offender in Cobb County in 2019 of terroristic threats. However, it was discharged in 6/21. Nothing further, Your Honor.
Thank you. Mr. Cohen.
Your Honor, if it please the court, what the court has heard is accurate. What the court has heard is a boy in a man's body. He had been smoking marijuana, weed, evil weed, call it what you want to call it. He had been doing far more alcohol than any human being should do. Since the time that he's been arrested, he had an ankle monitor for a while, which was removed. He has not had a drink. He is continuing to get counseling, and I provided that to Ms. Smith. He will continue to get counseling. And by the way, this is under conditional discharge in police accord, since he has used his first offender. I have made clear to him on numerous occasions, and by the way, that this is it. There is no more. This is the precipice, 1 inch the other way, and he's got a record that's going to last the rest of his life. I think he's sort of like NATO, no action, talk only, but this was horrible talk. This was something that one should never do, be they under the influence or not. It's unacceptable. And I've counseled with him numerous times, and I've spoken with his mom on numerous occasions. I know his dad passed away, and that was difficult, but all of us go through something that's bad. Some of us more, some of us less. This is it, Your Honor, and I ask the court to follow the recommendation.
Mr. Metrion, tell me, Mr. Cohen said you're receiving, is it drug treatment or what is it?
No, Your
Addiction
Honor.
counseling?
Just straight up regular counseling. I've been going since the arrest date. And just kind of working through my anger issues, mainly due to like how much the country's changed in the last 5 years. Can't really wrap my head around it. And they, the reason this happened is because they lied about the starting salary. And I figured that out when I got my first paycheck. So I will be reporting them to the Better Business Bureau.
No, you will not.
Okay. So I have in the system that you got arrested twice in connection.
It was the same night, but then the other two, like when that night I got arrested, they took me to the hospital, and then I went to Peachford Mental Hospital for 5 days. While I was in there, my family spoke with the Sandy Springs Police Department multiple times. They said, "Oh yeah, there's no charges. He's going to the mental health facility." As soon as I get out, a day later, right when college football kickoff, the first one happens, boom, they surround the house, arrest me. I bailed myself out. It was over the weekend, so I had to wait 3 days. I get out, a day later, they arrest me again for the same night, surround the house.
Okay.
Basically, Your Honor, in my view, he brought it upon himself.
Right. No, I'm not having a big pity party for him right now. I just was curious why there were 2 arrests. It looked like it was for the same conduct. So what did NX Direct do? Like if you
they lied about
No, I didn't ask that well. I don't want to hear that part. What line of work are they in, and what would you have done for them?
So it was a sales position, but I was not aware it was harassing people in Walmarts to subscribe to AT&T. So it's bottom feeder sales, but they didn't explain that. And then when I started working, I was in a desperate situation, so I stuck with it. And I can't stand those types of companies. They trick people. I was a corporate recruiter for 10 years dealing with 6-figure IT executives. So that's I felt some type of way that it was beneath me, and that I was not being paid what I was told I was being paid. And I did the wrong thing. I had a momentary lapse of judgment. I drank. I hadn't had a drink in like 6 months before that. And, when that anger builds, I just go straight to that booze. So not anymore. I haven't had a drop since that night.
So you get angry again. Talk to me about the Cobb County case. So in June of 21, 5 years ago, you got a first offender for terroristic threats and acts. What was that one about?
Yes. So when they were arresting me for disorderly conduct, I was blacked out drunk, and I guess I fought back, and I definitely, I grew up wrestling, doing jiu-jitsu, playing football. So, I definitely gave him a hard time. And then I guess I threatened one of them. I have no recollection of that night, just like this.
So it involved law enforcement as opposed to an employer.
Correct, as they were dragging me down the driveway.
Okay. All right. So I'm not inclined to do conditional discharge. I don't know if that changes what you all are going to do. But given what the first offender was for and sort of how I've heard things today, it's a final plea. So Mr. Metrion can always back out. But I just want to let you know, I am fine with the other pieces of the case, the 5 years probation. I was even going to set a behavioral incentive date, anger management, clearly no contact with anyone or anything to do with NX Direct. But I don't see this as the right case for a conditional discharge. Not because it's not drug charges. I get the connection to your addiction and whatnot, but because I see it as a second offender. I see this as another instance of what happens when things don't go well for you. And you had a first offender for that Cobb situation. So that's where I'm with this. All the other pieces, I'm all right with, but I don't intend to have it be a conditional discharge sentence. I'm happy to hear from you, Mr. Cohen, because you moved into the speaking position. But I also want to give you and your client a chance to talk because Mr. Metreon may say, I got to go to trial. And I respect that, and we'll do that. But that's where I am.
Your Honor, for please the court from the defense side, it is not a triable case. It is not a winnable case. And he understands all that he did that was wrong. I'd ask the court to reconsider because I hate to see someone who has 36 years behind him and a lot more in front of him not have the ability and the opportunity to continue on his life in a way that is appropriate for those people who have graduated the University of Alabama, if you will.
Or any other school. I get that. It's a complicated situation for him. I work with young men and women all the time who catch one felony or 6 and they work their way just okay through life as well. I think it is an appropriate consequence for this second incident. It says to me, and I think to others, that whatever happened the first time, I don't know that it's the first time, but the one for which first offender was granted didn't yield the kind of changes that I'm sure, Mr. Metreon, you wanted to make in your life, but they didn't go all the way through. And there's not a third offender. So I think that the appropriate outcome is for there to be a longer term consequence as a result of what happened here.
You know, I only say this was by LinkedIn. This wasn't a phone call. It wasn't even direct text. And that doesn't in any way absolve him of any of what he did.
I heard the facts. I understand. If it's not going to be a tribal case, then if it's not a tribal case, it doesn't sound like it is. It sounds like we're going forward. It's just not exactly what you were hoping for. So, Mr. Metreon, I'm sentencing you as to each of the 3 counts to 5 years probation. Special condition of probation number 1, no contact, direct or indirect, with either of the gentlemen whose names we heard. It'll be written on your sheet, your final disposition, but also anyone who is associated with NX Direct. That's probably the easiest condition you've got because you seem pretty fed up with them and the fact that they weren't straight with you about what line of work you'd be in or what you'd earn. Number 2, you should have a mental health evaluation and follow any treatment. I think you've got your arms around that already.
Yes, sir.
And that's gonna be one where you just engage with your probation officer, and it may well be that they say, heck, you're receiving counseling, and so let's not go there. But if, especially if you have the kind of prescriptions you said that you've got, it may be that that's unnecessary. I just want to make sure.
It's absolutely necessary.
Okay, that we're not leaving a piece of that unaddressed. You'll need to take an anger management course. Probation can help line that up. It'll also be a condition of your probation that you continue your counseling until a counselor says, I don't need it anymore.
He says I'm good, but if you want me to keep going, I'll keep paying.
No, if your counselor says the years that Mr. Metreon has put into working through his issues, because I thought you were still going. That's what I heard Mr. Cohen say.
Yes, I was, but after the court date, I figured that would cease.
If the letter from your counselor is you're in a good space, then it can cease.
Okay.
If the counselor says, 6 more months, I defer to that subject matter expert. I don't want to impose it if he or she is saying it's not necessary. So that'll be a call to be made by the counselor or therapist, whoever you're seeing. And that is it. I will set a behavioral incentive date of May 27th, 2029. That's 3 years from now. If you have done all the things you needed to do on probation and there have been no hiccups, no arrests, nothing like that, they can close everything out 2 years early.
2 years, okay.
Yep.
Yes, sir.
And your counts all run concurrently with each other. What county do you live in?
Fulton County, Sandy Springs.
All right. Ms. Simpson, who is with probation, but who will not be your probation officer, is going to give you reporting instructions. She'll meet with you right outside the courtroom. Don't miss your first date. That's the most important one. You'll need to come to the office, introduce yourself, give them your well, actually, you'll probably give your contact information to Ms. Simpson. But once you make that connect, then your officer may be fine with phone calls or drop by every once in a while. But that initial report is the important one.
Yes, sir.
All right. Ms. Smith, anything else from the state?
No.
Mr. Cohen?
Only have a nice afternoon.
Hey, thanks. I appreciate it. Make sure you.
What's gonna happen?
So just to be clear, so am I getting charged with a felony?
Yes,
Yeah.
yes.
Okay.
All right.
Yeah.
Thanks, everyone. If you filled it out. Oh, hold on one second. I need to get a couple more things on the record. Because I got distracted. I focused on something different. And then you can get with Ms. Simpson. First, Mr. Metrion, your signature is on, you and Mr. Cohen filled out our plea of guilty form.
Yes, sir.
And you initialed next to lots of things. You had all the time you needed to talk with Mr. Cohen about the form.
Yes, sir.
And then on page 4, you signed it?
Yes.
All right, Mr. Cohen, you signed it as well? Your indictment, Mr. Metrion, can we electronically sign your name to it indicating your plea to the 3 counts?
Yes, Your Honor.
Mr. Cohen, can we sign for you?
Absolutely.
And Ms. Smith, can we sign for you? All right, based on all that, I find there is a factual basis for your plea, and that your plea is knowing, meaning you've understood what we talked about, and voluntary, meaning no one's forcing you to enter this plea, but you've decided after consulting with counsel, friends, family, whomever, that it's in your best interest to go forward with the plea. Now you can meet with Ms. Simpson.
Awesome. Thank you, Your Honor.
You're welcome.
You guys have a nice afternoon.
You too. Do you all have something you want to do? We'll take a break in a little bit. I know Mr. Rhodes needs to speak with Ms. Smith. Ms. Smith probably could just use a break period, but do we have any other final plea things we could knock? Oh, we were going to do Mr. Fortis, and this is the revocation. Mr. Hughes. Is Mr. Hughes here? He should be up. Great. Let's bring him out, please.
Thank you, Judge.
Good afternoon, Mr. Hughes.
How's it going, Judge McBurney?
All right, how's it going with you?
Hopefully better now.
We'll find out. We're going to get on the record in your case, Mr. Hughes. It's 23 SC 187106. And your lawyer, Mr. Fortis, is appearing on the screen in front of you. You can see him. He was here actually all morning.
Yes,
Not your fault that it took a while to get you from Cobb.
Yes, sir.
And then Mr. Fortis had to be elsewhere. So we're bringing everyone together. He's here virtually, you're here in person, and Ms. Smith is the prosecutor who's going to handle this revocation. Mr. Hughes, it is alleged in a arrest warrant probation warrant that I signed on March 6th of this year, that basically you disappeared. They tried to track you down, left voicemail, didn't report. They went to the address that you had put on record, which I think is Childress Drive. House was vacant, burnt. And you also haven't done anger management, any of your community service, or your substance abuse evaluation. So kind of you're batting 0 for 5 on probation, but you don't have to defend yourself quite yet. I'm just letting you know that's what the allegations are. The good news is, despite being 0 for 5, is that none of those allegations are you got arrested again. So they're not new charges, but it's one of these reports where I say, well, have you done anything with probation? Mr. Fortis, is Mr. Hughes admitting to these allegations or contesting them? What are we doing?
We're admitting with explanation, Judge.
Well, why don't you start with the explanation?
Thank you, Judge. First, the offer, which is stipulated to, assuming the court will grant that, is revoke 90 days, commuted to the time he's already served and released. And upon his release, he'll have 30 days to complete the anger management courses. Regarding some of the reporting, I was able to show Ms. Smith a video of my client actually going to probation and reporting and indicating that he's there to see his probation officer who wasn't available. There was also dialogue back and forth between my client and probation department while he was there, indicating that he had been there a few times before and that he had been unable to meet up with his probation officer at that time. There was also some evidence that was provided to me regarding family members going up there to try and meet with his probation officer as well. Specifically, his mother, after he was arrested, went up there a few times to try and, basically tell probation what was going on, that he had actually been up there. She was unsuccessful as well. So there certainly is some sort of lack of communication between probation and my client, where I don't believe the full burden lies at the heels of my client. Number two, I was able to show Ms. Smith a document that was provided by the family regarding his entry into the anger management program. So he's ready to go on that. And I think based on all of that and the circumstances surrounding that, that's why we've agreed that it would be a time served disposition.
How about community service?
My understanding is that I was under the impression through a text message that I got from his mom that it had been completed, but I would inquire of my client whether that's been completed or not.
Yes, it's been completed. We presented it to the judge 3 years ago. I actually just spoke with my other lawyer. She was back there, Ms. Rios. She's the one who presented it to the judge 3 years ago. They tried to say the same thing. I never completed my community service, which I did. And
Hi, Mr. Hughes. Mr. Hughes, that's good. So in other words, Judge, it seems like he's completed that, and that we'll get a hold of that documentation.
Yeah, Ms. Rios is
and
back
provide
there
that.
if you want to speak to her.
Okay. What about
Yeah, she's right there.
right there. What about the address that the officer goes to Childress Drive and it's a burnt out, boarded up building?
My mother's house, it just burnt down when I got out of prison. I
We
just
do
got out of
need,
prison.
Mr. Hughes, hang on. We do need to update the address, Judge.
Yeah.
So that is accurate.
I tried to do that when we reported, but they were not at the office. That's why we were referring to. I recorded myself going into the office and everything. I had video proof.
What were you doing in prison?
Hughes.
The same exact thing. They violated my probation right after that, saying I didn't do my community service, which I did, but I didn't have anyone to speak for me. That's why I hired a real lawyer this time, because it's all bad. That's why I recorded it all when I went in probation and everything.
Okay.
I had every proof of everything.
So you meaning you got revoked before?
Judge, hold on. Judge, there's been a couple of revocations prior to this one.
Yes.
Okay. Oh, I'm looking. Here's one. There was one in February of 25.
And that's one that was
By Judge Mao. You got revoked for a year.
same thing.
Failed to report, community service, anger. Wow, a year.
That's crazy, right?
No, it's tough. is
No.
tough and it
M-
clearly didn't have a big impact on you. Should we do more than a year this time to get you to do the things you need to do?
I done
Judge,
it.
I think
record-
that,
like
Mr.
I
Hughes,
recorded it.
Mr.
I have,
Hughes,
I'm
Mr.
sorry.
Hughes,
Mr. Hughes, let your lawyer do the talking. You are not setting yourself up for a good outcome.
I apologize.
I don't think you're helping yourself, Mr. Hughes, please.
Yes.
Judge, the documentation that was provided by the family with the videos and whatnot, so there has been absolute effort to report. There's been absolute effort to get into the anger management. All of that has been documented and provided. I did show the videos again, not trying to plow the same fields twice, but this is not a similar situation to the times before. And I think that just for whatever reason, that my client and the probation officer that he's assigned to, are just not seeing eye to eye, but it's on my client to make sure that he's getting this information, to her in a timely fashion. But it looks like that she's been unavailable more than she's been available. And I would ask the court to go along with the recommendation based on the documentation that I've been able to show to Ms. Smith of him, in my opinion, substantially complying with the terms and the conditions of what he's supposed to be doing.
All right. Ms. Simpson, how much time is left on probation for Mr. Hughes? Right. And I see two earlier revocations. There's the year from Judge Mao, and then I revoked Mr. Hughes for 75 days because he wasn't reporting. Seems to be a lot of blaming probation, but also Mr. Hughes not reporting. Had to go to DeKalb DCS. Was that because back in this, you and I might not have been working together back in 24, but the order was that he was to report to DeKalb DCS and provide well, he had an address. They said it was in DeKalb. Do you have anything in the system that he's bounced from DeKalb to Fulton?
They're gonna have to be in cards, going to the corrections. Because after he got out of prison, we had his case.
Okay. All right. And what is your recommendation?
3 months in state that that's he needs to update his address with us, as well as he needs to enroll and complete the anger management within the first 30 days since Mr. Forrest has advised that he has enrolled.
Seems reasonable. Ms. Smith?
Yes, Judge, the state is following the probation's recommendation. However, we are not opposed to the time being commuted to time served, only because in this case, I did receive the video footage of the defendant going to try to talk to the probation officer, also the documentation that he's tried to, where he's enrolled into the anger management course, and that he has at least on certain occasions tried to get in contact with his probation officer. I was told by Mr. Porter in this case that when the defendant went to go see the probation officer, she had a doctor's appointment one day, but she made an appointment with him, but had a doctor's appointment and did not tell him about it. And then another time he was up there, she just wasn't there. So I don't know if it's because of the relationship between him and the probation officer, but based on what I've seen, I'm okay with the commuting to time served in this case.
Okay. Ms. Simpson, what's your understanding as to when DCS made the adjustment so that if someone shows up, but their officer's not available, they still can get, I'll call it credit for showing up? Oh.
Because there are always officers in the office, so if the assigned officer is not in, there is an officer on duty, and more so, there is an assistant chief that is also on duty that can handle recording.
Okay, and could register into the system, hey, Reginald Hughes was here. His officer wasn't, Melniquan Jackson wasn't, but that's all right. We'll make a note of it and they'll connect some other time. Okay. All right. Mr. Hughes, anything else you want to add?
I did my best. I haven't did anything wrong. I tried my best to report. I documented everything.
Mr. Hughes.
I did everything.
Mr. Hughes.
I didn't.
Well, what I'm going to do, Mr. Hughes, is revoke 3 months of your probation. You'll get credit for the 41 days you've been in, so you're over a third of the way through. I will reinstate your balance, and when you get out, you need to complete the anger management course within the first month of being out.
Yes, sir.
All right, not just sign up for it, but complete it.
Yes, sir.
Judge, are you going to commute that to the time served?
I'll get to that in a minute. Yes, Ms.
Okay.
Simpson? Yeah, I'm gonna get to that. So you got a month to do the anger management. It sounds like somewhere you've got paperwork that you did the 80 hours of community service?
Yes, everyone has proof of it.
Well, you say everybody has it. Ms. Simpson is with probation and she's saying she can't find that.
When I tried to take it to my probation office, she was not
Mr.
there.
Hughes, Mr. Hughes.
I'm sorry.
So do you still have the paperwork?
Yes, everyone, yes.
Well, you say everyone. Who's everyone?
My lawyer has it.
Great.
Ms. Rios probably still has it. Like everyone has it.
Okay. Do you have it?
I have a copy at home.
Good. Okay. You don't need to have it on you, but within that first month, when you get out, you're going to take anger management. You're also going to submit the proof of the community service. So we can either say, this is bogus, you didn't do it, or yep, you did. And we'll cross that off so it doesn't keep following you around. It's going to keep dogging you until you actually hand it to someone from probation.
Yes, sir.
So that takes care of that. What about the substance abuse evaluation? That's on the warrant as well. You're going to have a busy first month when you get out.
Yes, sir.
Okay. So, 4 things. Good address.
Yes, sir.
Wherever it is you're staying. It's in Fulton County?
Yes, sir.
Okay. So good address, not Childress Drive. I hope, is your grandmother okay?
She stays with my father now. He stays at 105.
All right. She wasn't hurt in the house fire.
No, no one was hurt.
Okay.
No, she's
Good.
okay.
So good address where you're going to be staying. You got 1 month to complete anger management. You got 1 month to prove up that you did the community service. If you can't, then you got to finish that community service within 6 months of your release. And you've also got within that first month, you do your substance abuse evaluation.
Yes, sir.
Probation will tell you where you need to go for that. I am not commuting to time served. Judges can't actually commute, but I'm not going to reduce it to time served based on our lengthy discussion, your explanations of what's been going on, and the fact that this is your 3rd revocation since you've been on this sentence, under this sentence. So it's not a year like Judge Mao. It's not 75 days like the first time you and I did business, but it is 3 months. But you do get credit for the time that you've done. And my hope is, this is it, that you're going to check those boxes. Here's the community service. I did my eval. Here's anger management, and here's an address. Okay?
Sir.
All right. Keep filming things.
Put everything on Instagram.
Judge, let me ask the court this. Mr. Hughes, do you know what your physical
The physical address as of right now, you can put 105. I can put my dad's address, 105 Middle Lake Road.
Well, Ms. Simpson can talk to you about that. She'll write that down.
All right.
Okay?
All right.
That's in Fulton County?
That's in Fulton County.
And that's where you'll be? Because, I mean, you can give them my address. That's not where you're going to be. That doesn't count. It's got to be a place where you're going to be.
That's where my grandma is right now. That's where everyone is since her house burned down.
Okay. And so that's where you, when you get out, that's where you'll stay?
That's where I'll be.
So if probation is knocking, I'm just trying to protect you, because if they knock and your dad said, Reginald hasn't been here in 6 months, boom, it's a warrant. And no matter what Fortis says, we're back into the Mao year stratosphere.
Yes, sir.
Okay. All right.
and Judge, let me ask this. Would the court, because you're not going to commute it to the time served, or whatever the proper language would be for the court, would the court be inclined to make it 60 days as opposed to 90 days? Because the intent of myself, Ms. Smith, and probation was for that Mr. Hughes would be released today. And this time, which is different, I guess, than the last times, because we actually provided, evidence of this information. So it wasn't any negligence on his part of not being, of not trying to complete everything, not trying to report, not registering and starting the evaluations. So it's a little different this time. And the intent was for him to get released. So I would ask the court, if you're not inclined to do that, would you at least shave 30 days off?
So, what you and your client didn't address was the substance abuse evaluation. That's just been a complete no-go flub. I appreciate that he eventually enrolled in anger management. That was supposed to happen 2 years ago. So there's a little bit that is coming awfully late to say, hey, give me credit for this thing I did 2 years late. It may be the community service he tackled a long time ago. And I'm saying, great, prove that up. And the address, I'm understanding a little bit because his grandmother's house burnt down, but it wasn't updated in the system. And so I say net, given that this is his third, not his first or his second revocation, we are at a good spot.
All right, thank you, Judge.
You're welcome. Thank you for dialing in. Good luck, Mr. Hughes.
I still do it. This perfect time. Thank you.
All right. All right, thank you, Judge. It's good to see you again.
All right, take care. Wow. Well, then I got a real lawyer.
I was like, what? Then I did good. It was like, then I got a real lawyer.
Yep. Oh, well. So do you have anyone out in the gallery left?
I do. I have two, please.
Okay. Could we take care of the gentleman in the neck brace? I'd love to get him on his way. Remind me, is this Mr. Barber?
This is Mr. Reeves.
Mr. Reeves. Oh, you definitely sit. We just need to get you over to council table. There's Mr. Reeves. Okay. And then we'll take a break after this plea to talk with Mr. Rhodes. This is number 4. Reeves. You all right?
Kill him. Yeah.
Sorry about that. No, you're good. Right? As long as Ms. Rivers can hear you while you're talking, you're good. Okay? All right. You ready? Okay. This is position 4 on our final plea calendar, State versus Reeves, 24 SC 005 345. Mr. Reeves is here in court with his lawyer, Ms. Rios. Ms. Smith is here for the state. And Mr. Reeves, you ready to enter a plea? Yes? You don't have to. I need to know that Ms. Rios told me that's what you were doing. Okay. Ms. Smith is going to put you under oath in just a moment and then ask you a bunch of questions. Please answer those questions truthfully and completely. And also let me know if you've got any questions. Will you do that? Okay, let's roll.
Aggravated assault is going to be reduced to reckless conduct. OCPA 16560.
16,560. Okay, so Mr. Reeves, it's still a plea, but it's to a misdemeanor. Okay.
Mr. Reeves, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do my best ability.
Please state your true, correct, and legal name for the court.
Nicholas Canterbury.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine? Is there any medication that you would normally take that you haven't been given today? How old are you and how far have you gone in school?
I'm 47 and I'm in 12th grade.
Did you graduate? Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charge in this indictment? Do you need more time to discuss your case with your attorney? And are you satisfied with her services? Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Yes.
Mr. Reeves, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 12-month probation?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and can sentence you to the maximum on this charge?
Yes, ma'am.
Do you understand that this is a Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today? Are you a United States citizen? Okay. Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty? Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present your own evidence and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
Yes.
Mr. Reeves, has anyone forced, threatened, or promised you anything to get you to enter into this plea today? As to indictment number 24 SC 005345, how do you plead to the reduced count of count 1, reckless conduct? Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
It was my best option for yes.
Do you understand that you do not have a direct right to appeal from your guilty plea? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. Do you understand that that process must be completed within 30 days from today? Do you understand that you have only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
You know the other word was, but yes, ma'am.
I can repeat it. I want to make sure you can hear it. Do you understand that you have only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
What you mean by heavy really?
Right.
So, Mr. Reeves, there are two ways you can challenge your conviction if you decide later on, wait, something was wrong. One is what we call a direct appeal, where you or a lawyer helping you would challenge some decision I made or maybe something the prosecutor did. you've got a pretty small window in which to do that. But you have the right to counsel to help with that. There's also something that we call a collateral attack, where you bring a civil lawsuit. It's actually a civil lawsuit, and we don't provide a lawyer for that. You can hire one if you want to, but it's another way to challenge your conviction, where you could say there was a mistake made, your sentence was illegal, something like that. You've got a little more time to bring that, they call it a habeas challenge, a civil case, and that clock doesn't start running until you would have exhausted all your direct appeals. I don't think you're going to appeal anything, but Ms. Smith needs to let you know that you've got both this direct appeal, which is a criminal case still, or this habeas, which is where you're basically almost suing, saying, hey, you need to throw this out.
Okay, thanks for understanding. Yes, I understand.
Okay, thank you.
Yes, ma'am.
Your Honor, this case were to proceed to trial, facts would show that on February 7th, 2021, Hateville police officers responded to 397 North Central Avenue. That's the Uptown Comedy Club at that time. The officers got there on a report of a person stabbed. When the officers got there, they spoke with Anthony Waddell, the victim in this case, who was stabbed in the hand. He told the officers that he was working as a DJ at this Uptown Comedy Club when there was a fight. The two people involved in that fight was a security guard, Mr. Moreau, and also the defendant. This fight started on one side of the club and made its way toward the DJ booth. And at this time, Mr. Waddell tried to get out of the way. But when he tried to get out of the way, at that time, the defendant had a knife in his hand. I want to say, I don't know if it was a pocket knife, just a knife that he was using on Mr. Moreau. And while he was trying to use it on Mr. Moreau, to my understanding, to protect himself, because the security guard was trying to attack him with brass knuckles or whatever that is. But when the defendant tried to defend himself with a knife, Mr. Waddell in that process got stabbed in the hand. The officers responded. The defendant was not on the scene at that time. He was not arrested until, I believe, like 2 years later. However, this all occurred in Fulton County. After that, officers took statements, and nothing really happened until, like I said, 2 years later when Mr. Reeves was arrested. I did get a chance to speak with the victim in this case, Mr. Waddell, and he told me that he still has pains in his hand, even though it's been a while ago. He said that he was okay with the reduction in this case because it happened so long ago. That comedy club is no longer at that location. They've moved. However, he would like no contact with the victim. He did tell me that the defendant in this case dated one of the waitresses that worked at the Uptown Comedy Club. So after the incident happened, he did see the defendant, but I don't think they spoke, and I also don't think it was an altercation or anything like that. The victim just wants the defendant to be held accountable, but he is okay with this reduction. The thing that he's worried about the most is just not having any contact with the defendant, and also just that pain that he still has in his hand. But other than that, those are the facts of the case and my victim contact regarding the negotiated offer from the state, and what defense has agreed to is 12 months probation for the defendant to stay away from the incident location. However, the Uptown Comedy Club isn't there anymore, so I would like to say to stay away from the Uptown Comedy Club, whatever that new location is. I can get that from the victim because it's my understanding that the victim still works there or is there frequently. Also, for there to be no contact with the victim in this case, and for the defendant to complete an anger management course. And that is all from the state.
Got it. Thank you. Ms. Smith-Mann, criminal history information on Mr. Reeves.
Yes, Your Honor. There are 22 prior cycles in Georgia, 1 in Alabama. Last arrest was 2/9/26, Fulton County, FTA. There is 2 felony convictions, 04, forgery and theft by taken. Open arrest, it looks like 5/18/24. It does not tell me for what that one is for, Your Honor. And there are several probation violations that is past the 10 years that pretrial will look at. Not sure if probation has something that would be more current for you. Nothing further, Your Honor.
Thank you. Ms. Simpson, is Mr. Reeves on probation now? No? Okay. Ms. Rios?
Yes, sir. Mr. Reeves is 47 years old. He's a life resident of Georgia. He has a wife who's here today, and they have a 2-year-old child. He is on disability because he fell from a ladder, I think 13 feet from a ladder. And while he was working at Lenox Mall, he was working for a master's electrician. As far as this case goes, the person so it was a man that I guess believed owed him some money or something, came up from behind with brass knuckles and hit him in the back of the head. Discombobulated him. He started fighting. But initially that's why I filed an immunity motion when I was able to get more information about the case, because I understand it would have been transferred immunity, but that's what he didn't mean to hurt the victim in the case. It was because he was initially attacked. And I think that consideration is also why the reduction was made. So I'm just asking that you accept the plea as negotiated and also waive the fees, the probation fees for right now, since he's on disability and they have a 2-year-old child they pay for daycare for, and finances are a little hard right now.
Mr. Reeves, when did you have the fall?
Last year, I did it, excuse me, just in November
Of last year. So after your child was born.
my baby was already born.
Right. Okay. And is the prognosis that you will recover, or is this a permanent disability? Neck, and I noticed you got a brace on your leg, also your leg.
Like I'm a certified electrician, so I can't even do my trade anymore. And like I don't like to talk about it because I gotta find a whole nother type of work to get into.
Okay. Well, I won't make you talk about it anymore. Does your wife work?
Yes, sir.
What does she do?
She work at Toyota, but I don't like ask her her business.
Okay. I'm not trying to pry either, but I'm just wanting to make sure your household has some income. You get disability, your wife has a top secret job at Toyota.
It ain't that, as a guy, ask her, but she is having a hard time, and then, when your woman make more than you now, that kind of.
That's been my situation for the last 12 years of my life, but I'm all right with that. So, okay. Anything more you want to add?
No, sir, I'm pretty much happy with everything that's going on, and I just want to get to my baby.
Boy or girl?
She's a girl, and she runs.
What's her name?
Her name Dream Alani Reeves.
Dream.
If I call her Mikey Baki Rocky.
Okay. I won't have you spell that. So Mr. Reeves, I find there's a factual basis for your plea. I appreciate some other guy hit you first. You pulled out a knife, and unfortunately, Mr. Waddell got caught in the middle. I also find that your plea is knowing, meaning you've understood what we were talking about. And when you didn't, you did what I asked you to do, which is, what's a habeas? You said, I have a question, and we did our best to answer it. And your plea is voluntary, meaning no one's forcing you to enter the plea. You've already told us you're doing this because you think it's the right way forward. So I will accept your plea. Ms. Rios, can someone in my office sign the indictment for you? Ms. Smith?
Yes.
And Mr. Reeves, can we sign it for you indicating your misdemeanor plea?
Yes. The anger management stuff, how do I do that? I'm not even mad about nothing. Okay.
We'll get to that in a sec.
Yes, sir.
And it's not a requirement that you show up angry. That's probably a bad plan. Like, they don't calm you down. They help you work through situations so that if something happens, like you're frustrated because you can't be an electrician anymore, how to manage your frustration about that so you don't take it out on others.
Just simply look at my little girl, and I'm an old man now, so I don't have time to be mad.
Okay, well, then anger management is going to be easy. Maybe you'll end up teaching it, okay?
Oh.
All right, so you're pleading to reckless conduct. You have 12 months probation. Special condition number 1, no contact with Anthony Waddell. Don't call him, write him, look him up online, anything like that. Also, you need to stay away from the Uptown Comedy Club, wherever that is now. It sounds like it's moved, but don't say, hey, secret wife from Toyota, we're going to go to the comedy club. You go somewhere else, okay?
Yes, sir.
All right, and you will need to complete an anger management course. It's one class, probation will help you find it. And I will waive your probation supervision fees, unless you magically get off disability. If 6 months from now, you're back as an electrician making good money, then you'll pay your probation supervision fees. If not, then we'll keep waiving them, all right?
Yes, sir.
Ms. Rios, anything else? Will you get to Ms. Nelson all the information for the, look at that, excellent. Mr. Reeves, you will get a call or an email from misdemeanor probation, and they're gonna let you know how to report the first time. Don't miss that initial appearance, okay?
Wait for them to call and talk.
I think that's right. I don't think you reach out to them. They will reach out to you, okay?
Yeah.
You do, and if they leave a voicemail, you need to call them back.
Can that be my fiance?
They have the contact, her contact rate.
Yeah, put her number because I don't talk on the phone and stuff, so I know if they call and if not.
You can put any number that's gonna work out and we'll get that info to you. So if that is your wife or fiance, you just changed her status. You guys married or not married?
Well, common law marriage, so she's my wife in my eyes, so
Okay. You're gonna ever do it in the Lord's eyes or it's just gonna be your eyes?
she runs the household.
Okay, it's her call. Okay. Well, I wouldn't read into that she don't want to marry you, but okay. Ms. Smith, anything else? Okay. All right, Mr. Reeves, have your wife look out for that call, and make sure you reconnect with them.
I'm checking up. Thank you so much. Yeah.
Good luck with everything.
All right, brothers.
Ms. Smith.
To court, could we do the final plea hearing for Alex Blue? I have
Yeah, of course. Yeah. I would giving you the break. So if you want to knock one more out, can we do?
But actually did tell him.
Oh, okay. All right. And Alex Blue is in custody? Okay.
She passed it?
We can bring Mr. Blue out. All right. Is it the same victim in both cases?
Well, hold on. And there's a third case, Judge.
Third
that's been
case.
indicted. That's a fleeing. Hold on, I'm trying to remember. Because the fleeing is related to the position 13.
Okay. All right. Let's get on the record and I can remove that. So these are positions 12 and 13 on our final plea calendar. Both involve Mr. Blue. Hello, Mr. Blue. I'm all right. 25 SC 007931 and 26 SC 000028. Mr. Blue, in the older case, the 25 SC, you're charged with aggravated assault, possession of a firearm. And in the 26 SC case, you've got 6 counts of aggravated assault, some more firearms possession charges, and reckless conduct. Ms. Wood mentioned to me that there's actually a third case rattling around out there. It's not indicted yet, but it relates somehow to the case with all the aggravated assault charges. That's not what we're here to talk about today, but it's good for all of us to know there's another piece out there. Do you feel, Ms. Wood, as you've looked at discovery, that you've got all the main materials out there for the 2 indicted cases?
So I think that I have everything that Ms. Smith has. Like I said, the unindicted case is, I think it happened like a day after. It's like very closely related. So some of the cameras that the police department turned over to the state are from the unindicted case, even though, because it's all related, like I said. There's a couple of things that I think might still be out there, but I'm gonna try to get it if Ms. Smith doesn't already have it.
Okay.
It's like there's surveillance cameras or anything like that.
Okay. It's not suppressible things. It's things that everyone would want, but it's not you're not missing your client's statement or something like that, that you're aware of.
Correct.
Okay. All right. Okay. What is the state's offer to resolve these cases combined?
Fire today is 15, serve 10, balance probated.
All right. So, Mr. Blue, if you were to enter pleas today in both these cases, the state would recommend that I sentence you to 10 years in custody, followed by 5 years on probation. That would resolve both the cases. Do you feel like you understand what the state's recommendation is?
I hope I understand, sir. Yes, sir.
Okay. Ms. Wood would be free to advocate for a different sentence. If I were to sentence you to more than what Ms. Wood advocated for, I'm gonna make something up. Maybe she said, no, it should be 3 years to serve. And I were to say, you know, as I hear all this information, I'm gonna make it 8 years to serve. If I were to sentence you to any more than what Ms. Wood asked for, today you could withdraw your plea. You could say, nope, I was willing to do this thing. You gave me something different. No thanks. No questions asked. All right, great. We'll see you for trial because you are on the June 16th trial calendar. After. Oh, I didn't know that. Okay. For count 2 in the 25 SC? Okay. You didn't charge him with possession by a felon as well. Okay. So got it. You've got a mandatory minimum of 10 years to serve for one of the counts in there. So this notion of Ms. Wood asking for 3 years, she could ask for that, but that would be an illegal sentence on my part to go below that, unless the state dismisses the count. But if they go forward with the count, it's a 10-year to serve sentence.
What charge is that?
Is that the possession? Because it's a subsequent conviction for him. He already has one of that. So Ms. Smith believes, and this would all have to be proven up, Mr. Blue, but Ms. Smith believes that you already been convicted of the crime of possession of a firearm during commission of a felony. If you have, second time around, it's 10 years to serve. So you know your criminal history better than I do.
Yeah, but
If you haven't been convicted of that before, then it's a different situation. But it sounds like to me, I don't want us to get wrapped around the axle on this. It sounds like you're not interested in the state's offer. You're kind of mumbling. I can't,
You're not interested in pleading today, correct?
oh no,
pardon me?
no.
No,
sir.
okay. Then what we're gonna do is move your case to the trial calendar. The state's offer, you heard Ms. Smith say it, of 15 to serve 10 was good for today only. They may bring it back, but she's letting you know that it expires today. Maybe she renews it at that level. She might come back and say, now it's 15 to serve. She may come back and say, "Eesh, we've learned more about the case. We're gonna drop that count with the 10-year mandatory minimum, and then you could get some traction at getting below 10 years to serve." But that's all on the state. There's nothing you can compel them to do, and I won't be saying, well, you offered this before, so you have to do it again, okay?
Yes, sir.
Any questions about anything?
Just need my discovery, that's it, so.
Okay. Ms. Wood is able to get to you soon. Paper discovery, if she's got paper discovery. If most of what she has is videos and things like that, she can't really send that to you because you can't do anything with a DVD or a thumb drive. You're not allowed to have them in your cell anyway. But you two should talk, and if it's important for you to review some of that, I can sign an order that allows Ms. Wood or her investigator to bring a laptop into the jail, and then they can play it, you can look at it, and they can say, whoa, what's that? You can tell them what you see there or whatever, okay? Ms. Wood is very good about doing those things, especially as a trial date approaches. That's likely something that'll happen soon. Ms. Wood, anything else on behalf of Mr. Blue?
No, Judge, thank you.
One of you mentioned, I think Ms. Smith, you mentioned that maybe on the call, although that person must have dropped off. Oh, in person, okay. Someone who is interested in this case is here.
Yes.
Okay, great, excellent.
Leave it possible for the court, the victim would like to be heard. I'm not sure, but I'm just offering.
So I never want to say no, but we aren't resolving anything today. So raise your hand if you're one of the victims. Bunch of you, okay. Let me explain how it will work. If at some point Mr. Blue decides he wants to enter a plea, then it will be important that I hear from each of you while you share with me what you think should happen. You're entitled to do that. I want to hear it. It's always more impactful than if I hear from Ms. Smith, not because she's not eloquent, but she didn't live through it. And so she's reading from a police report. If there's a trial, you're going to testify. So it's going to be one of those two things. Trial date, the call of the calendar is on June 16th. Mr. Blue will be back here. If between now and then he decides he wants to enter a plea, you'll get notice of that date. If you can be here in person, you can speak in person. If it is more convenient to appear through Zoom, I'm fine seeing you and hearing you through Zoom. Today, because I'm not changing Mr. Blue's status, I'm not giving him a bond, I'm not taking his plea, there's really not a role for us to be interacting. Other than that, you're always entitled to be in court when the case in which you're a victim is being heard. Okay? All right. Thank you, Ms. Smith. Mr. Blue, we will see you on June 16th if you don't sort the case out before then.
Thank you, Judge.
Now let's take a break. Mr. Rhodes is still here. So during your break, if you don't mind chatting with him, we've got Willingham and Lopez and Brown and we got a lot of people.
For Victor Brown, his mom and him are here, and they're waiting on a ride. So soon after the break, if possible, can we take his plea?
Yeah, we'll do that right after. Who are you here for? All right, we got it. Oh, that's what, so Mr. Rhodes is trying to talk to the, yeah. He's at the South Annex. Is he young? Okay, that's why he's at the South Annex. Blue doesn't seem to like any of his options. I'll be back in a few minutes.
Yes. Woman died on the was awful. Yeah. So I think it's a lot. Yeah.
How old was he?
Hey, Lewis is, you got a car to get him real quick. Is he staying or need me taking out Lewis?
I don't know who Lewis is. Hasn't Lewis here. Yeah, he can go down. There you go. Thank you.
What should you do with Lewis?
Lewis, it's just, it goes to the next court date.
Okay.
Yes, yes. You're welcome.
I feel it's funny when that older attorney guy was like talking to me about her nails.
Oh, I missed that. Did you see trap? I'm just having the worst time people get together. Which one? That one? No.
Which
no, I
one?
missed it.
Mr. Oh, he wasn't. No, I was. He just kept bringing me into it because he kept being like, Miss Rios, I gave Miss Rios a date. So this was 3 years ago.
And then,
3 years, you're the probation. I think.
I was so, it's like, why are you doing that?
I was like, I got nothing to do with you. Okay, you hired.
Right.
I know, that's why I was like, why am I catching a stray right now? And yeah, it was 3 years ago. I actually do remember giving him the community service, and I think you did let it go when I gave it to you, or something happened with that. But I don't physically have it. That was 3 years ago. No, I was like, bruh, what's this got to do with me?
Right.
I was just a person who just always saying, oh, talking about or whatever. I think I got messed up someone's birthday once, or someone's like I had like hit her like 5 years, and I said 7. They should know shit. I was like, wait, there's so much.
Was fantastic.
And he was kept looking back on Mr. Rios, and he was like, he didn't realize what was behind him.
I missed it.
He didn't realize what was behind him, so he kept saying it.
I had to go sit down. This was stressing me out.
And he finally turned around, there she is. There she is. I was like, Oh my God. You have a whole attorney in front of you. Like, why are you talking to Okay. So she probably still got it. And I'm like, wait, that do not still have it. Because I did not say. Oh my gosh. But he had other like violations too. It wasn't just that. So it was like that wasn't gonna like it's too much.
That was hilarious.
I didn't understand.
Yeah. Right. Yeah. Hey, I didn't say her. Right. Hey. Yeah, my job.
But they're also promising to that too. Like, I'm sure you heard with my client, because he didn't remember talking about anger management. And he was like, I remember you about that condition. I was like, you talked about it. We actually talked about it last night. And he was like, oh, I'm sorry. I was like, no, but I think he meant on his pharmaceutical drugs, to be fair. He's on so many medications for his like
What happened to him?
fell off the ladder.
I missed that part. I think that's when
Because he was working out when he's doing like something when he was high and he like fell. That's why he has a neck brace.
Yes. Oh yeah, I remember that.
Yeah.
I was born here with. Oh my.
Yeah. So he's on disability. Or he says he don't know if he'll ever like fully recover. I don't know.
What did he do?
12 months misdemeanor probation.
Okay.
Because he was like, to be fair, 'cause I filed them. That's when I asked about the muni motion because I filed came up behind with brass knuckles.
Oh, that's the one.
And he like was chasing him around, but accidentally stabbed the wrong person. The other person was just in the way. The other guy said, yeah, the other guy started it. So brass knuckles, I'm sure, really, really hurt too. Like
That's
me, he was justified.
you say my man.
So like I filed it, and then Leah was just like, I'll just reduce.
Much.
And then I got 2 other pleas.
Today?
Yeah.
Excuse me.
I do. I have Jamario Brown. Well, Jamario Brown we're for sure doing. I guess he could be moved to, well, no, what do we have? We don't have court tomorrow.
We have court Thursday. I moved on. Wait a minute. I gotta tell them.
Oh, you do?
It's
What?
It's private.
Oh, yeah, because I'm on duty
Yeah,
tomorrow.
yeah.
But
It's,
these 2 people are in custody, so if he wants to take this, and then we'll have to reset Mr. Barber and Mr. Battle, but yeah. But
yeah, no, there's a calendar for just, it's that, White Coffee.
Oh, okay.
Is there, drug court? Yeah. Okay. And that's why, because that's probably gonna be a long day.
What to a white collar?
Whatever. It's the.
Oh, yeah, the one I have, got the private attorney.
Yeah.
Yeah.
It's, yeah.
Yeah. I wonder if we're gonna go, because they won it 7 years. Well, did Wilton win? Oh,
It's like 3.
yeah. Gosh. One's her mom and it's another relative, but yeah, the offer was 7 years. I guess she thought like if I hire her, it would be less. But Will Wilton was pretty strict.
I'm sorry. No, you're not. This really would like to speak with you. Really? Yes.
Who you with the modern Brown, that's the term.
Brown.
You probation lady.
Yes.
Oh, you just want to talk about probation ahead of time?
Everything.
Oh, you want to do the paperwork now?
There's gonna be a probation.
Yeah, you might as well talk to her now while we're waiting. Yeah. Jamarian Brown. Yeah, what did I say? It's
Jamar.
Jamarian.
It's Jamar and Jamar.
Jamar. I'm saying it wrong the whole time. Jamar. You never correct me.
You know, his mom was moving to Texas, so.
Yeah, I was
He
gonna,
is. He
oh,
got a
like
job waiting on.
Miss Simpson. So he eventually, well, soon as possible, would like to go back to Texas because he has a job waiting on him. How long would that take?
Well, y'all know y'all got seventies, I had cases.
I mean, his mom is here right now, but like he did.
I'm a grandmother.
Oh, your grandmother. Oh, yeah.
Everybody
you was
fed.
Per policy, I have to tell you 45 days, but once he reports for his intake,
Cause his
Oh.
mom is moving too, all of
when,
soon as possible. She got a house and everything.
okay, so
But the problem is, they're not just gonna take him without permission, you know,
exactly.
cause they don't want him to
So
go to trouble.
policy states I have to tell you 45 days. Tell you 45 days.
Cause the job
You have
paying
to- you have to be here.
$25,000.
You need to plan to be here for 45 days. Because we have to transfer the case to Texas and Texas has to tell us, yeah, we'll take the case.
Mm,
Because if they don't, you have to stay here.
mm.
So it's 45 days. Do not leave without your officer saying, yeah, you can leave. Okay? Make sure whenever, if your mom already has the address and all of that, it would be helpful to you to go ahead and provide that information to your officer. So that you can say, hey, I know I'm here, but I'm planning on moving with my mom within as soon as possible. And if you want, how soon is she moving?
Sure, I think that my ready, she told me to find out what's going on here, cause he got a job paying 20, he had the job before.
Does he have somewhere to stay here? In Georgia?
Yes.
You do? For at least a month and a half? But why don't you make it out constantly?
How do we, they say it's gonna be a transfer?
Yeah, so
Okay.
at least he'll be on probation, but that transfer process will have started.
Okay.
If you already have your mother's new
have
prospective
the
address.
Yeah, he got it.
Okay, why don't you
Okay.
text it to me? Text me the address. And then I think who do I email with everything?
I need the police report.
Okay, so I'm gonna email you the police report. And what
then
else?
I'll get the,
You just need the police report? Okay. I can send that.
I'll get the business from Ms. Nelson.
Okay.
Thank you.
Do you mind getting Miss Smith? Thank you. Ms. Wood, is Mr. Lopez a final plea?
Yes.
Okay. Is he getting Mr. Brown? I don't know where the other deputy went. Oh, Brown's right here. Oh, excellent. I thought they were here to watch Mr. Brown come on out. Come on up, Mr. Brown. Brown's right here. Do you need help finding him? He's number 3. You bet. Ready? Okay. Ms. Rivers, you ready? Okay, we're on the record with position 3, 24 SC 005337. State versus Brown. Mr. Brown is in court with his whispering lawyer, Ms. Rios. The state's represented by Ms. Smith. Good afternoon, Mr. Brown.
Good afternoon.
How you doing?
Good. Can't complain.
How old are you?
21.
21. All right. You ready to enter a plea?
Yes.
Okay. Ms. Smith's going to put you under oath, ask you a bunch of questions. If any of the questions don't make sense to you or confuse you, will you let me know?
Yes, sir.
Okay. Make sure you answer the questions to the best of your ability. Ms. Smith?
Mr. Brown, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Jamira Marquise Brown.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 21 and I went to the 11th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defense in the indictment for the purposes of this plea?
Yes.
Mr. Brown, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No.
No, ma'am.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years to serve 4 months with the balance probated?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to obtain a passport, the right to serve on a jury, or the ability to obtain employment.
Yes, ma'am.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, ma'am.
Have you ever pleaded guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, ma'am.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No, ma'am.
Has your lawyer explained what First Offender Act is?
Yes, ma'am.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after your trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea, Mr. Brown?
No, ma'am.
And is it your decision to waive these rights we just talked about and enter a guilty plea because you are in fact guilty?
I'm guilty under Alfred.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes, ma'am.
And are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes, ma'am.
As to indictment number 24 SC 005337, how do you plead to count 1, terroristic threats and acts, count 2, terroristic threats and acts, count 3, criminal use of an article with altered ID mark, and count 4, willful obstruction of law enforcement officers?
I'm guilty under Alfred.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to directly appeal from your guilty plea conviction? But if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you understand that that process must be completed within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, Mr. Brown. Your Honor, if this case were to proceed to trial, the state would show and the facts would show that on July 20th, 2023, officers of the Atlanta Police Department responded to 610 Spring Street Northwest, Atlanta, Georgia. That's also in Fulton County. When the officers got there, they were first responding to an armed person call. When the officers got there, they were able to speak with the victim, Mr. Lewis Kafour. That's Lewis. Last name is Kuffour. The victim told the officers that there was a person that he got into a verbal altercation with that then started showing that he possessed a firearm and was telling him that he would kill him. And the person that when the officers got there, they did locate the defendant on the scene. When they tried to detain the victim and place him under arrest, he started to resist and he reached at his waistband a couple of times. However, the officers were able to detain him, put him in handcuffs, and a black firearm fell out of the possession of Mr. Brown once they detained him. Mr. Brown was then placed under arrest for the charges that we have before us. Those are the facts of the case regarding the negotiated plea between the state and defense. We've agreed to a sentence of 5 years to serve 4 months for counts 1 through 3 that are all felonies. And for count 4, that misdemeanor charge, we've agreed to 4 months to serve, all counts to run concurrent. Regarding the special conditions of probation, we're asking for the defendant to not have contact with either of the victims. There are 2 victims in this case. For the defendant to stay away from the incident location. Is my understanding that it's some type of convenience store. We're also asking for the defendant to get his GED and also for the defendant to commit an anger management course and 40 hours of community service. I was able to speak with both victims in the case, Mr. Kapoor and also Kentasha Arrington. Initially, we referred this case to diversion. They were okay with the case going to diversion because they understood that Mr. Brown was young. They felt like he needed to learn from his mistake, and they felt like diversion was a good option. Mr. Brown was rejected from diversion. And when I called back with the new plea terms, they were okay with that, with there being no additional custodial time. They just really wanted the defendant in this case to learn from what he done. And because it happened so long ago, they weren't as upset as they were back in 2023. However, Mr. Kafour said the bigger lesson that should be learned here is that when you're dealing with firearms, it could go either way, and it could have went either way that day. And he just wants the defendant in this case to learn from what he's done. But that's all from the state, Your Honor.
I got all the conditions of probation and I got the 4 months to serve. I missed, because I was writing some other things down, what the probation term is.
Yes, 5 years to serve, 4 months, balance probated.
Got it. And all 3 of the felonies 5 years to serve falls within the range.
Yes.
And then count 4 would just be 4 months to serve.
Yes.
Got it. Okay. Ms. Smith-Mann, do you have any criminal history information on Mr. Brown?
Your Honor, there are 3 prior convictions. Last arrest was 2/25/26 DeKalb County, FTA battery, family violence. There are 2 failure to appears in 25 and 26, Your Honor. No further, nothing else further, Your Honor.
What's the most recent conviction?
The most recent conviction, okay, let's see.
Because he's only 21 years old, so I'm trying to figure
Right.
out.
Okay, here we go, right here. I am trying to pull that back up. There are no felony convictions, so I'll be looking for misdemeanors.
Okay, I
There's
thought
no
you
felony.
started by saying he's got 3 convictions and an FDA.
3 cycles, Your Honor, I'm sorry.
3
If I did say
cycles.
convictions, let me correct that to cycles.
Okay, that's a much
We're going
happier
to
picture.
we're going to convictions. I'm sorry, we're not there yet.
Okay, got it. 3 cycles. Understood. Okay. Ms. Rios.
Yes, Your Honor. Mr. Brown is 21 years old. He's lived in the Atlanta area for about 6 or 7 years. His mother and his grandmother lived here too, but his mother is moving to Texas. He was in Texas for a while doing a job, working on solar panels. I believe he referred to as throwing solar panels. And so he has a job waiting for him there. His grandmother, who's here with him, has been waiting patiently, said it was $25 an hour. So a really, really
25.
Yeah, 25. So it's a really good job opportunity. We spoke with probation. We're going to get that transfer going so he can go there. But he said he was in school getting his GED, so he plans on going back to school, finishing that up and working on the solar panels. I'm asking for a behavioral incentive date of 2 years. Since this is a first offender and he doesn't have an extensive criminal history, and he seems to be on the right track by having a job lined up and to be going back to finish his education. And he has a supportive grandmother and mom. And this case, like the state said, was 3 years ago. He was taken in under Alford because he said there was an altercation. The guy was mad because he didn't hold up the door. He did not pull out a gun. Understand, we're not contesting the obstruction. But he disagrees on how the police report was written.
Okay.
Oh, and I was asked you to accept the negotiated plea.
And is Mr. Brown seeking first offender?
Yes, sir.
Okay. Any objection to that from the state? All right. Mr. Brown, where will you stay in Georgia while you try to get, are you trying to move to Texas so you can work there, or you just want to work in Texas, but you'd live in Georgia?
I live in Georgia, but I have plans on moving to Texas.
Okay. You can do that, but you have to get your probation transferred first. So you have a place to stay in Georgia.
Yes.
Is that with your mom?
Yes.
Okay, so grandma's in Texas.
No, my grandma live out here.
Oh, grandma is here also. Right, I know who you, I saw, but I thought someone was
He's
in,
moving to Texas.
oh, grandmother is
On him.
Yeah.
Is honest.
Okay, so I'll ignore your lawyer. Your mom is moving to Texas.
Yes.
Got it. And you would like to move with her and throw solar for 25 an hour?
Yes.
All right. You understand you can't move until you can get your probation transferred.
Yes.
But this is going to seem like, wait, it's not fair. You need to have an address in Texas you're going to. You can't just say, I don't move to Texas somewhere. Okay. You got a plan. That's good. Do you have kids?
No, not yet.
Not yet. That's good too. Did Ms. Rios talk to you about first offender?
Yes.
You understand that first offender is primarily a benefit. You qualify for it. It means this is not a conviction. So if you're applying for a job, going to school, you don't have to check that box that says, I'm a convicted felon, because you're not. But it has a risk. You, while you are under sentence, need to stay out of trouble. If you don't, not only would you have new charges, but I could revoke your first offender status and sentence you to the maximum in this case, which if I stacked all the charges, could be a whole bunch of time. I'm not saying that I would sentence you to the max, but you'd come in here and there'd be a pretty simple hearing for the state. All they need to show is it's more likely than not that you committed the new crime and everything falls apart with the old case. So there's a risk to first offender. Do you feel like you understand that?
Yes, I understand.
Understanding the benefit and the risk, do you want to be sentenced as a first offender?
Yes.
All right. Do you have any questions about anything?
Not at the moment, no, sir.
Anything you want to add?
No, sir.
Did you know either of the people, the man, or were they like a couple?
Yeah, there was a couple.
Okay. Did you know either of them?
No, sir.
And what's at this address on Spring Street?
It was across the street from my job. It's a gas station.
Okay. All right. Well, I find there's a factual basis for your plea, that your plea was knowing and voluntary, meaning you understood what we were talking about and no one forced you to enter a plea. Is it okay if we sign your name to the indictment, Mr. Brown?
Yes.
Ms. Rios, can we sign for you?
Yes, sir.
And when I say we, someone in my office, can we sign for you, Ms. Smith?
Yes.
All right. Well, I will accept this as an offered plea. I will sentence you as a first offender. Counts 1, 2, and 3 will be 5 years to serve 4 months with the balance on, I'm going to say 5 years to serve 5 months. You were 1 day off. You're not going to have to go back into custody, but that'll knock a year off probation. So 5 years to serve 5 months, balance probated on counts 1, 2, and 3. Count 4 is 5 months to serve. Special condition of your probation. One of them you're already working towards. Get your GED. Number 2, no contact with either of the individuals you had that disagreement with, the victims in this case. Stay away from that gas station on Spring Street. You'll need to complete an anger management course, and I'm going to require you to do that within the first 3 months of probation. You also have 40 hours of community service. You'll need to take care of that within the first 4 months of probation. Best if you take care of it before you go to Texas, if you can, but it's up to you. You're not required to do that if you can get to Texas that quickly. And I will set a behavioral incentive date of May 27th, 2029. That's 3 years. I know Ms. Rios asked for 2 years, but as a first offender, this is a pretty big opportunity for you. And I'm going to ask that probation keep their eyes on you for 3 and not just 2 years. But if everything goes smoothly in those first 3 years, they can close the case out and you're all set. Any questions?
No, sir.
Anything from you, Ms. Smith? Mr. Brown, what county do you live in now?
It's East Point.
So it's Fulton County.
Yes.
All right, you're going to need to meet with Ms. Simpson. She's with probation and she's going to give you reporting instructions. Don't miss your first date with probation.
Okay.
All right, Ms. Rios, anything else? All right, good luck, Mr. Brown.
Thank
Um, Now as far as what's left, I know we have that meeting, but I have this plea. I don't know if we need to reset it.
No, we'll do the plea. The meeting, we're good with the meeting.
Okay.
We've got Mr. Lopez. That's a quick final plea.
Yes.
All right, and then we've got Mr. Price. Is that the plea or is that?
Follows other cases. We have the newer cases that were just re-indicted, and I just filed waivers on those. So this case can follow that, so I can work on getting him to the next level boys academy and stuff like that.
Mr. Price?
Yes.
Okay.
Working on for him, so we can let him go. I don't know if we. Okay. I could probably just. We don't even probably need to bring him. I kind of already told him that's what was going to happen.
Told him, I can repeat what you said, but I don't need to if you think he knows what's happening.
I'll just let him know, because he's probably confused why he was brought today, actually. But I haven't gone back to let him know that.
Okay. So he is reset. I'm going to just say reset to inquiry where we can check, have the other cases been indicted? Then we've got Mr. Barber.
Yes, that's the non-negotiated plea.
So that's the plea and then Mr. Willingham. And then we've got your bond hearing, Mr. Battle. That one we may reset. Well,
That'll be the final hearing. We'll move forward with the trial calendar.
okay, well, why don't we do Willingham first, because he's had family here or friends all day, so let's bring him out. How much did you
Yo, I just
fit in there? Oh,
And Judge, if I can have 1 minute to just speak with him.
Sure.
Okay. So, state. She says that she might be willing to reduce your charge for other case less than 10 years that she offered. But we're going to be talking about it in the next couple of weeks. Going to say on record that we're not accepting the offer and that you're calendar. Are we going to run the case? No, no. But your case is just going to be reset totally, and then we'll figure out what the fee's going to be before. That's it. We're ready, Judge.
we good? Okay. Let's get on the record in your case, Mr. Willingham. It's 26 SC 000020. You're represented by Mr. Rhodes. Ms. Smith is handling the case for the district attorney's office. You're charged with armed robbery, aggravated assault, and possession of a firearm in connection with a felony. Armed robbery, as I'm sure Mr. Rhodes has explained to you, is a case with is a charge with a 10-year mandatory minimum, non-parolable, unless the state agrees. I can't make it happen. The state has to agree to it first, and then I can think about it to go below that 10-year mandatory minimum. So it's a pretty serious charge. Mr. Rhodes, do you feel like you've got all the discovery in the case?
We've discussed it with ADA Smith. There is one piece of video that she's working on getting me.
Is it law enforcement video or is it surveillance video?
It's video that comes directly from the victim.
Okay, it's victim video.
Yes.
All right. So it is not exclusively in the control of the state, but it's probably easier for them to get it.
Yes.
Okay. All right. Is it dispositive video or it's, hey, you need to know what it shows before you'll be fully ready for trial?
It, I believe, would be dispositive video. It does allegedly show the robbery as it happened.
Oh.
So
Ms. Smith, have you seen the video?
Yes, this on the cop's body cam is not as clear. It's from his car. His car was recording. So I'm having to.
Oh, the officer's car was recorded. Was this like a Uber driver or something?
It's just, I think it's like a Tesla. I don't know. It's like one of those newer cars.
Oh, somehow the car was recording what happened and the officer has made a recording of the recording?
Yes.
Got it. Okay. Understood. In the meantime, what is the state's offer to Mr. Willingham if he wanted to resolve the case today?
The state's you served 10 balance probated.
All right. So as a big old sentence, Mr. Willingham, 10 years to serve followed by 5 years in custody. It's also the minimum sentence that you face unless the state reduces charges. I already mentioned armed robbery is 10 to serve minimum. It's actually 10 to 20 or life. And then the firearms count is 5 years and it has to run consecutive, but it can be probated. So unless the state reduces charges, the lowest sentence I could give you would be 15 to serve 10 with the balance on probation. And right now, that's what the state's recommending. Is that something you're interested in pursuing right now? Or would you prefer that we move your case to the trial calendar?
To trial.
Okay, that's what we'll do. You're on the June 16th trial calendar, so it's not too far away. Means two things. One, hopefully closure is coming soon. If you're found not guilty, you go home. If it's worked out, you get your sentence. If it's a jury trial and it doesn't go well, you know that's what's coming. But two, it means that both your lawyer and the prosecutor are going to work real hard to get this other piece of video. I think it will help Mr. Rhodes. So have you seen the body cam that has it? And you just want to see it more clearly through the original, if the original can be obtained?
Precisely.
Okay, got it. Ms. Smith, do you have a reason to believe that the original still exists?
The victim, and he said that he's going to, those videos expire after a certain amount of time.
Right, because the car's always recording. Okay,
So once I get the confirmation from him that he has the video, I'll share it with Mr.
got it. Okay, so it may be out there, and if it is, you're certainly entitled to it. All right. Mr. Rhodes, anything else on behalf of Mr. Willingham?
Nothing in addition, Judge, except, I would anticipate, Judge, that this case won't exactly be on trial. We are working on a resolution pre-trial.
Okay.
So we're just looking forward to that. So if we come up with a resolution before trial or even on trial day, June 16th, we'll let the court know.
Sounds like a plan. Mr. Willingham, do you have any questions for me?
Sure.
Okay, your lawyer will stay in touch. He's working hard on your behalf, and maybe he'll be able to find that middle ground. Anything else, Ms. Smith? All right, thank you.
Thank you, Judge.
Can we bring Mr. Lopez out next, please? Mr. Wooten and Ms. Willingham, we'll turn to the calendar in just a minute. We got a couple more things we got to knock out. Hopefully you guys are multitasking.
I am definitely multitasking, Judge.
Did you see the order in the Tamika Clark case?
I did. I saw it early this morning, about 2 seconds after after it was filed. So
Okay.
I went and contacted the family. Thank you.
I just want to make sure it hit your radar.
Yes, it did.
Okay.
I'm trying to get it over with.
Ready?
Yes.
All right, we're going to get on the record. 24 SC 004662, State versus Jose Lopez. Good afternoon, Mr. Lopez.
Good afternoon, Your Honor.
You are represented by Ms. Wood, standing next to you. Ms. Smith is representing the state for the purposes of this hearing. Mr. Lopez, this is what we call your final plea hearing. It's a chance for me to make sure your lawyer's got all the discovery and sort of a last chance to work the case out in a pretty flexible, negotiated way. If you were to enter a plea today and I were to sentence you to more than what Ms. Wood asked for, you'd be able to withdraw your plea. One of the charges you face has a pretty serious sentence associated with it, so this is probably going to be a formality, but I'm going to get everything on the record and make sure you're following along, okay?
Yes, sir.
Ms. Wood, discovery going okay?
Yes, Judge.
All right. Anything you feel like you're missing?
Not that I know of, Judge.
Okay. Is this a case with a forensic interview?
Yes, there is an interview. There's a couple of files that I haven't been able to get into, but I have the transcript.
Okay, so you know the contents.
Yes.
Okay. Ms. Smith, what's the state's offer in this case?
State offered 20 years to serve 10 with the balance program.
That's the,
Involves a charge reduction?
it involves not processing count two.
Two,
Count
okay.
two, yes.
Got it. Okay. Yeah, count two, I think carries a 25-year mandatory minimum, but if you were working the case out today, the state would be dismissing count two. But the recommendation is still 10 years in custody followed by 10 years on probation. Do you understand that?
Sure.
Okay, is that something you're interested in pursuing now, or do you want to move this to the trial calendar?
Trial calendar.
Trial calendar. Okay. Well, that's coming up soon. It's June 16th, so we'll get you back here. If for some reason you and Ms. Wood work things out before then, we'll get you back here before then. Otherwise, you'll be here on the 16th. That's not when we actually do the trial. It's when we figure out which trial we're gonna do. So you'll still be dressed like that. If your case is the one that's going to trial, the week of trial, then we'll make sure that you're not looking at the jury wearing the orange jumpsuit, okay?
Yeah, sure.
All right, anything else from you? All right, Ms. Smith? Ms. Wood?
Judge, thank you.
All right, thank you, Mr. Lopez.
All right, have a good day. You're welcome.
All right, so is all that's left, the battle bond hearings, which we can defer, and the Barber plea? Okay. Would you mind if we did the trial calendar thing first and then the Barber plea? Okay, that way we can get everyone else out of here. I think it'll be a pretty quick conversation. I know the outcome for all the Wood entries. Let me go grab that. We're just gonna be talking. If you want to get people, we need to keep Mr. Barber up. Everyone else can go down, but we're just gonna be talking about upcoming trial calendar.
Yeah, I'm gonna let him know the behind the hearing is gonna have to be reset. We run out of time.
Okay.
Yeah, that he'll be brought back.
Barbara, stand up.
Barber's the only one staying up.
What about, Mr.
Cody.
Cody?
I just called your name, sir.
Alright.
You're welcome.
Oh, okay. Not here.